Well, it's almost 10 o'clock, so we can make a start. So, good morning to everybody, and thank you all for attending today's hearing, which is on terrestrial ecology matters, and that's in relation to the application for a pumped storage hydro electricity generating station at Loch Kemp, Dell Lodge, Whitebridge. My name is Gordon Reid, the reporter appointed by Scottish ministers to consider this application. I will be chairing today's session based on the agenda that was issued on the 1st of April, and I hope you've all received that copy of the agenda. The session is being broadcast live, so in taking part today you're consenting to being filmed and to the use and storage of those images and sound recordings and any information contained in them for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. So can I ask the parties to introduce themselves and the members of the team who will be participating in this morning's session. So we'll start with the applicant first.
Thank you, sir. Good morning. My name is James Findlay, King's Counsel. To my left sits Patrick Monroe from Burgess Salmon. To his left sits Duncan Watson, who's a technical director with SLR. To his left sits David Bell from David Bell Planning Limited. To his left sits Colin Murphy, who's hopefully you had who's an engineering manager at Statira Energy Limited. And to his left sits Andrew Troop, who's Development Director at Statira Energy Limited.
Okay, thank you. I probably won't remember all the names, so if I refer to applicant, then that will be an all-encompassing term for reference.
I will act as team leader and distribute the question accordingly.
Yeah, that's fine, thank you. And for the council?
Thank you, sir. I'm Alistair Burnett, King's Counsel, and I'm instructed by Arlene Gibbs of the Council's Legal Department, who's sitting to my right. And in this session, I'm aided by Dr. Michael Cordis from the Council's Planning Department.
Thank you. And for the British Lichen Society?
Good morning, sir. I'm Ewan Brown, Junior Counsel appointed by the British Lichen Society. Sitting to my immediate right is Neil Sanderson, who's the Joint Conservation Officer of the Society. To his right is Mr. Ben Kite. He is a Director of Ecological Planning and Research Limited. He's a Chartered Ecologist. And in the front row of the audience at the right-hand side is Mr. Andrew Cross, who's also part of Ecological Planning and Research Limited, and he is the lead botanist there. Thank you.
Thank you. And for Stratherick and Foyers Community Council?
Good morning, my name is Mark Hindley. I'm the Chair of Stratherick and Foyers Community Council.
Thank you all for that. So the purpose of today is for us to discuss some of the matters raised in the hearing and rebuttal statements relating to terrestrial ecology. I won't go over ground that is agreed or where I do not consider that I need further information in order to prepare my report. I have been through all of the statements, so I have the background knowledge and understanding. So in responding to questions, you don't have to feel the need to explain everything from in detail. You can just cut straight to an answer, and I will have read all that background information, and all that information will be taken into account in preparing my report to ministers. The session is a structured session, and I will lead based on the circulated agenda. I will not allow for any formal presentation of cases or cross-examination. I will lead the discussion on each agenda item by directing a question at one of the parties. After the answer, I will allow others to comment, and this may generate a bit of discussion or further questions. If you have any comments or questions as the discussion progresses, please make sure that they go through me and let the other party finish their own point. If you wish to come in, if you can raise your hand and draw my attention to yourself, that would be helpful. I will leave it up to each lead spokesperson to decide who answers my questions for them. but please have the documents to hand electronically and refer to the document number and electronic page or paragraph number if you're making any references to these. I can pause if necessary to make sure everyone, including myself, has the documents ready, because sometimes it can take a bit of time just to find it on the system, so we'll do that. I will keep us progressing through the items and we'll move on when I consider that I have what I need to write up my report. Don't feel obliged to comment if you're only repeating something that's already been said by someone else or is included in your submissions. I will have seen that in evidence. So all that you tell me today is evidence that may be included in my report, and you'll see me taking notes. I may again pause from time to time to make sure I have what I need. We've got quite a lot to get through and we've got a busy afternoon ahead, so we'll keep on progressing. If there's a need to take a break, or if somebody needs to take a break, then just let me know and we can break for a short period of time. So before we turn to the first item on the agenda, does anyone have any procedural questions that they wish to raise? I'll just start with the applicant.
No, sir, but just to inform you that there are continuing discussions between ourselves and the council as to conditions, and some progress is being made, and we'll hope to update you by the end of today on that.
Okay, thank you. For the council.
No, sorry, I just wanted to check. There was an updated SOAM in relation to this session, I think, with one small change to paragraph 3.9, just to check that you've received that.
Yes, I have received it, and I'll make reference to it as we go through the agenda, but I do have that, and I've read through it. Thank you. British Lichen Society. Sorry, British Lichen Society.
Thank you, sir. No, there's nothing from us.
And the Community Council.
No, nothing for me.
Okay, thank you all. On that basis, we'll progress into the agenda. My first questions are more just establishing sort of clarity of position with the relationship between certain documents, because I think that's important for the basis of where evidence lies. So the first question is to the applicant, and it's to do with the relationship of the EIA report. So can you just briefly explain the relationship between the EIA report, the Shadows Habitats Appraisal Report, and the case for derogation? So that's the first question. I'll let you answer that one first, because if I ask 3 questions, I'll probably have to repeat the third one, because we always forget the last one. So if we could just explain that one first.
Yes, sir, I'll just walk through that aspect at a high level. If I am at too high a level, please do let me know and I can cut through it a bit quicker. So the EIA report and the Shadow Habitats Regulations Appraisal Report are 2 forms of environmental assessment report, but they're addressing different legal requirements. The case for a derogation is an aspect of the Habitats Regulation Assessment process. So although the EIA and the HRA process consider impacts on the environment, they do so through that different legal lens, which I can just briefly outline the different requirements. So under the Environmental Impact Assessment regime, the relevant regulations for this application, the Electricity Works Environmental Impact Assessment Scotland Regulations 2017, and the EIA report is ultimately the outcome of that EIA process that the regulations govern. And EIA is an iterative process. Its aims are to ensure that there's an early consideration of environmental issues for a project, and that the EIA process influences design and ultimately mitigation measures. And it also provides the framework for consultation. The key legal requirement under the EIA regime is to identify, describe and assess the direct and indirect likely significant effects of a proposed development. And the way that it's to be used by a decision maker is that the EIA report and the consultation that follows on from it is intended to give the decision maker sufficient information about effects that are likely to occur on the environment to inform their consideration of policy compliance, and also allows them to weigh potentially significant effects in the planning balance. Moving on to the Habitats Regulations Assessment regime. For Section 36 applications, the relevant regulations are the Conservation of Habitats and Species Regulations 2017. And the purpose of the Habitats Regulations is that decision makers on consent applications, who in the Habitats Regulations context are referred to as the competent authority, have to give consideration to whether a plan or project could affect a European site before they can authorise that project to proceed. The key legal test under the Habitats regulations is whether the competent authority can be satisfied beyond reasonable scientific doubt, following an appropriate assessment, that the plan or project will not adversely affect the integrity of a European site. They can't grant consent if they conclude that it would have an adverse effect on integrity, or that one can't be ruled out, unless there is a basis for a derogation under the Habitats regulations assessment, and that's where the case for a derogation fits in. So where a competent authority has reached the conclusion that they can't conclude overall that there will not be an adverse effect on integrity of a European site, but still needs to consider whether to grant consent on the basis of a derogation, there are a number of tests that must be satisfied. The competent authority must be satisfied, firstly, that there are no alternative solutions to the project, then secondary, that there are imperative reasons of overriding public interest for the project to proceed, and the competent authority ultimately also needs to be satisfied that compensatory measures can be secured to ensure the overall coherence of the UK national site network being maintained. For the proposed development, the competent authority is the Scottish Ministers, and you'll report to them on that basis. So the Shadow Habitats Regulation Assessment for the proposed development concluded that there would be an adverse effect on the integrity of the Ness Woods SAC, which is why a case for a derogation has been submitted by the applicant in this case, which is document reference 3.5 as the updated version. So whilst there's a degree of overlap between environmental receptors that are considered in EIA and HRA, they are reporting on different outcomes of assessment in the context of the specific legal tests under the regulations.
Okay, thank you for that. So the second part of my question, just for clarity, just so we're sort of clear the different purposes and relationships, what was your purpose for submitting the Shadow Habitats Appraisal Report? Because obviously this is referred to as a shadow one rather than a Habitats Appraisal Report, and the case for derogation.
Yes, so under the Habitats regulations, it's ultimately for the competent authority to reach a conclusion based on all of the information that is presented to them on whether or not a development would ultimately have an adverse effect on the integrity of a European site. Within the regulations, there is a requirement on applicants to provide sufficient information to the competent authority to be able to undertake that assessment and reach a conclusion. And that's the purpose of the Shadow Habitats Regulation Assessment being submitted. Because the applicant's conclusion in the Shadow Habitats Regulation Assessment in this case is that there would be an adverse effect on integrity of the Ness Woods SAC, along with that a case for derogation has been provided to allow the competent authority to undertake an assessment of the derogation case that's being put forward and determine whether they are satisfied that the project can proceed, notwithstanding the conclusion that there'd be an adverse effect.
Okay, thank you for that. And my sort of third question is, in my reporting and in preparing my report to Scottish Ministers, what status should I give the Shadows Habitat Appraisal Report and the case for derogation? I'm clear, obviously, with the requirement for an EIA report, but what status should I give these two further documents?
Yes, sir. So the applicant's position is that the Habitats Regulations Assessment and some of the additional information that was submitted at a later date provide all of the information that you would require to reach a reasoned conclusion and make a recommendation to ministers on what the effect of the proposed development would be on all European sites, so not just the Ness Woods SAC, but any other special protected areas or special areas of conservation where there was a potential likely significant effect of the development as are set out in the Habitats Regulations Assessment. And the case for a derogation sets out the applicant's position on why each of the legal tests required for a derogation have been met, and the applicant considers that that sets out sufficient information to you to be able to make a recommendation to ministers on whether those tests have been satisfied.
Okay, thank you for that. Do any of the other parties have anything they wish to comment? The Council first.
I don't think we have anything to add to that, sir. Obviously, the last two documents are ultimately a matter for you and the ministers to come to decision on.
Okay, thank you. British Lichen Society.
Yes, thank you, sir. Mr. Kite has a point.
Good morning, sir. We agree with what the applicant's just said. One supplementary point, I suppose, is that the scope of information that you take into account for the purposes of applying the habitats regulations assessment tests and assessing the derogation case needn't be confined to what's in the documents provided by the applicant. You can take into account any other submitted information you wish in applying those tests, and also you needn't share the conclusions in the documents provided by the applicant if you have reasons to vary from them.
Okay, thank you for that. Community Council?
No, we agree and understand the applicant's position on these documents and their relationship.
Okay, thank you. Did the applicants want to say anything else? Okay, that's helpful. It's just so that there can be confusion over what role each of those documents have. So I think the starting point for this morning is to set the clarity that the EIA report stands on its own, and the shadow habitats regulation phase and the case for derogation are running parallel with that. And there is obviously crossover of information that relates to those things, but it's just to have clarity that these are different documents for different purposes. That was helpful, thank you. Moving on to item 3, residual effects on woodland. There's been a fair bit of discussion and evidence, so I just want to pick through just a few points to clarify some matters on this. So first one, effects on ancient woodland. Again, we'll start with the applicant. With the reference to the findings in the EIA report, I think chapter 10, can the applicant just briefly summarise the significant residual effects on ancient woodland, taking into account any proposed mitigation, but excluding any compensatory matters that might be in the case for derogation, etc. So just looking at it in EIA purposes alone.
Thank you. I'll ask Mr. Watson to deal with that.
Right, hopefully I'll get the right sort of level of detail that you're after here. Stop me if not. So obviously all the information's in EIA chapter 10. So in summary, I'll start by saying that for simplicity we're essentially conflating the area of ancient woodland with the area of semi-natural ancient woodland with the area of Nestwoods SAC. There are some very slight differences in the mapping of the two things, but essentially they're one and the same. There is also another area of mapped as long established woodland of plantation origin in the western part of the site. However, that area is dominated by non-native conifer plantation. It's into its third or fourth rotation. None of the ancient trees or other ancient woodland features are present, so it's effectively excluding that from consideration, focusing on the ancient woodland that lies within Nestwoods SAC. So within Nestwoods SAC, excluding the proposed compensation, the key effects are the loss of ancient woodland habitat. So dividing that between the Nestwoods SAC includes 2 woodland qualifying habitat features, one of which is the mixed woodland on base-rich soils associated with the rocky slopes, which is a priority habitat feature, and the other which is western acidic oak woodland. So taking each one in turn, the EIA predicts that the direct loss of 0.51 hectares of mixed woodland on base-rich soils associated with rocky slopes, and direct loss of 4.96 hectares of western acidic woodland, oak woodland. So that's a total loss of 5.42 hectares. In addition to that, there is also a significant effect resulting from fragmentation. Fragmentation being where primarily where the access track to the powerhouse will cut through the woodland, and where there are tight hairpin bends, Some of the woodland that may not be directly lost, it's in between the bends and on the outside of the bends, could be affected by fragmentation effects. So for each habitat type, the area that could be affected by fragmentation for mixed woodland on base-rich soils associated with rocky slopes is 0.13 hectares. The area that could be affected by habitat change from fragmentation for the western acidic oak woodland is 1.04 hectares. So, yeah, the total extent of ancient woodland in that basis that's affected by habitat loss and fragmentation combined should be 6.59 hectares. I think it's worth saying that in the EIA report concludes that these effects are significant effects at an international level, given the status of the site. Various other effects on the ancient woodland were assessed within the EIA. None of those were found likely to be significant. So it's ultimately it's the direct loss and it's the fragmentation effects. So yeah, I know you said not to talk about compensation, but I think it is worth noting now that the compensation will obviously offset those effects. We'll touch on that later.
Yes, well, and what I'm trying to just establish at the moment is that there'll be significant residual effects in the loss of each woodland, and my understanding is there's no mitigation against that. There's the compensation that is being argued through the derogation report. Now, I might be incorrect, but I think that's my understanding of it.
I would just say those are the residual effects after mitigation. Obviously, there has been, within the design process, the design has sought to minimise those effects as far as possible. There are also various fairly standard mitigation measures that would be employed during construction, which would again seek to keep that to a minimum, but those, yes, are the residual effects.
Yes, I acknowledge those. That's why I just wanted to clarify what the actual area was in terms of residual, taking into account everything else that's come before that. That's helpful. Does anybody else want to add anything into that position of the Council? British Lichen Society?
Yes, thank you.
Thank you, sir. Just a couple of supplementary points, if I may. I think the first one is that although we're talking about ancient woodland, that is in fact a very broad category within which there are woodlands that only just meet the definition of being ancient, which I think in the NPF4 is that they've been forested since 1750. And there can be woodlands at that end of the value scale that are fairly poor for ecology as a result of existing impacts and prevailing influences. But at the other end of the value scale, you have woodlands like Ness Woodlands, SAC, that is internationally important and has various attributes that push it up that end. So although we're dealing with one broad category, it's not all homogeneous. Related to that is the fact that ancient woodland is a habitat which has constituent parts. From our perspective, from the Lichen Society's perspective, an important constituent part is the lichen assemblage, and that I think will experience impacts that are not necessarily directly attributable either to loss or fragmentation. So opening up a woodland will change the conditions inside that woodland in terms of light, desiccation, humidity, etc. And those will have effects on a constituent part of the ancient woodland habitat, which is the lichen assemblage from our perspective, sir.
Okay, we will come on to that particular aspect. I'm just trying to break things down into sort of logical chunks for my brain to kind of work through what the positions are, so we can kind of conclude in that. But that's helpful, thank you. Community Council, anything to add, Mr. Hindley?
Nothing at this time, thanks.
Okay. If you do, just raise your hand, then I'll know to ask. Okay, so again, this is to the applicant, and I'm just trying to break this down. Effects on other woodland, which I think you would just start to touch on. Can you just identify the area of affected non-ancient woodland, just advising on the status of that, and the main conclusions from the EI report, again, just very briefly, in relation to if there are any significant effects, and what would be the mitigation for that. So just in a very kind of general response to the effects on other woodland within the site.
Sure. Just to go back on the previous, regarding the ancient woodland, was just to pick up on that point about the lichens, and noting that they are indeed a component part of the SAC woodland qualifying habitats. They are one of several component parts of the...
Yes, I understand that bit, and as I say, we will pick up the lichen bit further on the agenda. So, and if not, you can pick it up at that point if I've missed something. Okay.
In terms of the other woodland, and I'll keep this brief. So outside the SAC, the permanent loss of woodland would extend to 54.87 hectares. That's picked up in, so as well as a lot of my evidence will relate to chapter 10 of the EIA, which is document 116. That's also picked up in chapter 19 of the EIA, which is the forestry chapter, document 125. So of that 54.87 hectares, the majority of that relates to non-native coniferous plantation forestry. Some of those areas have actually been clear-felled already, separate to the development, but they are in the woodland management plan as awaiting restocking. So we treated them as lost because they'd be affected primarily by inundation as part of the development. Of that 54.87 in the terrestrial ecology chapter of the EIA report, the only areas that of that 6.1 hectares relates to broadleaf woodland, and of the conifer plantation, 6.34 hectares of that is the area that I mentioned before that's mapped as long established plantation origin woodland. I think we're going to touch upon compensatory planting later, so I won't go into that now necessarily.
Yeah, it's probably more just sort of, in terms of compensatory planting for the non-ancient woodland, you can cover that just now.
Okay.
That would be fine.
Okay, so
just because that's a different context.
Yeah. Okay, so in terms of compensatory planting, so EIA chapter 19 and associated appendices have calculated the compensatory planting requirement to meet the Scottish Government's control of woodland removal policy. That calculates, which includes the loss of woodland within Esford's SAC, 52.86 hectares required for compensatory planting. The reason that's less than the total combined loss is because some of that area is proposed for forest to bog restoration, and some of it's adjacent to access tracks which will be coming out regardless of the development. That's why the slight discrepancy in the numbers. The actual proposed compensatory planting, this excludes the compensation relating to the SAC, amounts to an area of 63.11 hectares, all of which would be new native woodland. So I think that equates to a ratio of loss to creation for woodland, excluding the SAC, of 1 to 1.2. So, and it's also an increase in native woodland at the site of 51.5 hectares, on the basis that the compensatory planting will be native woodland rather than coniferous plantation.
Okay, that's great. Thank you for that. Any comments from any parties?
So, sorry, our main comments in relation to effects on the SAC relate to lichens. Would you prefer we save those for the lichen section?
Yes, this might seem a bit slow, but I'm just trying to differentiate between the ancient woodland, because we're coming on to the policy bit next, so hopefully it'll make sense that we've got clarity of the position before we go into that, so there's no confusion. But yes, we will be picking up on the SAC and the liking, etc. as an agenda. And if not, just raise your hand and we'll... Okay.
The Community Council would just like to highlight that NPF 4 specifically excludes areas from development that were due for restocking.
Okay, we're just going to move on to that, so we can pick that point up. Okay, so moving on to, hopefully you'll be able to pick these points up under the policy aspect of it. But if not, just raise your hand and fire in. So the final point just on this is just, again, to the applicant, but it's just for clarity and just briefly, in terms of the ancient woodland, can you just set out the conclusions of the EI report in terms of the significant effects on the qualifying interests of the Nestwoods SAC? So just the conclusions on that.
Certainly. So, try not to repeat myself here. Obviously, there is a clear overlap here between the ancient woodland and the qualifying habitats of the SAC. So, just to summarise, as before said, the direct loss and the fragmentation effects on the two woodland qualifying habitats combined add up to 6.59 hectares. It would also, which we're going to touch on later, it would result in the loss of a range of component parts of that habitat, including lichens, biophytes, etc. So in terms of the conclusions of the Shadow Habitats Regulations appraisal, those effects represent an adverse effect on the integrity of Nestwoods SAC, and therefore hence the requirement for a derogation, which I think we'll come back to later.
Okay, that's fine. I just wanted to be sort of clear that you are concluding in the EI terms that there is significant residual effects on the qualifying interests, which then leads to the requirement through the HRA process for the derogation report, just so that the lines of understanding are clear. Did the council want to add anything?
Sorry, can I just...
Yes, we can come back to you.
Come in on that slightly. So I think the fact that the compensation is put forward as part of the derogation case under the Habitats Regulations assessment doesn't mean that it's completely disregarded in an EIA context. So I think if within Chapter 10 at Table 10.15 it summarises the overall conclusions on effects on ecological receptors from an EIA perspective, and as Mr Watson explained, the conclusion on the Nestwoods SAC is that there's a significant negative effect at international level, but it does go on to conclude that with the significant positive effect from compensatory woodland and restoration management, that would be offset. So there is a nuance there. There's a conclusion that there's a significant effect, but I just wanted to be clear that the compensatory planting isn't completely ignored in an EIA context.
No, I understand that you've referred to that within the EIA. What I'm just trying to sort of keep clarity is just the difference between the different, because in some of the evidence there's quite a lot of overlap and cross between the HRA derogation line and the EIA, and I know that there is overlap between them, but sometimes it was getting a bit confusing in terms of it, so I just wanted to get clarity that we're in each of the lanes, but the lanes do cross over, so I'm conscious that you have referenced that in the EIA report.
Okay, thanks, understood.
Okay, does anybody else have any comments before we move on to the next item? Okay, so sorry, that was a long way round for a shortcut, but it was just to try and set the scene. Item 4 is looking at NPF 4 Policy 6, which is forestry, woodland and trees. So just to start with, Policy 6 Part B covers ancient woodland, and I would just like to ask the Council and then the applicant to follow to clarify their position with regards to Policy 6B Part 1 in relation to the loss of ancient woodland, and whether Part 1 apply. I think I know what the answer, but applies in this case, just so that we've got the scene set.
Yes, in this case, our opinion is that the proposals are contrary to Policy 6B Part 1.
I'm just
Yes, in this case, the Council's opinion is that the policy, is that the proposals are contrary to Policy 6B Part 1. Because
So Part B1 apply. I'm not switching my microphone now. Apologies. So Part 1B applies, and then there's the loss of ancient woodland from this site. Yeah.
yes, the loss of the area of ancient woodland that's been described in the annual report.
Okay. And for the applicants.
Good morning, sir. Yes, there's agreement with that position that there is an element of conflict with that first part B of Policy 6. We do have some other comments on other aspects of the policy. You may be coming on to that. Thank you.
Yeah, I'm just trying to see we're starting from the same place. So I think there's no dispute that Policy B Part 1 applies, and there is the loss of ancient woodland. So there's no dispute on that particular factor. Okay, that's fine. So looking at, and it's been touched on briefly, looking at Part 3 of B, that refers to fragmentation and severing of woodland. Again, can I just ask the same questions of the parties, whether they consider that this applies to the ancient woodland? So we'll just start with the council again.
Yes, it is our opinion that that applies in this case as well.
Okay, and for the applicants?
And yes, there is agreement. Sir, Mr. Watson explained that earlier in terms of that aspect of impact on the ancient woodland too.
Okay, that's helpful. Any other comments from any parties about application?
Not on parties.
Okay, thank you. Just setting the scene that we were all on the same page with these matters. So I think where there may be some more discussion in detail is application of Policy 6 Part C, which relates to compensatory planting. So again, I'll put this to the Council first. In paras 2.2 to 2.11, I think of your rebuttal statement, I think that's E pages 2 to 4, you set out the approach to applying Part C with commentary within that. So can you just sort of explain your position in terms of the application of Part C in relation to the loss of the ancient woodland?
Thank you. Yes, our interpretation in these circumstances is that Policy 6 is to be read as a whole, and it is a development plan, it's to be read as a whole, and that Policy 6 contains a number of distinct parts against which the development proposal is to be assessed against. So in this case, the Council has come to the opinion that Policy 6B1 offers no policy support for developments which result in the loss of ancient woodland, and that Policy 6B1 in this regard also provides no opportunity for mitigation or compensation for such a loss.
Okay, so just to make sure I understand that, so in terms of C doesn't, correct me if I'm wrong, but C doesn't apply because Policy B Part 1 doesn't provide qualifying parts to it, is that?
Yes, that's correct.
The position. Okay, that's fine. Okay, and would the applicants like to provide me with their view on the application of this part of Policy 6?
Thanks, sir. Part C, firstly, maybe direct you to the planning statement is quite helpful, just for your notes in terms of the application of this policy and the development, which is document 1.4. Sorry, I can cover it verbally first, but just give you the note.
I will listen while I'm logging back in again.
So the document is 1.4, and it's Table 7, which deals with Policy 6 and cross-references to aspects of the EIA report. But the applicant's position is that Part C is relevant. I think our view is you need to read Policy 6 as well as a whole. As I understand it, the Council's position seems to be you read NPF 4 as a whole, but not Policy 6, the distinct parts that they silo or want you to look at in isolation. My view is you need to look at Policy 6 overall. and indeed that was the position that the planning department within the council took, and that's clear in the report of handling, and in particular for your note, it's report of handling paragraph A 4.15, which is the planning officer's appraisal of policy 6. And there's really two points to what I would say about part C of the policy. Firstly, if we go to the planning officer's position in the overall appraisal, in that paragraph, they say that it is considered that the proposal is generally in overall conformity with policy 6, given the significant compensatory planting scheme of woodland areas both in and out with Nestwoods SAC. So the planners took the view, yes, there is conflict with ancient woodland removal, that's regrettable, but there is compensatory planting proposed. That won't fully mitigate, but it is compensatory planting in line with the EIA mitigation hierarchy. And I would say that's the right approach to take when you look at the policy overall. The second point I was going to mention...
Sorry, can I just matter for clarification, this is where it comes back to the report that you're referring to, and that's referring to ancient woodland at that point, or the loss of woodland as a whole. This is where I'm trying to make sure that the two aren't conflated. Because that logically applies fairly straightforwardly to non-ancient woodland. I don't think there'd be much dispute over that.
It's their overall conclusion, so it will incorporate all woodland.
So that's including ancient and non-ancient woodland in that conclusion.
Yes, that's my understanding.
I'll come back to the council on that, but okay.
Yep. The second point I was going to mention overlaps a bit with something on your later agenda about the other decisions. If it's okay just to go to one of them, or would you rather me wait till we come to
I'm happy enough we roll these two in if it speeds the process up, then let's roll them in. Because I think there's only really one decision. Actually, when I looked through it, I think there's one main decision that's been referred to, which may be the one you're picking up. Okay. So we may cover those both points, but you'll have the council will have the opportunity to comment back.
That's fine. The one I was going to refer to is the Dunoon to Loch Long 132 kilovolt overhead line rebuild, which is document 18.019, and in the addendum to the applicant's ecology hearing statement, which I prepared, I have in turn an appendix 1 which has the extracts of those decisions, and in that particular one it's the Scottish Minister's decision letter, and they state in the quotation that I've highlighted in the appendix, the Scottish Ministers conclude that there will be a significant residual effects due to the removal of ancient woodland, which is contrary to Policy 6 of NPF4, which is similar to what we have here. And they go on to say, the company have, however, committed to compensatory planting, which shall be secured as a condition with this consent. So clearly, in dealing with acknowledging the ancient woodland impact, the ministers have taken the view that compensatory planting is a relevant factor when considering the weight to be given to aspects of Policy 6. And if you look at the slightly later quote that I've put in, they do say that it's regrettable that there is some loss of ancient woodland. It's accepted that this is an impact that cannot be fully mitigated. The Scottish Ministers have given consideration to this impact, but consider the proposed development as both urgent and necessary. Now that's going on to a different point in the wider planning balance, but there's 2 points there. One is compensatory planting is engaged, and that would link with Part C of Policy 6. And then there is, of course, the wider balance, which we won't go into at the moment. Thank you.
Okay, thank you for that. We'll come back to the council, but does anybody else want to have the opportunity to comment? British Lichen Society?
Sorry, sir, I couldn't quite decide whether or not our view of this policy is the same as that, so I thought I'd better explain our view, just in case it differs. I think our view is that whilst you read the different parts of the policy together, they're approached in sequence. So Part B applies first, and you have to establish that the justification for the development outweighs the loss of the woodland. In other words, whatever development is proposed with whatever benefits outweighs the harm to the particular ancient woodland that's affected, and every ancient woodland will have a different value in that weighing exercise. And then once you've established that the loss is justified, you look at Part C, which requires compensation in the form of woodland planting, but that woodland planting can only replace the trees and needs to be enough for the trees. There are other aspects of the woodland habitat, such as the ancient woodland vascular plants, the fungal mycorrhiza, the invertebrates, the lichens that cannot be replaced, at least within a human lifespan for some of them, and therefore there will remain a residual negative effect that needs to be weighed in the planning balance as a result of the fact that those particular elements can't be put back.
Okay, thank you for that. Community Council?
Yes, we agree with the council's view on this, that ancient woodland is not replaceable, and therefore this particular policy has been worded this way deliberately because compensatory planting cannot make up for loss of ancient woodland.
Okay, thank you. Now we'll come back to the council. Is there anything you want to add to your position, or respond to any of the points raised?
Yes, just to sort of further with comments on the sequential nature of policy 6B1, policy 6B in the council's view that policy 6B1 offers no policy support for development proposals that will result in the loss of ancient woodland being a replaceable habitat, and as such it provides no further opportunities for mitigation or compensation for such a loss.
Okay, so I didn't quite sort of catch the. Are you saying that you do look at it sequentially, and if it doesn't pass one, then Part C doesn't apply? Or am I misunderstanding that? Apologies if I have.
No, that understanding is correct.
That's the correct understanding. So it's a sequential application to Policy 6. Mr. Burnett, do you wish to come in?
I was just going to say, so I think that is right, and just on the decision referred to by Mr. Bell, it's still, in that case, found to be contrary to Policy 6, and then go on to look at other policies in the development plan as a whole, but it's contrary to 6B1, and then you may still take into account 6C, but it can't stop the non-compliance with 6B1, because 6C may still be relevant because there's some loss of woodland in the overall development, but it can't change B1 because it refers to any loss of ancient woodland.
Okay, I think I understand your position on that. Did the council want to make any final comments?
So just this, that I'm still slightly confused about the council's position and whether it differs from that set out in paragraph A 4.15 of the officer's report. I understand their position that if there's a conflict with policy 6B1, there's a conflict with policy 6B1. But when you're assessing policy 6 overall, the question then is whether compensatory planting is relevant in that overall assessment of compliance or otherwise with policy 6. And the conclusion in A4.15, which is we understand to be the considered conclusion of officers, is that you assess that on the proposal, or their assessment was that the proposal was in overall conformity with policy 6. The word overall obviously indicating that there's a conflict with part of policy 6, and they specifically refer to the significant compensatory planting scheme both in and out with Nestwoods SAC. So that, for your notice, electronic page 119 of 154 of document CD47. I'm not sure there's any disagreement with the way that Mr. Cordis has just put the matter, that you look at them sequentially, but when you're taking an overall approach, our submission is that the council officers had it correct in their report.
Okay, so is the point being made that there's an inconsistency or a difference between the position in the officer's report and the evidence that's been submitted before me just now.
I'm not sure whether there is an
But
inconsistency.
I will ask the question anyway, just so for clarity.
Very kind.
Microphone. Thank you. I forget to switch mine off all the time. Just for clarity, obviously there's a point being made there about the report of handling. Obviously the members took a different decision at committee, which they're entitled to do so, and obviously the evidence that's been presented today would normally be the evidence that I would be taking as before me. Is there any comment that the council want to make on that, just to help clarify matters?
Thank you, sir. Good morning. I think the point you've just made there is that the report before the committee was the officer's view. That doesn't mean that the members had to take that view exactly, and they reached a different conclusion that this proposal is not compliant with Policy 6B Part 1, and that Policy 6 Part C doesn't apply to the ancient woodland.
Okay, so I'm moving forward on the basis of the evidence in the hearing statement and the rebuttal statement for my considerations. Okay. Did the applicant want to make any final comment on that?
Obviously, slightly surprised if members had articulated a position on the proper analysis of Policy 6. It's absolutely clear they took a different view as to outcome from officers on Policy 6. It's the point I wish to raise was the proper approach to interpretation and application of Policy 6. We have the Council's position that they're advancing to you by way of evidence at this inquiry. You also have their officer's position, and you will have to form your view as to which is correct.
That is correct. I have all the evidence before me, and I'll take that into consideration. Okay, any final points on that particular matter? Okay, so moving on to, we had the item other report cases decisions. Now, the applicant has already referred to one of the cases. I think one of the cases the council referred to was the Richard Cross case. And it's really just to give the council, is there any points in that you wish to kind of raise or make clear in this position?
Thank you, sir. My understanding would be that the senior counsel for the petitioner has set out exactly what we have just summarised, that Part 6C does not apply to loss of ancient woodland under 6B1.
Okay, so in terms of the Richard Cross case, that was just an example that you were providing. I'm just trying to make sure I understand the relevance of why that's been referred to in evidence.
Thank you, sir. We lodged that on the basis that that decision was recent, and it was a court decision on the interpretation of Policy 6, which is akin to the situation that we have here before us today.
Okay, thank you. I think the applicants might want to come back to me on this.
Just very briefly, the senior counsel for the petitioner is me, so
that's why I'm coming back to you.
So no doubt that, but there's nothing in our submission that in either submissions I made to the court or the judgment of Lord Mingus, which is inconsistent with the case that we're putting to you. And if necessary, and if the council persists in its view that there is, we can deal with that in closing submissions.
Okay, thank you for that. It was just to make sure I understood the sort of council position. Do any of the other parties have any comment on that? Okay. Okay, so just for completeness, loss of other woodland, and then this is just to the council and then the applicant in terms of whether they consider the relevant parts of Policy 6, what are the relevant parts of Policy 6 to the consideration of the areas of non-ancient woodland, and in particular Part C apply. I think I know the answer to this, but I just want, for completeness, to get the proper understanding of what parts of Policy 6 apply to the non-ancient woodland areas. Council first.
Yes, would be Policy 6C in this case.
So 6C clearly applies for the...
Yeah, certainly in terms of the...
Okay. So policy A through to C, sorry, policy B applies, and then C applies as well. Okay, from the applicant's point of view.
Sir, I think 6B would also apply where there's adverse impact on other woodland that is not ancient. There's aspects there, 6B Roman 2, and also potentially fragmentation, Roman 3. And then Part C, yes, that would apply. Because the end of Part C says where woodland is removed, that will be all woodland.
Okay, so I don't think there's any dispute between the council and the applicants on the application of policy 6 in relation to the to the areas of non-ancient woodland. British Lichen Society, do you wish to add anything?
Nothing to add, sir.
Community Council?
Well, merely to highlight the fact that policy 6.4 identifies that the developments will not be supported when there's a conflict with a restocking direction. And as we highlighted earlier, there is an area of non-ancient woodland which has been felled and would not be restocked as part of this development.
Okay, so I think what you're saying is Part 4 would apply in this case. Does anybody dispute that? Just looking at the applicants, any comment on that?
My understanding, sir, is there's not a restocking direction that there would be conflict with. Mr. Watson may be able to illuminate that further.
The only thing I'd add to that is that any areas of woodland that would be, coniferous woodland that would be lost due to the inundation have been included within the loss of woodland figures, whether or not they are currently stocked with trees or not.
Okay, because I think in terms of 4, conflict with a restocking direction, it's where that circumstances occurs, where a restocking direction isn't being complied with in some manner. Is that your understanding of when that, it's just when does that kick in and apply, I suppose, is the question. Or rather than answer it myself, I'll ask the question.
Yes, sir, I think we agree with your point there. A restocking direction is a specific legal notice that's issued by Scottish Forestry. I think, as Mr Watson explained earlier, there's an area that has been felled and is being restocked as part of standard forestry practices. That's a distinct situation from a forestry direction, which is what Roman numeral 4 is getting at. So our position would be that it doesn't apply in this case.
Okay, thank you. Mr Henley, do you want to come back on that?
Yes, thanks. Our understanding is that when Scottish Forestry give a felling licence, they also apply restocking conditions to that. The particular licence that we referred to in our original submission to the ECU is FLA 01500, which required restocking by 2021, and that's not taken place, and that area would now be lost in the current development, so would then not be restocked.
Okay, I think that's probably going beyond the point I'm looking at today. It has been submitted in evidence, so I can have a look at that and I can make sort of my own judgment on that in relation to policy 6.4. But do the applicants wish to add anything else?
Lisa, just to say that there may well be a condition attached to the licence, but that's not a restocking direction.
Okay, thank you for that. And the Council or British Lichen Society, anything else to add? Okay, thank you. Right, we've moved to item 5. Now, I know we've been going for a short while. This would be an opportunity if anybody needed a couple of minutes break. If not, I'm happy to carry on. I'll look at parties. Everybody wish to carry on? Okay, that's fine. So, item 5 is looking at the lichens, and the first point I wish to sort of just examine is the location of lichen assemblages. So this is just to set context sort of to the applicant, just to confirm where the location of the lichen assemblages that will be impacted upon by the proposed development are positioned, just so that we're all on the same page with regards to the location. And if there's a drawing that could be referred to, that would be helpful.
Thank you. Yes, the relevant drawing is going to be figure 10.8, which is in the additional environmental information appendix 1. The document reference is 2.8. So that figure shows the location of all the lichen species recorded as being of medium, high or very high value by the survey within the site as a whole, and within the area of Nestwoods within the Dell estate boundary, which extends beyond the site boundary. So that's the relevant figure here. It's probably worth pointing out within the SAC, the species of higher value are strongly associated with the veteran hazel trees, not exclusively, but primarily, and you can see on that drawing the important areas for lichens which tend to coincide with the location of the hazel groves. Outside the SAC, the main areas of interest for lichens are the rocky shore of Loch Kemp itself, and also some of the heathland areas adjacent to Loch Kemp. That should show up on that same figure 10.8.
Okay, thank you for that. Is everybody sort of following that in terms of the locations that are set out in the EIA report? Yep. Okay. I just wanted to start from the right place so that we're not talking at cross purposes. So, questions to the British Lichen Society. Paragraphs 2.4 to 2.8 of your hearing statement, which I think are pages 7 to 8. You refer to concerns regarding the lack of survey work out with the application site and to 2 other SSSIs that form part of the Nestwoods SEC. Can you just sort of refer us to where those locations are in the first place and why you consider, actually I'll let you find that first and then I'll ask the next part of the question. I think there's a drawing that shows the locations of the other qualifying areas.
There is, sir. I just don't have a note of it immediately. I'll find it shortly.
If anybody else has it that can refer us to it, then please pitch in.
Which document reference that?
That's actually Scottish Natural Heritage.
Sorry, so I don't actually have a reference for the map. I can find that, but if it helps, I can explain what our concerns are, and we can return to the map once I've found the document reference number, if that helps.
The applicants, who I'm assuming, are aware where these other parts of the SAC, ones to the north and the other bits to the south, is that correct, that you're referring to?
It's the Nature Scott drawing that shows the three component parts of the SAC, the three SSI constituent parts.
Okay, I'm fairly familiar with that. I'm assuming the applicants are as well. I'm looking for a nod from somebody.
Yes, we're familiar with the other parts of the SCC.
Okay, so on that basis, can you explain to me why there's a need for these areas to be considered in terms of the comparative data for an assessment in terms of the EIA process? And the second part to this is the criticism in relation to the EIA process or in terms of the habitats regulations appraisal, or both? And that's just why, again, at the very outset, I wanted to kind of clarify the different functions of those processes.
Yeah, so if I can answer those questions in reverse, just because it'll help, I think. The point's relevant to both, but has different implications under each regime. So obviously EIA is the decision-informing process, and it informs you as to the balance of positive and negative effects. And the concerns that we raise would speak to the negative effects of the proposal, and therefore weigh in that regime as a decision-informing factor in the planning balance. But they also speak to the HRA regime in terms of whether or not there's been adequate exploration of the alternatives for delivering the plan or project as part of the derogation tests, and whether or not the compensatory measures that have been brought to bear are adequate to task. So I think they're relevant to both, is the answer. So in terms of the relevance of knowing the distribution of lichens across the remainder of the SAC, I think our view, if I can start you, sir, the conservation objectives for the SAC are given by the applicant in their derogation report. That's document 003005 at paragraph 4.2.6. That details the conservation objectives, but it summarises them, and in doing so it omits any reference to lichens. If you look at the actual conservation advice package that Nature Scott have produced, which is document 018038, that provides further detail as to what makes up what the important component parts are of the two qualifying habitats of the SAC. And I leave you to make your own judgment, sir, but my view is that makes it abundantly clear that the lichen assemblage is an incredibly important part of those two qualifying habitats. It's relevant because in the applicant's reporting, they focus on net losses and gains, to put it crudely, of those qualifying habitat types. And the crux of the Lichen Society's concern is that the particular elements of those habitats that are important concerning the lichen assemblage are not replaceable or incredibly hard to replace. We can come on to further detail on that in a moment. And therefore, when you're looking at the balance of losses and gains, it's important to bear that in mind, that actually quite a large proportion of the existing value of Nestwood's SAC in terms of the lichen interest is being lost, and the compensation can't necessarily put that back. So to understand when we're applying the HRA tests and relevant policy, which again we can come on to, a much larger percentage of the important interest of the SAC is being lost than is perhaps perceptible in the figures that are reported by the applicant. I can provide more detail on that. A particularly important point is that in his rebuttal, Mr. Watson indicates that 50% of all the important lichen species are being retained somewhere within the Nestwood site, and we don't agree with that. I've got some specific examples that I can give you, but there's one lichen, for example, where the only reported location in Scotland is in the area that's going to be impacted. I can provide more detail.
I've got already in evidence, so if it's in your evidence, I will have already seen it. I think the point I'm just trying to clarify is when you're talking about the sort of comparative element to it, these two areas are physically separate from the main sort of body of the SAC and are both out with the application site. Factually, that's correct, yes.
Yes.
So what I'm trying to say, and there's no argument being put forward that the application will affect the lichen in either of those two sites directly. Is that correct?
That's correct, sir.
Yeah. So what I'm trying to, so I just wanted to clarify those points. So that I'm trying to make sure I'm not misquoting you or not misunderstanding. So you're not saying there's direct effect. It's more about the assessment overall of the loss on the application site in the context of the SAC as a whole and lichen within the whole. Is that my understanding of what's being said? Because it's the word, using the word comparative is the bit that I'm still not clear what you mean by that.
So the integrity of the SAC is its ecological structure and function across its whole area. And when we're looking at compensation, we need to look at the overall coherence of the Natura 2000 network. So if, for example, we know that those other parts of the SAC contain significant reservoirs of the important lichens, then we could perhaps be a little bit more relaxed about losing some of the lichen within the site itself. Our case, I think, is that more of the core lichen assemblage within the site is being lost than is reported, and I've got some detail which I think will help illustrate that. And in the absence of being able to know that the lichen is well represented elsewhere, we don't know that the SSC will continue to support that qualifying feature, and the compensation won't be provided. I think that's fundamentally the case that we're trying to communicate.
Okay, I think I'm understanding what you're saying is that if you've not looked at these sort of other areas in terms of quantifying what's there,
yes,
then there's part of the sort of overall picture of the qualifying interest of the SCC as a whole, that if there were the same quantities of the same lichen in each of the three areas, I think you said then there may be less of an argument for the loss of some because proportionately it's in. But what am I right in saying that what you're saying is that because they don't exist in the other two, or may not exist
yes,
in the other two, is that the point that you're right?
That's it, sir.
I understand all about the effects and the qualifying and all the consequential stuff that you're talking about. It was more just trying to grasp what you meant by sort of the comparative element. So I wasn't misunderstanding the evidence that was being put forward in your statement.
No, so it sounds like you've understood. I mean, put simply, looking at total area of qualifying habitat misses the key detail, which is that within that habitat, the key feature, as Mr. Watson just said, are the veteran hazels. Looking at the applicant's own figures, we think that something in the region of 21% of all the veteran hazels are going to go, including disproportionately high numbers of the trees that have the key lichens on. We don't think it's correct that 50% of all the species, the key species, will remain represented in the unaffected parts of the site.
Okay, I've got all that, the factual elements that you're talking about there, everything in your evidence I've gone through and I've read. What I just wasn't quite grasping was what your position was in that comparative. I understand that now, so that has answered the question for me. And you've covered the second part first. Is there anything else in terms of just that comparative side of things you want to add to?
No, sir, I don't think so. We'd like to come back on the degree to which alternative route lines were explored, but I think that comes later on. So.
Commenting on. Would the applicants like to come back on the question of the comparative element and the assessment of these other parts of the SAC in relation to lichen and how you would assess that in terms of the impact on the qualifying interests?
Yes, thank you. So I've got a few points in response to that. So I mean, as I said earlier, the lichen surveys that were done weren't limited to the area within the site boundary. Within the SAC, they included all of the SAC that was in Dell Estate, which does provide context of parts of the SAC that lie outside the site boundary, outside the areas that will be affected.
Sorry, can I just... Are you saying that the areas that were referred to in the SAC, they were included in the assessment?
Within the as you said before that there are three different separate, clearly separated parts of the SAC. Our surveys were restricted to the area that of those three that the site lies within, which is Eastern Forest, SSI. We haven't surveyed for lichens within the other two component parts of the SAC, that's Inverfarigate and Glen Taff. What I would say, however, we've obviously gone through a very extensive scoping process for both the EIA and the Shadow HRA. That's involved lots of consultation with Nature Scott and other parties through the scoping process. At no point in that process has anybody raised the requirement to survey for lichens outside of the site itself. The surveys for lichens that have been undertaken actually exceed the area that was requested by Nature Scott through the scoping process and through subsequent consultation. On a related note, I'd point you towards Nature Scott's final response on all matters. I think it's document 9.7, the letter dated the 6th of November 2025, which states that the Shadow HRA provided for this SAC is thorough, covers everything we would expect. The quality of the underpinning vegetation surveys and reports is high. The statement of agreed matters with the Council, which is document 1603, states in paragraph 3.6 that the parties agree that the scope and methodology for the assessment within chapter 10 of the EIAR were appropriate. Obviously that covers the scope of the lichen surveys too. Moving on from that, my view would be that the further lichen surveys of other component parts of the SCC would not affect the conclusions of the EIA or the Shadow HRA. The Shadow HRA concludes an adverse effect on integrity of Neswith's SAC. Further data for other parts of the SAC would not affect that conclusion. Were we trying to put forward a case that there was not an adverse effect on integrity, then in that case I can see that there may be a place for contextual data from other parts of the SAC, but that's not the case here. Similarly, in terms of the development of the compensation measures, they are very much focused on the part of the SAC within which the impact will be taking place. As I've said, we have lichen data for a large part of that part of the SAC beyond the site itself, which provides, in my view, sufficient information to develop the proposed compensation measures. And as I'm sure you're aware, that view is shared by Nature Scott in relation to the compensation measures and the adequacy of them. I think in summary, I would argue that the requirement to survey other parts of the SAC, one of which is over 7 kilometres from the site, the other is over 11 kilometres from the site, is disproportionate and not required.
Can I perhaps add to that? And one minor correction, the Nature Scott response is CD 9.1, not 9.7. And just picking up on the point that Mr. Watson made as to the way the case has been put forward, it is accepted there is a significant impact, and it's building on what he said. It's no part of the derogation case or the assessment of impact that it can be compensated for by the existence of lichens in other parts of the SAC, so that there's been no attempt to reduce the significance of what is being lost by reference to other parts of the SAC, either in the derogation case or by Nature Scott and their acceptance of that.
Okay, thank you for that. Do the Council have anything to add in on this particular matter? Community Council? No. I think that's been helpful because, as I said, I did understand most of what has been submitted and the detail. It was just getting clarity on the sort of comparative element, and I now understand what your argument is, and I understand it's in terms of looking at the qualifying, so the effects on the integrity and qualifying as a whole, looking at that. So I'm fairly clear that I now have a grasp of that. Is there any additional thing that you need to add in?
Very briefly, so regrettably, I'll be as quick as I can. In terms of the Nature Scott letter, they do say in their letter that it's not within their technical remit to assess the alternatives that are being offered. And I would suggest that that's perhaps a reason why they weren't looking to extend the scope of surveys, because if they'd effectively accepted at face value that there are no available alternatives, then there's no need to study whether or not those would have a reduced effect on the integrity of this SAC. I'm not talking about the need to know about lichens in external parts of the SAC in terms of compensation. My point is that compensation needs to reach a state where the overall coherence of the SAC is, and the protected sites network is achieved, and we don't know, as things stand, whether or not features of the SAC will be lost entirely because they're not represented elsewhere, but they are going as a result of this project. Final point, sir, is that the surveys didn't actually cover all of Dell Estate. The lichen report itself identifies areas of veteran hazel that weren't surveyed, both areas, discrete areas and individual veteran hazels. So there is a lacuna in the data there. I think I'll leave it there, sir, and we'll pick up some things in closing submissions.
Okay, I think I've got the clarity that I was looking for from what your position was, and the applicant has obviously clarified their position, so I think we can move on to the next item, and that's looking at the selection of the access track to the powerhouse and alternative options. Firstly, to the applicant. British Lichen Society, in their hearing statement at paras 210 to 211, page 9, referred to the timing of the lichen study and that it didn't form part of the access route selection process. An alternative route, sorry, I'll come on to that later. Can the applicant confirm whether the collected lichen survey data fed into the route selection process? And if not, would it have affected the assessment process itself? So it's really about the timing of when the survey was done in relation to the assessment of the route selection process. So to the applicant first.
Mr. Murphy to deal with that.
Good morning. In direct answer to the question, yes, the lichen survey was taken into account in the optioneering of the access track. If I take it from the top in the sort of strategic context of how the general arrangement has been set out down at the lower reservoir area, the geographical context is important here from a pure technical viability and safety perspective. There are very few areas where a pumped hydro storage powerhouse and intake structure can be constructed, and as you may well have noted from site visits, that the area outlined in the Section 36 location is one of the few sort of flat areas within the wider Loch Ness coastline on the south side related to Loch Kemp. So the location from an engineering perspective is fairly clear. It's fairly directed in what we can do geographically. The question is, what do we need to do down there, and how many assets do we need to access? And that question feeds directly into the number of access tracks that may be required and where they need to get to. So from the outset, the powerhouse general arrangement was developed on the basis of knowing not just where the lichens were, but also other habitat in the wider SAC. So the decisions were taken early on in 2022 to combine. There's a number of key assets that you would have in a pumped hydro. One, namely, is the intake structure. So the nature of our discharge into Loch Ness requires an intake structure. We also have waterways which need to be constructed, as well as main access tunnels, and then the powerhouse itself. A decision was taken early on to combine those into one location, with due regard to lichen studies carried out in Q1, Q2 of 2022. So turning to the
the optioneering of the access tracks themselves. At a macro level, there were ultimately 6 options that were considered. There were 2 options from the northeast and 4 options from the southwest. Their options 1 to 4 are on the southwest, and options 5 and 6 are in the northeast. Options 1 through 4 are effectively options that were based around the use of the existing access tracks on the site. So when we looked at how we could utilise an access track through the SAC, we first and foremost tried to optioneer out the need for an access track. So prior to getting into the detail of the options, we sought to minimise the need or the functional requirements for the access tracks themselves. So we looked at what we could do from a marine access perspective. Could we maximise marine access directly from Loch Ness and thus minimise or eliminate the access track itself? When you play that one to conclusion, ultimately you end up with quite a significant area of land take within the SAC out with the area of the powerhouse. So from a land take perspective and an SAC impact perspective, a marine access solution would have actually induced more land take than it would have reduced. A second alternative would have been to utilise a tunnel option, and I just direct you, sir, to everything I'm discussing here is within the EIA chapter 2 predominantly of the EIA. We looked at whether we could eliminate or reduce the requirement for an access track through the use of a tunnel from the upper reservoir area down to the lower reservoir area. Ultimately, what we need to do from a levels perspective is we need to drop from a level of 183 metres above ordnance datum up at the upper reservoir level down to a level of about 20 metres AOD. So a drop in elevation of approximately 160 metres, and we need to do that over the course of about 1.5 to 2 kilometres. A tunnel, in order to achieve that, would have taken approximately 18 months to 2 years to construct at substantial financial cost. And that point aside, when you look at what you would need to construct that tunnel, you would still require an area of construction support at the base of the tunnel entrance to form the adits to the tunnel at the powerhouse. And similar to the marine access, you may well have actually induced more land take within the SAC. So those 2 points combined lead you directly to the need of an access track, and therefore a move to optioneer the access track as best as possible. So turning back to the 6 options I outlined, options 1 to 4.
Can I just pause for a minute? I've read through all the submissions, so I understand the process you went through to selection. So that's fine. I've got that evidence and understand that. It's a slightly narrower point, and it's relating to that the British Lichen Society refer to an alternative route, and it's really that alternative route that they refer to that would be helpful to get an understanding whether that was assessed and why it wasn't read. Because I've read through all the information, so I'm not wanting to cut you short, but I have done that, and I understand sort of how you've gone through that process. But just maybe to aid this and to focus it onto the point, the British Lichen Society, could you just refer what the alternative route that you're referring to is in terms of the EIA sort of process? And I'm assuming it's one of the routes that were actually looked at, and this may just help us to focus onto that one particular point.
I'm not sure I can focus it down on one, sir, sorry to be unhelpful, but it's effectively the route options to the north of the chosen option. Our general view is that those haven't been adequately explored. I heard what's been said about those having been ruled out very early following the initial appraisal, and we now have the Gilks engineering note which says that those have been ruled out. But I think the language that's used in certainly the Managing Natura 2000 and in the case law we refer to in our hearing statement says that the absence of alternatives needs to be demonstrated. And I don't think that's been done. I think they've been ruled out, that we're told that they've been ruled out, and there's no demonstration that they've been ruled out. I think the applicant's view, I don't want to, obviously they'll correct me if I've got it wrong, is that it would be disproportionate to produce detailed drawings for those cost projections, other forms of assessment. I think I would say that it might be disproportionate if the ecological interest that you were affecting was trivial, but if you're dealing with a site of global importance, producing some drawings to demonstrate that you've explored those options and ruled them out would be proportionate and would be part of demonstrating those options. I can give you the route numbers of the two routes that were looked. I think they were option 5 and 6.
Yeah, and it's red because they're both numbered 5, which is confusing.
But I think our general case is that those were looked at an extremely high level with coloured lines on a plan with no engineering detail and no apparent attempt, or none that we can see, to overcome the engineering difficulties and constraints with delivering them. That's fundamentally our concern.
Okay, so did you say it was route 5?
Route 5 and 6, sir.
Route
Yes,
5
sir.
and 6.
5, yeah, it's 5,
So-
I think, yeah.
Yep. So primarily 5, but route 6 I assume is in a similar location, is that correct? So if we can just sort of respond to those points, that may help us to focus the nub of the point.
Yeah.
Okay, thank
So
you.
the crux of the issue here is the terrain in that area. So options 5 and 6, there were engineering assessments undertaken in the background, which fair enough, you're not seeing in the documentation. The key point here is that in order to descend from a level of 180 MALT down to 20, you induce significant cut. So the terrain there is extremely steep. You've got scree slopes and high-sided slopes coming down into Loch Ness. And what that does when you try to inject an access track into terrain of that nature, you automatically begin to induce cutting, significant levels of cut and significant levels of fill. In the majority of cases along either options 5 or 6, the issue was one of cut. And what I mean by cut is when you need to excavate down to maintain a gradient, a safe gradient for an access track, you need to consider how you're going to stabilise the ground either side of you. For every metre that you drop in cut, you induce 2 metres of width. And in order to safely navigate an access track, either through options 5 or 6, you would induce a working corridor, which would be of the order of 40 to 60 metres in width, and cut depths of the order of 20 to 25, indeed even 30 metres of depth in places, which when we consider the overall habitat impact in the SAC would have induced significant impact on the SAC. Options 5 and 6 don't utilise, or were unable to utilise any existing access tracks in that area. There are no existing access tracks down to the powerhouse in that particular area. And as a result of focusing on those engineering issues, with the best will in the world and all abilities, all activities to minimise gradient and steepen things up as much as we physically could, you come back to the point that the impact on the SAC would be disproportionate from either of those options. And it was at that point in time that either of those options were discounted and we moved to options 1 to 4.
And perhaps I could ask Mr. Murphy to contrast the terrain to the north and to the south, and what, if that would assist you.
No, I've been on site and I've walked it, and I've walked down both, well, only one side because the other bit was too steep to walk down, so I'm physically aware of that. We also saw yesterday when we were on sort of Loch Ness itself, we had a clear view of what the profile of that area was. What I'm really just needing to clarify is at what level of assessment was carried out to rule the routes out. And I think that's the point that British Lichen Society are making, is just to clarify. So I think what you've said is that by assessing it, an assessment of the technical difficulty was what ruled it out. The degree to what level you go to beyond that is a matter of judgment. But I think that's your point, that you don't feel there's sufficient submitted evidence to demonstrate.
Essentially so, sir, yes. My reading of the legislation, the case law and the guidance is that the absence of alternative needs to be demonstrated so that the competent authority can reach that view. And I don't think it has. I don't think the evidence has been submitted to allow you to come to that conclusion, sir.
Okay, that will be for me to review and decide in due course. I think that's all I require sort of that bit. I was just wanting to make sure what the alternative route you're referring to was and what the particular concerns. I think I've covered that off. Is there anything that the applicant wants to add to that? Any other parties?
one very minor one, so that was the macro level alternatives. Just on the micro, I just wanted to point out that the terrestrial lichen survey assessment that was done by Mr. Acton, it does contain a sections 8.2 to 8.3 set out various recommendations that he made for refining the route at the micro level to reduce impacts on important lichens. I've looked and I can't really see how those recommendations have been implemented, so I just invite you to look at that.
Could you give me that reference again? It was just a bit too quick for me to write that down. Is there a document reference number?
Yes, there is, so one moment. Terrestrial lichen. The document reference number is 001124, and the relevant sections are 8.2 to 8.3. So,
thank you. I'll be able to look that up. Okay, I think that's all I have on that question. Moving on, looking at residual impacts on the lichen assemblages, I think we've touched on this a bit, and the level of significance of effects. So in the Ness Woods SEC, the British Lichen Society in paragraphs 2.19 and 2.25 in the hearing statement, that's E pages 11 to 12, highlight that there is an understatement of the damage to the internationally important lichen assemblages. So firstly, can the Lichen Society just expand on why it considers that the EIA report understates the effects, and then can the applicant briefly explain the findings of the EIA report in terms of the residual impacts that you found on lichen?
Yes, sir. So broadly our criticism is the assessment focuses on net losses and gains of the qualifying habitat type rather than losses of the particularly important parts of those qualifying habitats that host the constituent characteristic elements, such as the lichen assemblage. Mr. Watson's correctly said that those are the veteran hazels, and we've estimated that something in the region of 21% of those are going within the area that's been surveyed, which is much higher than the 2% and 1% figures were given for total area loss. Mr. Watson said in his rebuttal that, as I mentioned previously, that something in the region of 50% of all those key species of lichens will be retained within the site. We don't think that's correct, having reviewed the data in the Terrestrial Lichen Survey report that we've just referred to, sir. Just a couple of very quick examples. Arthonia zvakii, which is located at TN9 in that report, which is, as far as we're aware, the only current Scottish record is within the area of impact. Pachyphiala fagicola, it's only been recorded on one veteran hazel, which is TN27, which is near the existing access track. Other records of those elsewhere have been lost in recent times. Microcalcium disseminatum, there's only one recorded birch tree along the proposed access track at TN58. And we have several others, including in particular Navesia sampiana and its obligate parasite. So that's a parasite that only lives on that lichen.
Is that set out in your, what part of your evidence are you referring to for those?
Well,
is that in your original submission or in
it's in several places in the evidence. So in our hearing statement, we say these are the important lichens. The Terrestrial Lichen Survey report sets out where those are. Mr. Watson has said they're not being affected. My point is that we don't think that's correct when you compare those things. When you look at the impact area with the location of the actual location of the lichens in the Terrestrial Lichen Survey report, there are several cases where the important lichen, there isn't 50% of those lichen populations left after you cookie cutter out the bit that's being lost.
Okay, I understand that now. That's clarified. Sort of that. Would the applicant like to respond to that?
Yeah, just briefly on those specific species mentioned, that it's the first time I've seen them mentioned specifically like that. I haven't seen that elsewhere in the evidence.
That's why I was asking where it was sourced from.
So it's difficult for me to comment about specific species. I'd need to go away and look at them and come back.
No, I appreciate if there's just a general sort of to the general point rather than the individual ones?
Yes,
that would
okay.
be-
I can give you a general summary of what the EIA and the HRA say in terms of lichens. So,
Yes, I'll bring you back in a minute. Yeah.
so firstly, just to reiterate that there's no dispute that the lichen assemblage is important. It's assessed as internationally important within the EIA under the assessment methodology used in the EIA, which is the SIEM standard method, which is widely used. An international level of importance is as high as you can get. So in terms of undervaluing it, I can't see how we're undervaluing it because we can't actually assess it any higher. In terms of the level of impact, again, we've assessed it as a significant effect at an international level in the EIA, and that then translates through to the shadow HRA, where I don't think there's any dispute lichens are an important component part of the habitat. They're not the qualifying feature themselves, but they are an important component part of the habitat. And the shadow HRA concludes that there will be an adverse effect on integrity due to habitat loss and fragmentation. I'd also just add in at this point, just again, I know they're not present, but just to quote from Nature Scott's final response, so try and get the number right this time, it's 9-1, I believe. So in respect to Nesbitt's SAC, they state that the shadow HRA provided for this SAC is thorough and covers everything we would expect. In Annex B to that response on page 16, it goes on to state, we agree with the description of the residual impacts on the proposal on Nesbitt's SAC after mitigation provided in the shadow HRA.
Okay, thank you for that. I think that sets out the position. You were keen to come back in.
Very briefly, sir. Just firstly, apologies that this is all coming out here, but there wasn't any other option because the fact that we believe the loss of some of these lichens being understated only came out as a result of Mr. Watson's rebuttal statement, so that's why there wasn't an opportunity to submit something earlier. The only other point I wanted to make is, of course, that Nature Scott have said in terms in their letter that they do not have the ability to assess alternatives. So, to the extent that they agree with the case for derogation, it doesn't necessarily include the assessment of alternatives and which ones may have done less harm, because I think they've accepted it at face value that those aren't feasible.
Okay, I have Nature Scott's comments position, so I will take my own understanding sort of that, but that's helpful, thank you. Okay, moving on to the non-SEC lichens, Loch Kemp and unidentified samples translocation. So to the applicant, paragraph 4.1 to 4.5 of the Lichen Society's hearing statement, which is at page 19 to 20, refers to translocation of lichens. Can the applicant just briefly set out the proposed approach to mitigation in relation to the translocation of lichens, and just comment on the feasibility of this approach? I think I understand it in the set out in the report, but if you can just clarify that for us, please.
Sure. So I think the first point to note here, and the reason we're talking about translocation at all, is because the loss of the lichen assemblage around Loch Kemp is unavoidable. It's due to the it's within the inundation zone. Therefore, there's nothing that can be done to mitigate for that. Those lichens that are present within that inundation zone will ultimately be lost. So translocation is essentially, it's always a last resort in terms of mitigation and compensation options, and you would only ever consider it where there is no alternative mitigation option, which is the case here. In terms of its certainty of success. There is considerable uncertainty over the success of translocation of lichens in this circumstance. In fact, in most cases of translocation, there is considerable uncertainty about success, and that's the case here, and that's acknowledged within the EIA. However, we believe, and then this was a suggestion that initially came from the lichen specialist who carried out the surveys, that an attempt at translocation is worth doing, because it may at least save some of the lichen assemblage. This is both the heathland lichen assemblage and the rocky shore lichen assemblage that will be affected by the inundation, extra inundation at Loch Kemp. We're not considering it to represent full compensation for the negative effect, but if it's even partially successful, it would represent partial compensation for that effect. The applicant's willing to do it where it's feasible to do it, and I think our view is that in simple terms, it's worth a try, but it doesn't fully compensate for the loss of those lichens, and there is no plausible other mitigation for that. So it's essentially doing what we can.
Okay, that was my understanding from reading. Does anybody have any comments on that particular aspect?
I think we could say so that we're now in a position where I think we agree with the applicant's position on the non-SAC lichens around Loch Kemp. Our concern was that the statement of agreed matters appeared to suggest that a degree of satisfaction that the compensation would be adequate. We're keen to push back on that, really, to point out that it's got a high chance of failure, and therefore, in our view, a nationally significant negative impact needs to be weighed in the balance. So. But
there's no dispute that the applicant's accepting that the likelihood is...
No, sir, that's I think what we're saying. We just wanted that clarified.
Okay, thank you for that. Yeah, this is just to the Community Council. I think you state in your hearing statement at paragraph 2.1, which is page 4, that a number of samples remain incompletely identified and the significance of those assemblages remains to be fully established. Can you just clarify on what basis that you reached that conclusion, and then can the applicant respond to that, please?
So looking at the chapter 10 of volume 4 of the EIA freshwater lichens, the surveyor describes a species resembling Placyntium panellarium but without lobes, and he says it requires further investigation, and also a freshwater sponge tentatively identified as Spongilla lacustris was also frequently found around the loch, as well as out Acheen Vonach. And he says this should be investigated further by a specialist. The surveyor has very limited knowledge of this freshwater sponge. A specialist should be sought to identify this species and evaluate its rarity and the impact of the proposed development on this species. So there are at least 2 species present, so outside the SAC, on the around Loch Kemp, that have been incompletely identified. The applicant in their rebuttal said that they've assessed these lichens to be of national importance, but without actually identifying these species, we don't know whether they are actually more significant than that. It's at least possible the species, that the Placyntium panellarium but without lobes, it could be anything from a misidentification by the surveyor to an unknown species that could be of international importance. We don't know.
Okay, would the applicant like to respond?
Thank you. Yes, a few points in response. As has been pointed out, this is addressed in paragraph 4.6 of the applicant's rebuttal statement, that's 1868. A lot of lichens can be very difficult to identify, even for specialists. And I think one or two unidentified specimens during surveys of this scale is not unexpected and doesn't mean that the survey is invalid. In relation to the sponge, obviously that's not a lichen, it's an invertebrate, hence the surveyor not having the knowledge of that species, and the species expected is not, it's not a species of substantial conservation importance, it's not included on any lists. In terms of, has this affected the evaluation of the importance? No, it hasn't. The way that the importance of the lichen assemblages has been determined is based on indices which are based on the number of certain species that are present within the assemblage. These are all standard ways of evaluating lichen assemblages. So the presence of one additional species would not substantially affect that. I should note also that the species referred to was included in the index as a precaution anyway, so it doesn't affect that evaluation of national importance at all.
Okay, thank you for that. Does anybody else wish to make any comment on that particular point? No? Okay, thank you. Lost my place, just bear with me a second. Okay, so item 6, I think we're on now. Ancient and other woodland, we're looking at mitigation compensatory measures, and this is to the applicant. I think we've actually partly covered this in previous answers. Yep, I think we've covered the mitigation measures in relation to the EI report for ancient woodland. No, let's cover the lichen bit. So, focusing on lichen rather than ancient woodland, because I think we've covered off the ancient woodland fairly clearly. So, in terms of any mitigation measures that are included in the EI report in relation to the lichen, can you briefly just summarise any compensatory measures proposed that form part of the HRA or the case for derogation? Basically, the difference between what's in the EIA report and the case for sort of derogation in relation to lichen.
So we're referring to Nestwood's SAC specifically here. Well, the compensation measures set out in the EIA report and those set out in the derogation report are the same,
right?
Ultimately,
okay.
So, in summary, and these compensation measures were developed over some time through ongoing consultation with Nature Scott. And that's why, for instance, we don't propose compensatory planting within the SAC. That's through discussions with Nature Scott. But in summary, so those compensation measures are set out in section 4.6 of the updated case for derogation report. That's document 3.5. They're also set out in paragraphs 10.9.1 to 10.9.5 of chapter 10 of the EIA report. That's document 116. So in summary, the compensation measures include the adaptive management. So that's starting off with focusing on managing grazing impacts, but adaptive in the sense that those measures could be changed if monitoring results or specialist input over the course of time determines that they're not having the desired effect. That would be applied to 234.76 hectares within Nestwood's SAC, which is essentially all of the area of the SAC that's within the Dell Estate boundary. The aim of that management would be to improve its condition from unfavourable, which it is currently, firstly to unfavourable recovering, and then in due course to favourable. The compensation would also include the adaptive management of 8.08 hectares of land which is outside Neswood's SAC, that's sites 3 to 8 as shown in the updated case for derogation report, with the ultimate aim that those sites would be able to be brought into the SAC in time. There is also an additional area of land outside the SAC immediately adjacent to the north, which is the FLS Foyers South Camas land. That's 30.08 hectares in size. The compensation would include the adaptive management of that land, which would include 22.5 hectares of that land is planted with non-native conifers. Those would be felled, and management would take place with the aim of ultimately bringing that site into the SAC in time. Then the final one is a smaller one, but it would be the restoration of the existing 4x4 track within the SAC, the parts of the 4x4 track that wouldn't be on the proposed access and currently has no ecological value. So I think those are the key elements of the compensation package. I think it's worth noting that without these measures or equivalent measures, the ancient woodland and so therefore the qualifying features and ultimately the lichens too are declining in value primarily due to high grazing impacts, and without substantial management the current unfavourable condition is likely to decline further over time, so that ultimately without intervention on that scale there would likely be a long-term decline in the woodland extent within the SAC.
Okay, thank you for that. Just wanted to set that scene. Turning to British Lichen Society then, at paragraphs 5.1 to 5.2 of your hearing statement, which I think is e-page 23, you contend that the proposed compensation measures, which we've been referring to, are not sufficient to ensure the coherence of the national site network. Can you just expand briefly on what further compensatory provisions you think should be included in relation to the ancient woodland or the lichen assemblages?
Yes, sir, certainly. So, I mean, I think the key point is that whilst we accept that the compensation provision has a degree of efficacy when you're trying to replace the broad habitat types that form the qualifying features of the SAC, the problem is that there are significant doubts over the ability of that compensation to replace the lichen assemblage and other irreplaceable constituent parts. So the bits where its existence relies on a very narrow range of environmental conditions or the long passage of time, you can't put those things back. And for us, it's the combination of losing a very large proportion of what's there currently with faith in compensation provision that has a high degree of doubt in terms of replacing those missing pieces of the puzzle where our concern lies. 2 points related to that. One is that traditionally regulators have been, as I've set out in my hearing statement, worried about relying on bringing SACs back into favourable management as forming part of a compensation package, because the Habitats Directive expects that member states would implement appropriate management for SACs. And if you were to accept bringing an SAC back into favourable management, the concern is that it might create a perverse incentive for owners of such sites to allow management to lapse so that it can then be offered as compensation for development effectively. And that's, in my view, why the provisions of Article 6.1, 6.2 and 6.3 of the Habitats Directive are deliberately separated, so it talks about expectations on existing management of SACs and then compensation provisions separately. Finally, we remain concerned that the element of the compensation package that relies on bringing Neswood's SAC back into favourable management, Mr. Watson says that the cessation of grazing is not proposed in his rebuttal statement, but it is in fact stated at, let me find the link. It is document 003004, which is the SLR technical report to inform updated Nestwoods SAC compensation. Page 14 of that has a statement stating that the cessation of grazing will have positive effects. We agree with the applicant that the SAC is overbrowsed by deer, and that is harming the lichen interest and other things, and it would benefit from a reduction in deer browsing. But the cessation of grazing in its entirety would be catastrophic for the lichen assemblage. Ideally, the wood needs a light grazing by some deer and some cattle to bring the lichen assemblage back into favourable conservation status. So those are the main points. Did that answer your question? Sorry, I slightly lost track.
That's okay. I got the gist of it. Yes, I think what I was just trying to establish was that there wasn't any additional compensatory measures that hadn't been included. I think there's a discussion over the appropriateness of that and management, and that's all in the evidence, and I understand that. But I just wanted to make sure there wasn't anything additional. You've mentioned the limited grazing element to it, but I think that clarifies that for me. Okay, moving on. The next one is about the SOAM, but I think that's been updated by the submission of a revised SOAM. So I don't know whether the applicant or the council just want to cover that point. The council mentioned it to me this morning, so I'm going to ask them to do it.
Sorry, it's just to check you had the updated version that has a small change to paragraph 3.9b that I think helps clarify the issue we've just been talking about in relation to the lichens, and perhaps it was overstated, the amount of agreement and the indication that it might not be thought to be a problem, as opposed to recognition that there's nothing more that can be done. Hopefully that's been clarified through the new SOAM.
Okay, I've got a copy of the SOAM, and it was circulated. Did the British Lichen Society see that, because it was one of their points that they raised? It's basically, you raised the point that in the Statement of Agreed Matters, the wording that impacts on lichens outside the Nestwoods SEC would be mitigated and compensated for, which I think is just, from what the applicant and the council said, it was an error, and they've readdressed that, saying clearly it's in the document. I don't know if you've got the document to hand.
Yes, I have seen it, and I think the clarification provided today addresses our concern.
And are you content that response is more accurate then? It may not fully address your concerns, but I think it's changed the emphasis of what was being said.
Would it be okay for me to come back to you on that, sir? Apologies.
Yes, yeah. You can always pick that up in closing submissions if you need to.
Yeah, yes, rather than deal with it on the hoof.
I understand that fully, yeah.
In written submissions.
That's perfectly fine.
Thank you.
Okay, 12 o'clock, we'll hopefully get this finished.
So can I just raise...
Yes, Mr. Finlay.
Sorry, so can I just raise one point to take you back to item 5 on the agenda? You were referred by the British Lichen Society to a document you said you would have a look at, which is CD 1.124. My note, I think, is at sections 8.2 and 8.3. And that was in the concept of micrositing and taking into account the lichen survey and small changes to the roots as opposed to big changes to the roots, if I can use that technical language. Just when looking at that, so can I draw your attention to chapter 2 of the EIAR, which is CD 1.8, and plate 2.8, which I think is electronic page 24 of 32, and paragraphs 2.8.9 and 2.8.15, as well as 2.9.1, which detail some of the detailed consideration given to the access track. I hoped it was more helpful to say that now rather than closing submissions, so that you can consider both those two together, and indeed other parties can too.
I've taken a note of those references. Thank you. Okay, moving on to back to policy. We've had a little break from that. Looking at policy 3, biodiversity. Just bear with me while I copy of it. In paragraph 5.5 of the Lichen Society's hearing statement, that was page 26, prevents the view that the proposed development fails to accord with policy 3 of NPF 4. So I just want to look briefly at the points raised in turn. There's not a huge amount, I just want to sort of clarify a few points. So there's a few headings, but hopefully it's really just for my clarity of understanding. Yeah, so in terms of policy 3 part B and looking at the term intervention, just from the applicant, could you just briefly outline what interventions the proposed development would bring that would not happen without it, and what best practice assessments have been used?
Maybe if I come in first, sir, then Mr Watson, on some of the technical aspects of best practice and assessments. I think just earlier Mr Watson said that without intervention a number of the qualifying features of the SAC are in decline, so that's a good overarching illustration of the positive effect of the actions, the intervention to arrest that decline and result in a net benefit. And that point about there being a net benefit is the overall thrust of the policy, I would say, where it talks about interventions.
So one of the interventions is the management of the estate that you referred to in the mitigation measures. Yeah.
That is right, and I think from my perspective, looking at policy, there would be two arms to that. The other interventions. One is the habitat creation and enhancement that's set out in the outline habitat management plan, which is Appendix 20.7. That's the non-SAC interventions, and then separately the compensation package for the Nest Woods SAC. And as Mr Watson said, that's referenced in the derogation report and in Chapter 10 of the EIA report. I don't know, Mr Watson, if you want to add any further points to
just to add some detail to that. So outside the SAC, I think it's Table 10.14 in EIA Chapter 10, so document 116, provides a sort of
Sorry, can you just give me that table reference number again?
Table 10.14.
Thank you.
So that provides a sort of a brief summary of some of the losses and gains of important terrestrial habitat types as a result of the proposed development. It also includes a summary of what represent enhancement measures. So of particular relevance outside the SEC in terms of delivering substantial biodiversity enhancement are the woodland creation proposals as part of the compensatory planting, and the fact, as noted before, that would result in an increase of 51.5 hectares of native woodland within the site compared with currently. The other key one outside the SEC would be the heathland management proposals that form part of that outline HMP, which would include enhancement of an area around 10 times the size of the area of heathland that would be lost as a result of the proposed development. So again, delivering a substantial biodiversity enhancement. There are also probably more minor enhancement measures regarding a number of protected and notable species, red squirrel, bats, etc., which are detailed in the same document. And then just to go back to the SAC briefly, I think because of the unfavourable condition of the SAC, because its condition is declining without the substantial intervention over the substantial time period that's proposed here, I think it's certainly fair to say that the proposed development will leave the SAC in in a better state than it is currently.
Okay, thank you for that. Just taking the second sort of part, policy 3B refers to inform this after the sort of those qualifications of interventions. Best practice assessment methods should be used. What's your understanding of what that means?
I would understand that to mean that the assessment carried out as part of the EIA and that is also used to inform the Shadow HRA report. And as I've highlighted to you previously, in the statement of agreed matters with the Council, there's no disagreement with regard to the technical findings of the assessment. Nature Scott also have no concerns over the quality of the assessment.
Okay, thank you. Does anybody else have any comments they want to make on Part B in terms of intervention? Okay, looking at Policy 3 Part B, Roman numeral 1, existing characteristics. The Lichen Society in paragraph 5.6 of their hearing statement, that was page 26, states that the proposed development fails to meet the requirements of B1 by failing to provide information that enables the scale of the loss of lichen assemblage to be fully understood at local, national, and local, regional, and national level, and failing to acknowledge or address the loss of a replaceable ancient woodland. I think a lot of that's been clarified in the evidence you've submitted today. Is there anything else that you would want to add to that? Because reading it, I think I've picked up most of those points from your evidence, but is there anything else that you wish to add in terms of Part B 1?
Only one point, sir, which is broad but sort of fairly fundamental, is that insofar as this policy refers to biodiversity as being a variety of life on Earth, the bits that the compensation doesn't do much to address are those irreplaceable elements of the ancient woodland and the lichen assemblage that we've mentioned. So that although you're getting more of other things, the overall variety of life is what's at stake in terms of, as I've mentioned earlier in oral evidence, things that are unique to Scotland and only occur here, potentially being lost. I think biodiversity will decline overall in terms of that breadth of variety. That's the only point, really.
Okay, does anybody else wish to comment on that? It must be getting close to lunchtime, but we will keep on progressing through. Looking at Policy 3 Part B, Roman numerals 3, mitigation, hierarchy and compensation, the applicant at paragraph 3.64 of the rebuttal statement, I think that's page 15, provides a summary of the assessment undertaken in relation to this part of the policy. This is a question to the Lichen Society. Can you just clarify what your concerns are in relation to this part of the policy? That's Part B, Roman numerals 3.
Yes, sir. I mean, I think without repeating all the detail of previous evidence, it's that the flow of the mitigation hierarchy in MPF4 is to avoid harm first, then minimise it, then restore, then offset. I think from the evidence we've already presented, you can see we have concerns about the fact that opportunities to avoid and minimise harm were not taken, or haven't been fully explored at least to the extent that that's not, our view is that that's not been demonstrated in the submitted evidence, and that much of what's being done by the proposals sits at that very last stage of the mitigation hierarchy and trying to offset that harm by providing compensation. So we think that the earlier stages of that flow are underexplored.
Okay, thank you for that. Would the applicants wish to make any response?
Just say, sir, that the EIA is thorough, and the Chapter 2, Design, Evolution and Alternatives, goes through the full baseline studies that have been undertaken and examines the various constraints. So the applicant's position is that there's been a thorough EIA approach and the proper application of the mitigation hierarchy. Thank you.
Okay, thank you for that. Does anybody else wish to make any comment on that? Policy 3 Part C is referred to in the evidence, but my understanding is that really refers to local development, and what we're dealing with here is a national development. So I'm assuming that nobody's arguing that this would apply in this particular circumstance. It's mentioned, I think, in the British Lichen Society's case, but I think that's just been maybe just an oversight of the policy. Yep. Okay, thank you for that. Policy 3 Part D, which covers sort of planning and design matters. This is to British Lichen Society. Paragraph 5.7 of your hearing statement at page 26 suggests that the majority of concerns and objections expressed appear capable of being overcome through revisions to the proposed development. So apart from the access track alternative options, which we've already looked at, are there any other design elements that you think should have been considered to address the issues?
There's none that we wish to raise, so our fundamental concern is the degree of impact on the lichen assemblage and that particular alternative options that we've covered.
Okay, so there's nothing else for me to take into consideration apart from the track. So again, sorry, British Lichen Society, just that this is a good, sort of a substantial part of your evidence. Can you just very briefly then just summarise to me which parts of Policy 3 you consider that the proposal does not sort of comply with? Because there's a general statement of non-compliance, but I just want to make sure I'm fully understanding which parts of the policy you consider are non-compliant. That's just because we're referring to local development was within that originally.
Yes, sir, and you're right. That was an oversight. Bear with me. So we consider conflict with Policy 3 Part B, insofar as we don't think that what's been done to address effects on the specific irreplaceable features that we've mentioned to do with the ancient woodland and the lichens have been adequately addressed, so that the extent to which that part of the policy applies to biodiversity and those features of biodiversity, we think that the result is net negative rather than net positive. Policy B, Part I, not understanding the local, regional and national ecological context, that relates to our points about insufficient understanding of how much of the lichen resource is actually being lost. So under representation of what's being lost and a lack of knowledge of what remains in the SAC, which also speaks to the HRA test in terms of ensuring the overall coherence of Natura 2000 by making sure that the SAC continues to support those features. So Policy BI, we believe there's a conflict with that. Policy 3 Part B, Roman numeral 3, I've already mentioned our view that the earlier stages of the mitigation hierarchy aren't adequately explored. Certainly not to the extent that is justified by the importance of the feature that's being negatively affected. Part D. And to that extent also, we believe there's a conflict with Policy 3 Part D, which is in that the design of the proposals hasn't adequately taken steps to minimise the impacts I've just described through careful planning and design. I think that's it.
Okay, thank you. I just want to be clear where your main focus was on that. Does anybody else have any other comment to make on that? The applicants? Community Council? Yep. Council? Okay. Moving on to item 8, shadow derogation case, alternative solutions. So this is to the Community Council. I think at paragraph 2.2 of your hearing statement and page 5, you make reference to alternative solutions would you be able to expand your concerns in relation to the applicant's statement? I think it's in the Statement of Agreed Matters at paragraph 3.17c, which is page 4, that the case, and this is what the SOAM says, that the case for derogation contains an appropriate consideration of alternative solutions and its conclusions are not disputed. So I think you call on that question. Can you just expand on what your concerns are in relation to that statement?
Yes, so I think there's general agreement that the 3 steps in the shadow derogation case are to be considered sequentially, and the Community Council is concerned that the first step is not satisfied, so therefore the subsequent steps are therefore moot. I think the exact wording of the DEFRA guidance that the applicant referred to in the rebuttal hearing statement is really important. The DEFRA guidance says examples of alternatives that may not, that's my emphasis, may not meet the original objective include proposals, and then there's an example of nuclear instead of offshore wind energy. So the language there, may not, also implies the possibility that it may. So that does not, that in itself does not mean that other modes of energy storage should not be considered. It just means that if the objectives are not met, it might not need to be considered. I think there's general agreement that the objectives are supported by the Department of Energy Security Net Zero's target, which is 4 to 6 gigawatts of LDES, long duration energy storage, by 2030. I'm not aware of any government targets for pump storage beyond a general acknowledgement that it will be part of that LDES mix. It's the Community Council's view that the applicant continues to conflate long duration energy storage with pump storage and considers them to be equivalent, as if pump storage is the only the only mode to be considered. The applicant's statement in the case of derogation section 2.3.2 that pump storage is the only long duration energy storage technology that can store for over 8 hours is now factually incorrect. The off-gem cap and floor scheme, which is currently under consideration, item 5 of their 7 eligibility criteria, it requires that schemes can store for...
Sorry, Mr. Hindley, is that submitted in evidence that what you're referring to?
Yes.
Okay, you've got the reference number just so I can take note of that, please. That's okay, take your time, that's all right.
So that is 023.002. 23.002. LDES eligibility assessment outcome. So there are 7 criteria. 5 is duration, and that requires that projects that are considered eligible for further consideration can produce 8 hours of energy at full power. There are 77 schemes that have passed the eligibility criteria. Of those, 48 are lithium ion, and 5 are pump storage, 16 vanadium flow or zinc, 5 vanadium flow pure, and then 2 liquid air energy storage and 1 compressed air energy storage. So our submission is that there are alternatives to this project that would deliver the government aim of 4 to 6 gigawatt hours of LDES by 2030.
Okay, thank you for that. Would the applicant like to make a response?
Yes, sir. So just for your note, the applicant's case on alternatives is set out in detail in section 2.5 onwards of the updated case for derogation, which is document 3.5. The DEFRA 2021 Guidance on Habitats Regulations Assessment, which is document 18.62 that was referred to, the explanation given in that guidance on the process of looking at alternatives, it starts on PDF page 16. The first bullet point notes there that an alternative solution is acceptable if it achieves the same overall objective as the original proposal. And then, as Mr. Hindley explained, it goes on to list the examples of alternatives that may not meet the original objective of the project, including one that offered nuclear instead of offshore wind energy, provides rail instead of road transport, and it provides a number of other examples as well. If I can just add a bit of colour to how that's been applied in practice by the Scottish ministers previously in Scotland, particularly in the offshore wind sector, where it's probably the most recent derogation cases for each of the west of Orkney wind farm, Berwick Bank offshore wind farm, and the Greenville offshore wind farm. The Scottish ministers, in determining what the objectives of the project were to have a look at the technology component as well. So in each case, they concluded that the delivery of significant volumes of low-carbon electricity from offshore...
Sorry, Mr. Miller, is there a reference for that you're referring to?
I don't have the decision letters in.
It's not submitted as evidence?
It's not in evidence, no.
Right, okay.
I was just speaking to it from my own knowledge of that sector. I can submit decision letters if it would assist.
I think it would be helpful if that was the case, because otherwise I've got nothing to reference to, if nobody has any objection to that. Okay.
And so I was explaining that the way that they have determined what the objective of those projects was to conclude that it was a decarbonisation of Scottish electricity supply from offshore wind farms, and then they went on to rule out alternative technologies such as onshore wind as being able to deliver that. And the reason that they had the technology component as part of that objective is that there was support for that in planning policy. So that was applied by the applicant in considering the case for derogation in this case, and the primary project objective that the applicant has identified set out in paragraph 2.3.3 of the updated case for derogation, and again document 3.5, and that's to deliver pumped hydro storage in northern Scotland to help Great Britain meet the requirement of 4 to 6 gigawatts of long-duration electricity storage by 2030. And the delivery of pumped storage is a key component of that. And the applicant's position is that, similar to offshore wind developments, there is identification of a specific technology need in planning policy, in particular NPF 4 at page 102, document reference 12.1, identifies pumped hydro storage as a national development, and that is distinct from other forms of electricity infrastructure, including battery technology. Within the case for a derogation, the applicant has noted other technologies at paragraph 2.5.8, and it sets out an analysis of technical reasons why they are not comparable to pumped storage. That is leaving aside the planning policy point that I just referred to. In respect of the off-gem eligibility assessment outcome that was referred to earlier, document 23.2, that is specifically in relation to a government subsidy process about subsidising various technologies that would deliver long-duration energy storage, and the applicant's submission is that that's not something that can be read across into the alternatives assessment under the HRA process. It isn't a document that has any planning policy status.
Okay, thank you for that. Mr. Hindley, do you want to come back on any particular matter? As I say, I've got your evidence on that, and obviously I've got the case for derogation, so there's obviously a difference of views on that. But is there anything else you wish to add?
The Community Council would also highlight that in the case for derogation, in the section where the applicant is considering alternative pump storage schemes, it ignores, this is section 2.5.15, It ignores the Glen Erich scheme, which was formerly Barmacan, which has just entered planning. So we would still submit that alternatives to this scheme do exist, and therefore the case for derogation, the first step of the case for derogation is not met.
I think that may well been the scheme that was referred to in the further written submissions that came in relation to the race-saw decision. Am I right? I think Mr Kelly's nodding, because I think it was Mr Kelly that referred to it, and I have asked the applicants to, in the context of that further written submission, sort of to comment on that aspect of it. But if the applicants, do you want to make any comment about that decision in relationship to the timescales when you were preparing the case for derogation?
That application is certainly subsequent to the application for a derogation, but I think the wider conclusion in that section of the case for a derogation is that any pumped storage hydro project that would be considered acceptable in the planning balance is required and supported by planning policy. So they're not trying to compare alternative proposals like for like. That is supported in a planning policy context. If I can just give it for your notes, sir, it's something that is quoted within the updated derogation case at paragraphs 2.5.12 to 2.5.14, and that's a reference to the UK Government's National Policy Statement for Energy, EN1. That's document number 18/15, and it goes on to note that that projects at other locations are not likely to be treated as an alternative solution for electricity infrastructure because of the critical national priority need for all of those projects to be developed.
Okay, I think I've got the two positions on that, and obviously evidence has been submitted on that basis. So I'm happy enough to move on. Are you okay with that, Mr Hindley? Okay, that brings us to item 9, which was any other matters. So is there anything else that anybody wishes to raise in the context of this particular hearing? I'll just go around the table. The applicant? No? The council? British Lichen Society?
Yeah. Thanks. Yeah. Sorry, I can't read the writing. What was it there?
Sir, what the Society would like to say is that we're obviously not part of the conditions session, but if there was a role for the BLS in assisting with the input into the habitat management plan, so I'd very much welcome the opportunity to have that as part of the condition, or at least to consult with the council and provide input to the council when the habitat management plan is being agreed.
Okay, we've got the conditions hearing on Wednesday afternoon, and I don't think you're down for part of that, but if you want to submit an email to me, I'll give me a chance to consider it, and then I can deal with it on Wednesday at the conditions hearing itself, if that's...
Thank you, sir.
Okay, I'll give me a chance to have a think through it. Mr Hindley, do you have anything else to add?
No, nothing.
No? Okay, well, that's really just the end of this hearing number 1, and we've most brought it in at 12:30, which is pretty good going. So I would just like to thank you all for your participation. It's been a very useful discussion for me, and it's helped to clarify a fair few points that I had. So that closes this session. I look forward to seeing probably many of you again after lunch, and the proceedings will commence at 1:30 p.m. if people are happy enough for an hour for lunch, at which time we'll be considering the transport access and traffic matters. So thank you all for this morning's session and your attendance. Good afternoon, everybody, and welcome to this second session hearing. This afternoon's hearing will be on traffic access and transport matters as part of the inquiry into the application for the Loch Kemp storage electricity generating station at Dell Lodge, Whitebridge. As most of you will know by now, but not everybody, my name is Gordon Reid. I'm the reporter appointed by Scottish ministers to consider this pumped storage hydro application and to report back to them. An agenda for today's hearing was issued on the 1st of April, which I hope you have a copy of. This is an in-person session, is being broadcast live. As with the previous sessions, by taking part today, you're consenting to being filmed and to the use and storage of those images and sound recordings and any information contained in them for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. So, can we just ask the parties to introduce themselves, and we'll start with the applicant.
Yes, thank you very much. Good afternoon. My name is James Findlay, King's Counsel. I'm instructed by Patrick Munro, who sits to my left from Burgess Salmon. To his left sits Gordon Buchan, who's a chartered engineer, and to his left sits Stephen Reid, who's a project manager with Stratera Energy. And at the end of the table is Andrew Troop, also from Stratera Energy.
Okay, thank you. And for the council?
Good afternoon, sir. I'm Alistair Burnett, King's Counsel. I'm instructed by Arlene Gibbs of the Council's Legal Department, who's sitting to my right. And for this session, I'm accompanied on my left by Colin Ross, and on my right by Mark Clough of the Council's Roads Department.
Thank you for that. And for Strathnairn Community Council?
Good afternoon, I'm Maria Coburn. I'm representing Strathnairn Community Council. To my right, I have Julie McRae, we have David Lumsden and Rob Atkinson.
Thank you for that. And Stratherick and Foyers Community Council?
Good afternoon, my name is Mark Hindley. I'm the Chair of Stratherick and Foyers Community Council.
Okay, thank you all. So the purpose of this afternoon's hearing session is for me to examine matters raised in relation to traffic, access and transport matters. However, I will not go over ground that where there's agreement or where I consider that further information is not required for me to prepare my report. So the session will be a structured discussion that I will lead based on the headings in the agenda that was circulated. I will not allow any formal presentation of cases or any cross-examination. I shall lead the discussion by starting off each agenda item by directing a question at one of the parties. After the answer, I shall invite other parties to comment in turn. If you have comments or questions as the discussion progresses, please make sure these go through me and let the other party finish their point. Even if you feel strongly or disagree with it, please do not interrupt them. You'll have your chance to make comment in due course. So I will leave it up to the main spokesperson to decide who answers the questions for their team, and that spokesperson may wish to add some concluding remarks on certain points. These, however, should be brief and focused. If you remember, when you're not speaking, to switch off your microphone, that would be helpful. And also, if you're referring to documents, please have the document number and electronic page, paragraph number, if you're making references to hand. If you can provide those references clearly to me so I can take a note of them for future reference, that would be helpful. So when I consider that I have the information I need to write up my report, I'll move on to the next item. Don't feel obliged to comment if you're only repeating something that has already been said, or if you've already submitted it in your written material, I will have already seen it and read it. All that you tell me today is evidence, and that may need to be included in my report, and you will see me take notes. I may have to pause to make sure I've taken everything down properly, so I may need time to catch up. I expect that the matters set out in the agenda will be dealt with during the course of this afternoon. And before we turn to item 2 on the agenda, does anybody have any questions or matters to raise before we commence? I'm not seeing any nods. That's fine. Okay, so we'll move on to the first item on the agenda. This is the proposed construction of vehicle delivery routes, oblique traffic volumes. Now, the first few questions will be primarily towards the applicant, and that's for me to get some idea and to set some context of what we're going to talk about in the subsequent questions that follow. But if you wish to raise a point or a question, then please feel free to do that. So just looking at the route selection process first, can the applicant briefly outline the reasons why the proposed construction traffic route was chosen, and in particular why the B851 is being used rather than the B862 along its full length into Inverness from the application site?
Thank you, sir. I'm Gordon Buchan on behalf of the applicant. The routes selected use routes that have been previously used for the construction of other projects in the past. These include Dunmaglass Wind Farm, Aberarder Wind Farm and Corrigarth Wind Farm, and they've previously accommodated construction traffic movements, including abnormal indivisible load access, notably from the A9 along the route. The route, the B851 and the 862 from the A9 have also benefited from various road improvement works, twin tracking of the road, corner widening and the recent replacement of the Flickety Bridge. Options coming from the B862 straight from Inverness would bring construction HGV traffic through Doris and Inverness and would take traffic away from the efficient access to the strategic trunk road network on the A9 and also present more of a diversion for potential material suppliers. So that's generally why we've looked at access coming directly from the A9 via the B851 and 862. So.
I forgot to switch my microphone on. So it's primarily due to the access directly from the A9 that the B851 has been used in terms of HGV vehicles. Is that the main point of not taking traffic through Inverness itself?
Yeah, yes, that is correct, sir.
Okay, thank you for that. Does anybody else wish to sort of comment on that, just that principle?
Hi, my name's David, part of Strathnairn. So I stay on the B851, and there's another project that's in the pipeline, Red John or Loch Kemp as it's called now. They've been in dialogue with us about a possible alternative route that's going alongside the Essex Road. Is that something that you guys have evaluated and to try and keep your traffic and your HGV traffic off the main roads to use something that's off-road?
Sorry, Mr. Holmes, can you just clarify what alternative route would that be? Because obviously I've been referring to the B851 and B85, other way around, 52. Is this an additional route that you're referring to?
Correct.
Yeah. And where would that be?
So it's the discussions that we've been having or we've been hearing from the sideline from the Red John project is alongside the Essex Road, which is
you'll have to assist me in that because my geography is not.
I
know the numbers, but if it's names, I need to explain that to me.
It's to the south, or sorry, to the north of the B861.
Okay.
So, if I may assist, the Essex Road comes from the A8082, which is the southern orbital of Inverness, and drops down between the 862 and the B861, and it provides a kind of parallel route in section.
So I assume that catches up with the B851 at some point along its route.
It avoids the settlement of doors.
So if you can switch your microphone off, please. It's the cameras follow the microphone, so if you can just remember. So it's one that comes. Does that come out of Inverness, bypasses doors, and then joins the B851?
It runs parallel to the road that runs Loch Ness side to Doors, but up high, and then you ascend out of Doors at elevation, and that road marries in with the B862 at that point.
Okay, thank you. Does the applicant wish to make any comment on that?
Thank you, sir. The Essex road again would divert traffic away from the A9. It would increase the vehicle journey times coming from the A9. In addition, the road itself would require enhanced improvements, provision of further passing places and other elements potentially in excess to those required for the route that has been proposed.
Can I just clarify, was that looked at as part of the traffic assessment and ruled out, or was it not considered?
At the start, sir, we looked at all alternative options. That was not a route that we considered feasible.
And that's within the traffic assessment as submitted?
It is not, no. It was part of an engineering feasibility review undertaken at the start. So.
Right, so your decision predates preparing the transport assessment?
Yes, that's correct.
Okay, thank you. Okay, thank you for that. Looking at the breakdown of traffic volumes in terms of HGVs, abnormal and divisible loads will shorthand to AIL, just for everybody's benefit, and it saves me trying to pronounce it every time. So an AIL is just reference to that. So to the applicant, can you just, again, a bit of scene setting here, can you just sort of set out what the total number of journeys along the B851 route on a daily basis would be, and by which vehicles?
So can I just clarify, is that for development traffic or for...
Sorry, I'll clarify. For the proposed development, generated by the proposed development. Yeah. And I'll give you the second part, because I might help you in the first part. So the second part is, will any vehicles generated by the proposed development use the B852 from Inverness? Now, I'm aware that HGVs are using the 851, but will any of the other vehicles use the alternative route? And thirdly, what route will the AIL deliveries use if coming by road? I know there's a separate issue about coming via sort of Loch Ness, but if they were coming by road, what route would they use, just to have clarity?
Just helps, so I'll get the reference for the transport assessment, which is 001.142, which is potentially the easiest way to illustrate that. And if I can refer you to page 6, which is the peak construction traffic broken down. In that document, so the vehicle numbers are broken down into cars and light goods vehicles. You then have heavy goods vehicles, HGVs, and then there's a total there. So, for example, the B851 at Inverarney has 60 cars and LGVs at peak per day, 68 HGVs, which results in a total of 128 vehicles per day. In terms of abnormal indivisible loads, there are two routes for AIL components. The first is the use of the canal, and that would be used for the proposed development pumps, larger elements of the high voltage equipment required on site. Those elements are proposed to be brought up the canal, and that is in accordance with the UK government water preferred policy for abnormal load movements. These loads are potentially quite heavy and potentially heavier than other loads that have been on the route as used for the construction of the wind farm projects. The other abnormal load element to it would be items of plant. They're covered within the transport assessment as well, sir, and they relate to cranes, large-scale earth-moving plant, and that again would be from the A9, B851, and then on the 862. And again, that is provided within the transport assessment. That is in Appendix C, and there's a route survey report for those items of plant there, sir.
I've got that. So in terms of what vehicles will be using the B862, will that be staff going to the site, light vans and vehicles, will that route be used for that purpose?
In terms of the B862, so the site access is on the B862, so that would accommodate staff movements, it would accommodate light goods vehicle movements for the provision of smaller elements to and from the site. It would also accommodate HGVs for bulk material deliveries, and it would also accommodate abnormal loads in terms of plant and equipment movements.
If somebody's coming from Inverness rather than the A9, what vehicles or movements would be coming from the Inverness to the site? Sorry, I didn't quite explain the point I was trying to make. I'm just trying to work out what traffic generated by, or what type of traffic generated by the proposed development would be using the B862. I understand the HGVs will use the other route, but is there a volume that will be using that alternative route? Sorry, I should have explained that better in the first place.
Sorry, my apologies, sir. On the B862 from the Inverness section, that is proposed to be cars in terms of staff movements and some limited HGV movements. There would be no HGV movements on that section, sir.
Thank you, that helps to clarify that. As I say, I'm just trying to set the scene of what roads being used for what as we move forward. Okay, I think you may have answered this next question, but just looking at the use of the canal for AIL as part of the TA, reference has been made to the use of the Caledonian Canal for AIL deliveries. Has the viability of this option been investigated to ascertain whether it is possible, practical, and what reduction in journeys would using this option have on AILs using the existing road network?
In terms of the abnormal loads, sir, the applicant has had discussions with the canal authorities in terms of looking at the movements in regards to vessel types, their ability to fit within the lock network, and their ability to move up and down the canal and Loch Ness itself. So that has been reviewed. Obviously, equipment would not be confirmed until closer to the time, so there may be some variations in component weights and dimensions, but further discussions would be ongoing with the canal operators and barge operators to detail exactly the components to be moved, their weights, and a detailed programme, and proposed within the transport assessment and the environmental impact assessment report in terms of the transport chapter is a canal management plan, and that would set out when these loads would move, how they would move, the management with other users of the canal and other traffic elements of it there, sir, and that would clarify exactly the number of loads, the weight of those loads and their dimensions.
The traffic assessment that's been submitted as part of it, does that assume that the AILs will be coming by the canal, or is it built in a worst case scenario that they'd be coming by the road network?
The assessment assumes that the very heaviest sections would come in via the canal already, because that is in line with government policy under the water preferred policy, but it does assume that a number of the abnormal plant sections would come in by road, and that section's already assumed within the assessment presented.
Okay, that's what I was just, because I was aware that some seemed to be, but not everything. It wasn't clear if everything was assumed to be coming through on the transport assessment, taking the worst case scenario being everything. But so you've already done a split of some coming by canal and some by road. which may end up coming by canal in the long run, but at the moment you made an assumption that it would arrive to site by road.
That is correct, yes.
Okay, thank you for that. Moving on to construction time scale and the use of the routes. Again, this is to the applicant. I think reference is made to, I think, month 16, chapter 16 of the AI report at paragraph 16.1.16, and that's page 2. And I think reference is made to month 16 being the peak period for deliveries to the site. So that's the busiest point for HGVs. It might be helpful for me in terms of the overall 5-year timescale that we're talking about construction. Is there an average figure, if that's the peak, you know, to get a context of what would it be like generally on a daily basis of vehicles coming to the site? A peak month will be sort of something that you'll notice, but it'll just be a month. You know, what would be the sort of average number of deliveries by HGVs over the sort of day? I accept that things will vary depending on the stage of the project you're in, but it's just to get an idea of the intensity of traffic on the road over that longer time scale.
That's not a number I have to hand, sir, because the transport assessment and the EIA chapter deal with the worst case. But if it assists, I can get you that number after the inquiry, after this hearing session. It's a large spreadsheet to try and work it out, sir. But if that's of assistance, I can send it on afterwards.
I think what I was just trying to establish was we've got the worst case scenario. Does the sort of average just drop slightly below that, or considerably sort of below that, or are there sort of other peaks where you will have that in traffic? Because seeing the one case scenario in just a month, it doesn't really give you an idea of the impact over sort of the wider time scale. So I don't know if there's anything within the submitted material that you could point me to. If there's something there you can just point me to, I'll go in and have a look at that to get a better idea of that. So as I say, I'm not looking for new evidence, but if there's something in there that you can refer to me later on, then we can move on from this point and I can come back to that.
If it is of assistance, sir, Appendix B has a construction traffic profile that's located within the transport assessment, and the reference number for that is 142. 142.
Okay, my sort of final question within this section. The applicant makes reference to significant effects on the settlement of doors, I hope I've pronounced that correctly, in the EIA findings at chapter 16, 6.1.8, page 2. And now my understanding is doors is not on the B851, and I couldn't figure out why there would be significant effects on that particular settlement if all the traffic was on the B851. So I'm not sure whether you can just enlighten me of where those conclusions came from.
Again, referring back to the transport assessment, which is 001.142, there are car and light goods vehicle movements travelling on the B862 past doors on that section. Again, the traffic impact there is 30.6% as modelled in the assessment there, but that's solely created by staff movements and LGV movements.
Sorry, what does the 30.6% sort of relate to, just so I make sure I understand where that's coming from?
Apologies, sir. That is the percentage increase in traffic in terms of total traffic flow at doors, and again that number comes from table 7 of the transport assessment, which is reference 001.142, and again it's solely related to car and LGV movements, not HGVs.
And is that the peak figure from the assessment?
That is correct, yes.
Okay, thank you. That was part of the reason why I was trying to work out where the split of traffic went, because I was trying to figure out why there would be a significant effect on doors if there's no HGVs running through that, and then where the other traffic was generated, where that was coming from. But what we're talking about here is that's cars being basically staff, workers, visitors to the site who are coming by car and light goods vehicles, resulting in the impact on doors. Is that correct?
That is correct. So it'll be coming down from Inverness, going around the southern section of doors, then on to continue on the B862. HGV movements would come from the A9, and then moving from the A9 onto the A51, and then joining the 862, and they join at that point, then proceed to site.
Okay, that's helpful. As I say, I was just trying to make sure I understood the starting point from everything else that will flow from today, where the split of traffic generated will actually be, because there's not many options, but there's at least two, and I had to make sure that it was clear where that was coming from. Okay, thank you for that.
Sir, can I ask so based on that modelling, so the HGV, as you said, are predicted or expected to come from the A9, but for the rest of the traffic, the way I read the modelling was it was assumed traffic would come the non-HGV traffic would go in different routes. Is that going to be managed or directed, or is the work traffic going to site just going to go where they go? How is that going to be managed and monitored?
Okay, I think the applicant can respond to that. We are coming on to later on about conditions in terms of construction management plans and elements that sort of look to manage traffic, but I'll allow the applicant to respond directly to that point.
Thank you, sir. All traffic, regardless of if it is light goods vehicle, heavy goods vehicle or abnormal load, will be under the control of a detailed and robust construction traffic management plan. That will set out the approved routes to site. It will also set out routes that are not approved to site. It will detail the monitoring regime that is undertaken to ensure that vehicles stay on those routes. It will have details of what will occur in terms of disciplinary action for those that do not stick to the approved routes. So it is a very robust document in ensuring that vehicle movements stay where they are. Elements of checking will include the use of GPS in terms of the HGV movements to and from site, so it can be accurately mapped where vehicles are, what routes they're taking, and if people don't adhere to it, they would be subject potentially to removal from site. And to give you an example, one wind farm project we were working on, someone decided they would try and cut a corner and use the route that wasn't approved. They were spotted and it was reported to site, and by the time the vehicle had arrived at site, that contractor had already had his fate decided and was removed and excluded from the project. So these measures would control that. The other item that we have is the staff travel plan, and that will be specifically for staff movements, the use of minibuses, vehicle sharing and other elements, and again that will require people to be on set and agreed access routes to and from site during the construction phase.
Okay, thank you for that. That does preempt one of my questions that we're going to come on later on that very point, but we'll maybe explore it in a bit more detail as we come on to it, but hopefully that's an initial sort of response to that. Okay, item 3. Looking at the transport assessment, a question for the Council. Can the Council outline the main concerns? I think it's in your hearing statement, page 7. It has with the applicant's methodology used to carry out the transport assessment. There's some sort of critique of that. And what, if any, implications it has for the conclusions reached. So yeah, I think that was section 5, page 7 of your hearing statement, I think.
Yep, good afternoon, thank you. There are probably two main aspects that we've got concerns about in the transport assessment work that's been done. The first one was a lack of any appraisal of the road network's physical capability of being able to accommodate predicted construction traffic that was forecast associated with the application. And we fully note and accept that the Institute of Environmental Management and Assessment Guidelines sets out environmental appraisal requirements, but there's no, that doesn't take account of the road asset itself being a receptor of the impact, and the road asset itself needs to be appraised in terms of its physical capability of being able to accommodate such traffic. If I can just refer to a document, which is that Institute or the EMA guidance. It's document number 018023. There's a paragraph in there, paragraph 122 on page 4, which says transport assessments report the overall transport strategy for development sites to assess, to maximise accessibility for non-car modes of transport, but also to assess the traffic impacts of proposals based on the assessment of the condition of the highway network in its peak periods. So what the document is trying to say is that transport assessments and environmental impact assessments are different tools, and both are needed when you've got a development that's trying to route an exceptional amount of traffic on what is a fragile substandard road network like the routes in the South Loch Ness area. So that was the first key concern that we had.
Let's pause there, and rather than sort of run through both of them, let's pick that one up just for the applicant, and then we'll come on to your second point. So we'd like applicants like to respond to that first point.
So the methodology that has been used here and you can see within the transport assessment, we have described the road network there. If you turn to, if you give me, I'm just going to get the section. There is a brief description of the road network on section 5.4. I mean, the methodology assessment use has been used extensively across the United Kingdom. It has been used with success and without objection to a number of projects across the Highland area. That includes a number of wind farm projects. I can read off a list if you'd like, sir, but it's easily over 15 to 20 projects.
No, that's okay. I'll take that in the evidence already read. Yeah.
Thank you. And also on similar road networks as well that are classed as the council as fragile, including Strathtirry, which there was no transport objection to. So the assessment has reviewed the road network. One thing in particular on this road network which is different is the council has a strategy of improvement and continuous improvement of the road network. It is difficult because that, and you'll see from today that there are works on that road to offer improvements to it. It is difficult at the time when you're writing the assessment there to get an idea of exactly what road measures will be in place at the time of assessment, because there are other projects which are proposing improvements, such as the wind farm projects at Flichty Bridge being replaced. There are other projects such as the Red John scheme or Loch Kemp, as it is now referred to, which is also providing contributions to road improvements, and indeed this project is suggesting contributions to the road network. So it is difficult at the time of undertaking the assessment to give an accurate picture of what the road network will be in the future at the time of the peak of road traffic occurring. So that's why within the transport assessment it has said that we would look at undertaking a detailed review of exactly what's on the ground prior to works commencing.
Okay, so in terms of the reference I think the council made to treating the road itself as a receptor, what's your understanding of that, and is that, actually, I'll just clarify the council, that's under the TA rather than the EIA?
That's correct. The EIA guidelines don't really cover the road asset as a receptor itself, so that's why we requested at the EIA scoping stage and at pre-application stage that a transport assessment was required to specifically undertake that appraisal of the existing road asset's capability to take such impacts.
Okay, so it's within the context of the TA?
Yes.
Okay. So would you like to respond to that?
So we've made an initial overview, but obviously with the road changing and improvement plans being coming in from different types of development, it's difficult to provide an accurate baseline for the future with the road evolving.
Okay, thank you for that. Just back to the council then, does the timing of that survey or that assessment, how significant is that in your view in terms of the stage and process that we're currently at, or do you consider it has to be done at the start, or can it be initially reviewed and then the detailed work undertaken sort of once you're closer to that point?
The road asset is having some changes made to it. They're not excessive, they're happening in a gradual form as finances become available to the council to undertake that work, but the road itself is not going to change drastically between now and any development like this coming forward. It's not going to change its form or character to a dramatic extent that it's going to change its capability to be able to take traffic like this at this time.
Okay, so what therefore are the implications of not doing it at this stage that I should be taking into consideration in assessing the proposed development?
I think without any assessment work being undertaken at this stage, this transport assessment that was submitted seemed to rely on this overarching statement, if I got the comment correctly, or overarching appraisal, which was these theoretical assessments, which was our second concern. We'll come on to that in a second. But they don't seem to be in any form reasonable or reflective of the road asset itself. But we'll get onto that detail if you like to later.
Okay, do you want to come back at this stage, or will we get the second point and then come back to that point?
I'll wait for the second point.
Okay. Okay, would you like to go into the second point then?
Sorry, just to add in, I think if you don't assess the road for what its current status is and its physical form at the time of carrying out the assessment, when you're submitting the application, you haven't accurately determined how it's performing in its base condition before you can consider how it's going to perform when you add in development traffic. So that is missed right at the outset.
Okay, I'd like to make your second point.
Yeah, the second point relates to that use of theoretical road capacities as a means of trying to justify the road's capability of being able to take the predicted construction traffic. They are based on a document that's been withdrawn from the Design Manual for Roads and Bridges, I think it's back to the NESA manual, that it doesn't apply to substandard fragile roads like the B851 and the B862. It is can I just refer to the transport assessment? There's a table.
Just give me the reference to the page.
Sorry. Transport assessment reference 001142 on pages 21 and 22 of that document. There's a table 8 which includes those theoretical road capacities. And those are suggesting, for example, that the B851 at Inverani has the same theoretical road capacity as the A82 trunk road, and slightly less than the A9 trunk road, one of the key roads in Scotland. I think anyone who's driven that route will suggest that that is nowhere near reasonable. So that the information of those theoretical capacities is not, in our opinion, should not be relied on, but it has been used in detail within the environmental impact assessment.
Okay, for the applicant.
Thank you, sir. Just heading back to one of the previous points, it is important to note that the road network has been used for construction traffic to permit the development of 3 large-scale wind farms already to date. So the road has accommodated construction traffic over a sustained period previously, and is proposed to be used by other projects, including the Loch Kemp potentially. Certainly it's used within their transport assessment, and it is proposed to be used for the extension of Corrigarth Wind Farm, which is also now consented. With regards to the use of the theoretical road capacity assessments, that comes from the NESA manual, which was formerly part of the design manual for roads and bridges. The assessment there is acknowledged to be entirely theoretical. It is a ready reckoner, it is nothing more. It is not relied upon to say this is exactly what that road may or may not accommodate. The advantage of using that table within the NESA assessment, and NESA was used to evaluate the economic performance of roads within Scotland, and is entirely a Scottish document that deals with road widths ranging from 4 metres all the way up to motorway standards. So it has been used, it has the ability to accommodate, so I'll let you get your pen working. So it allows the use of roads from 4 metres, similar to the fragile road network that was just described by the council, all the way through to 3-lane motorways such as the M74. So it is a tool that is of relevance, but we make no claim that it will absolutely provide an answer there. And that is why we class it as a theoretical capacity, sir, but it doesn't hang anything particularly in the assessment of it there.
So can I just add 2 points on this, really, picking up a question you asked the council as to where this might go in effect. Just to remind the council and yourself, sir, of the statement of agreed matters at 3.9, where it said the parties agree the increase in traffic and, perhaps most importantly, the proposed construction routes are not a reason for objection. And secondly, at 3.10, the parties agree that the effect of on the local road networks can be suitably mitigated if appropriate mitigation measures are put in place. Now, there's clearly dispute about appropriate mitigation measures, but we take it from that the Highland Council had there's no part of their objection that the local road network was incapable of catering for this traffic.
Okay, thank you for that. I'll give the council an opportunity to respond. I'll let the councillor respond, and then I'll bring you straight in if that's okay, just so I can follow the flow of the argument, if that's okay.
So I think it's clear the council's position that it shouldn't be a reason for objection if there's adequate mitigation to add the capacity into the road network. It's not a nothing needs to be done agreement. It's something that should be capable of being agreed and done.
Okay, I just want to make sure that I understand this sort of council's position correctly. You've got some issues in terms of the theoretical approach or the approach that's been taken that results in concerns about the impacts, but those impacts are not so significant that appropriate mitigation couldn't resolve them. Is that what you've said to me, just so I've got that accurately?
Yes, sir, as long as that appropriate mitigation is there, and that's what the dispute about is, what's the appropriate mitigation.
Okay. All right, before
Sorry, I was just going to add, the thing with when you pick the theoretical capacities, the problem with the B851 and the B862 is that the physical form and the width of the road changes multiple times along its length. So when you select a position on the road to determine what the theoretical capacity is, a few hundred metres along the road has changed in its width and its physical form and its condition. And then you go another few hundred metres and it changes again, and then it changes again. So the capacities that have been used are almost locally at that exact point, but they're implying the route has this capacity. So they're inappropriately used to give the impression that the road is better than it is.
Okay, I think I followed that. I have driven the road on multiple occasions during my site visits, so I've been back and forward through all the different narrow, wider, etc. sections, so I'm well versed on both routes. So there. Mr. Hindley, do you want to come in just now, and then I'll come back to the applicant?
Yes, just 2 points from what's been said. It's already been picked up a little bit by the council, but I'd highlight to the applicant that they were talking about the NESA guidelines as working for roads that are 4 metres wide and up to motorway width. Significant areas of the South Loch Ness Road network are narrower than 4 metres, so therefore the NESA guidelines simply don't apply. And the second point was in relation to the SOAMs relating to the roads. Stratherick and Foyers Community Council wasn't consulted at all about the preparation of the SOAMs, and we specifically disagree that the effects on the local road network can be adequately mitigated.
Okay, just picking up the point on the statement of agreed matters. At the pre-inquiry meeting, I requested if the applicant and the council could sort of advise me basically where they were in agreement. That would help me in terms of the dispute between those two parties. That does not remove the fact that other parties have made objections to it and have got concerns. So they are not null and void by the SOAM. That's just from the two sort of main parties in terms of the evidence, that it helps to focus down on where they are in dispute, but that doesn't mean that there aren't other disputes that I will be taking into consideration. So your own evidence and the evidence of Strathnairn, that's the SOAM doesn't affect that position. It's not the position where, because the council and the applicant agree on the matter, it's okay. That's not what the purpose of that. It's really just to cut down the time I've got to go looking through between those two particular parties. And we don't normally, well, normally other parties don't want to be part of that process anyway, because they want to keep their independence. So what your position is fine and it hasn't changed, and the SOAM is just between those two. Does that make sense?
Yes, thanks for that clarification.
Okay, and we'll come back to the applicant just on that point if there's anything further you wish to add.
So just returning back to Table 8 of the Transport Assessment, if you look at the B862, you can see the theoretical road capacity does change along that route. As Mr. Ross has alluded to, the survey locations reported there are tying with the traffic survey locations, but again, I'll just stress again, it is a theoretical exercise. So.
Okay, that's been helpful. Mr. Lonsden.
Yeah, hiya. Does the capacity assessments and the traffic data assessments, considering they're all theoretical, do they, and we've already discussed how much the road narrows, widens, does that theoretical data take into account the availability of the road or the capacity that the road could take for HGV, meeting HGV on that road?
In terms of vehicle movement, sir, it considers two-way flows, but it is a review to look at the link capacity element there. In terms of vehicle passing opportunities, that's dealt with more in the mitigation proposals, of which the assessment provides a number of suggested measures. So that's dealt with at that point there.
Okay, I understand the difference between the two sort of parts of the process for that. Does that help? We will be coming on to more detailed matters, so it may well, we'll may well answer, but if it's not towards the end, then feel free to ask me. Okay. We may have probably answered my next point, because we did get into the receptors element to it. Just for my benefit then, to the applicant, we've touched on the TA in terms of receptor. Can just the applicant clarify whether the EIA report addresses the road or the route as a receptor in terms of predicted significant effects?
So the EIA reviews users of the road network and residents or communities along the road rather than the road itself.
I think the point I was saying, but it includes sort of residents along the road as well as people actually on the road itself. Is that what?
Yes, sir, that is correct.
Okay, that's fine. That was just a point of clarification I was requiring. Next point should hopefully be more straightforward. It's just to assist me against the applicant. Various parties, including the community councils, have raised concerns with the use of the data survey sources. I think quoting the 2019 figures as an example, the pre-COVID figures, as a basis for assessing the effects on the road. Can you just briefly explain why these data sets have been used, and also why the locations used for updated surveys were chosen, and any issues that you see with carrying out these during the school holiday trades period? These were, I think, the three elements that were raised of concern by the community council. I can go back and pick up but the first one is just the use of the data set from 2019.
Sorry. In terms of the traffic data, if you refer to section 5.5 of the transport assessment, which is reference 001.142, it details the different sources of traffic data that were obtained. So there were bespoke automatic traffic count surveys. They rely on a series of tubes across the road to measure vehicle speed, vehicle composition and vehicle class, as well as total volume of traffic. There were other publicly available data sources that were available for the B862, and in addition we used traffic data for the A9 and A82 from government databases. The government
Can I just clarify the tubes across the road, for want of a better term? When was that survey carried out?
So they were undertaken in July, and it's those ones that I think the Community Council has expressed a concern over.
Sorry, what year?
2022.
Okay, fine. I'm just trying to clarify, because we've got 2019 as a date for certain data. So this survey work was done 2022.
Yeah.
Right.
Yeah. So in terms of the 2029 data, a large portion of that is actually on the trunk road network, so the A9 and the A82, and that's come from government sources. Transport Scotland has not objected to the use of that data, which has been subject to National Road Traffic Forecast growth assumptions from a 2029 to a 2022 base, and on the trunk roads there's not been any concern raised by the Trunk Road Authority in the use of that information there. The COVID lockdown played havoc with the ability to collect data, so unfortunately this period in time we were looking at getting available data that was clear of any lockdown implications, and obviously we have the school holidays as well. The data collected in the July of 2022 was within the school holiday period. However, the school rolls of both schools are not massive, so we didn't think that would adversely impact the data collection exercise, and indeed the Highland Council in previous projects has encouraged consultants to look at summer flows because they're slightly higher. As I understand it, the Community Council has expressed a concern that they believe the traffic numbers to be not accurate and perhaps representing a lower baseline because of the school holidays and the trade holidays, which I think they've made mention in their representations. If that has reduced the traffic numbers on that road, then the percentage impact of development traffic will actually be artificially higher because it's a percentage impact review comparing the development case to the baseline. If that baseline is lower, then the impact will be higher on that. So we recognise that at the time the data sources were affected by COVID. We had to provide some way of providing a robust assessment. We believe that the information provided to date is robust and relevant. It has been used in another application for DEL 2. It has not seemingly attracted the same level of concern for that project.
Okay, thank you for that. Does the council wish to make any comment on that particular matter?
Just to confirm that the council never challenged the location of traffic surveys, the dates when the automatic traffic counts were done, the tubes on the road, was of the first week of the school holidays in 2022, but it was prior to as well the English schools breaking up, so it probably was at the quietest period on the network because the locals have probably gone on holiday somewhere else and other people going on holiday weren't yet on holiday, so it was probably the quietest period.
And as it sort of explained by the applicant then, the implications of that would be if the English schools went off, the road use would be lower and therefore theoretically any impact would be higher. What's your view on that?
The environmental impact assessment approach would support that because it's about proportional change. The lack of assessment of the road's physical capability to take the traffic would probably be adversely impacted by taking a lower level because the impact of the road's physical capability to take traffic relies on the understanding the quantity of traffic, so you would expect it to take a worst case scenario of the busier periods of load, which will be when schools are in, people are at work and not on holiday, and business is operating.
Okay, so there's two different elements that you're talking about there. The applicant just want to pick up that second point about the condition of the road and the impact capacity. Then I will come to the Community Council. I'm just trying to close this loop in my understanding of what's been said.
So the physical condition of the road would remain constant throughout the winter, spring, summer, autumn, regardless. The physical ability of the road doesn't change during the seasons.
Can I just come back on that, if that's okay?
Yes.
It's just to say that when you're assessing the physical capability of a road asset to take load, it's on the quantum and type of vehicles that are using it. So if you're picking a base period that's lower than normal, then the number of vehicle loads hitting that pavement will be lower than it might otherwise be.
Okay, I think I'm following that. Is there any disagreement from the applicant on that?
So I'd just come back and reiterate the points. I can't stand the Community Council's position, but as far as the Council's concerned, they seem to be taking an overall capacity point, which seems to be inconsistent with the statement of agreed matters.
Okay, I think we've kind of covered that point. I'm fine that I've got where parties are on that, and I'd like to bring the Community Council in because I think they wanted to say something on this point. Yes. So I will actually say which Community Council next time. That's the question. My apologies.
Stratherick and Foyers Community Council would like to note that we did object to the identical flawed traffic methodology being used in the DEL 2 wind farm in our submission to the ECU made on the 7th of May 2024. In relation to speaking just for Stratherick and Foynes Community Council, our particular concerns in relation to the baseline data is actually in relation to the HGVs rather than the general car traffic flows. And I think, particularly as we're sat here in Wildside, just next to the B862, the proposed site entrance is 800 metres up the road. If you look at the transport assessment, that's 001.142, table 3 in section 5.7, that gives an adjusted for 2025 HGV flow of 193 HGVs per day. If you equate that to a 12-hour day, that's 16 HGVs an hour. And you don't need to be a traffic professional to know that there are not one HGV every 3 or 4 minutes going past us on the road here. So that data is simply unbelievable for anybody who lives in this particular location. And if the baseline is incorrect, so we would suggest that the baseline is artificially elevated, and that therefore means that the effects of the flows associated with the construction traffic therefore have been downgraded, downplayed, because the baseline is artificially elevated.
Okay, thank you for that. Do you have a similar point or a different point to that?
Slightly different, sir.
Okay, let's answer that one, and then I'll come back so that we've got full attention onto the point you want to make. The applicant like to comment on the Community Council's point about the existing or the forecast, the theoretical sort of volume of traffic on there at how many per?
So the 2025 baseline data suggests 193 HGVs per day.
I forgot to write down the number, that's why I was trying to remember, but I didn't want to misquote you. And the applicant?
Sir, the traffic surveys have been undertaken independently. They've not been interrupted with in that regard. They are undertaken by subcontractors who are specialists in this field. We take their information as read. 193 vehicles, HGV vehicles, isn't per 12 hours, it's per 24 hours. We've heard this claim repeated, but we've not seen anyone provide any independent data to prove or disprove that number.
Okay, I'll take both parties' position to note on that. We'll move on to Strathnairn Community Council.
We would just like to make the point that we agree with everything that Stratherick and Foynes Community Council has just stated, but in addition, it is incorrect to make the assumption that there are just 2 primary schools served by the B851 and B862. In the last census, the population of Strathnairn alone was 2,800, and that is likely to have increased. The B851 and B862 not only serve the 2 local primary schools, they also are routes for children to go to school in 6 primaries in the near vicinity within Inverness and 3 secondary schools.
Sorry, I missed that. How many primary schools?
6 primary schools.
6.
And 3 secondary schools, all of which are detailed in our Appendix B that has been supplied to the inquiry.
Okay, thank you for that. I did remember sort of reading that. I just couldn't remember the numbers. And these are people who are not using the local primary schools, but are going to Inverness for secondary school. I'm assuming everybody's going from the area into Inverness for secondary schooling, but there's additional primary schools in Inverness that serve the area rather than just the 2 that are being referred to. Is that your point?
That's correct, and they are oversubscribed. Hence the reason for parents to have to travel.
So, just so I'm clear, that's 6 in Inverness, or 6 in total, 2 here and 4 in Inverness?
6 in total.
6 in total.
And because people will travel not just one direction for school, they're going to the local school in their catchment area. It's much greater than just the 2 in the community. Some of the schools are schools like the Galaxy School, which people like to attend, and the academies are at capacity 1,200, and the children travel from these communities to that academy as well. So they will travel in one direction, Inverness, or depending on the catchment, they may be in the other direction, down to Fort Augustus. So it's not just the two schools that are on this road.
Okay, I think I've got that now. I did drive the both routes at school pickup time. I did pass the single decker coach that was obviously picking school pupils up, and then obviously saw pupils waiting at the ends of drives, etc. The primary schools seem to be less. I'm assuming they're either taken directly by taxi to the local primary schools or a bus. I saw one bus and I saw 2 or 3 taxis, but obviously with that younger age group, they weren't hanging about to the same extent at the end of roads, etc. So I'm assuming that the secondary school routes are to Inverness primarily, and the primary schools, are they all to Inverness, or is there a primary school to Fort Augustus?
Also to Alduri, down at Doors, so they go in various directions, just it's relative to distance, and also whether they're going to a specialist education as well. And you know, there's another one we haven't included, which is Drummond Primary, which picks up all special needs for Inverness, so that's not in, so there's kids go from the communities down there too.
Okay, I think I kind of understand the point that there's, it's not just 2 primary schools, because they're physically located within the area. The road network itself is serving a wider network. Okay, that's fine.
I'll clarify the buses. So there's 2 secondary school buses that go from the B851 down to Inverness, and then there's 1 primary school bus that goes along the B851 from the Dunmore-Glass Corner, if you know that area, to the far primary school, and then before that it comes from from the Inverness side down onto the B851 to the school that way. So the school bus goes both ways along the B851, and then there's 2 secondary school buses. That's just the B851. Mark could maybe fill you in once they get onto your section of road, because there's going to be more buses going to your schools and going to the Inverness secondary schools from there.
There's just a single bus from Whitebridge which goes through Far and then into Inverness.
Okay, that's been very helpful, cause just to get the sort of picture of what's actually happening. So I'd had a reasonable handle on that, but that's been helpful just to say where people are actually going and that. Okay, that's good. Right, I think we've probably actually covered the next item, which was assessment of road capacity, oblique road conditions survey. I think we've touched on that, the council's evidence and the response to that, and yes, just sort of one minor point, just for clarity for everybody else. There's obviously a condition survey in terms of capacity, but there's also during the process a condition in terms of wear and tear survey that's often taken out prior to the development. Just to clarify, the council, these are 2 separate things.
Yes, the wear and tear agreement is really a way of trying to manage the process of damage that will occur from such a large amount of traffic travelling on a fragile substandard road network. The assessment of the road's ability to be able to take the predicted construction traffic from a physical and safety perspective is a different matter altogether.
Okay, I just wanted to clarify that point, because sometimes the 2 have been mentioned, that they are 2 different things from the council's point of view, and I'm assuming the applicants of the same position with that. I guess. Okay, thank you for that point of clarification. Okay, looking at cumulative effects of construction traffic from other developments, the community councils, and I think in Strath Eric and Foyer's hearing statement, para 1.2 on e-page 2, concerns have been raised that cumulative effects with other proposed developments have not been properly considered, and specifically the works related to the associated grid connection at Foyers. Can the applicant just outline briefly the approach taken to the consideration of cumulative effects and how these are to be mitigated or managed?
Thank you, sir. Cumulative effects have been accounted for of projects at the time of submission, and that's detailed in section 5.8 of the Transport Assessment, reference 001.142, and paragraph 6.10.8 of the Transport and Access chapter, reference 001.022. Those included the following schemes: the Blairy Wind Farm extension, Aberarder Wind Farm, Dell Wind Farm, Red John Hydro Scheme, which is now known as Loch Kemp, Corriglass Pump Storage Hydro Scheme, and you know, the detail of those measures are included in that section. So they include the traffic movements at that time. Now, it is difficult because construction projects have longer periods, and within that there are peaks within that project. So to provide a fair assessment, the peak periods from each of those schemes has been included into the baseline, and then an assessment undertaken with that peak traffic held within it. I think it is important to note, however, sir, that Aberarder Wind Farm is more substantially complete now, so the traffic flows with that can essentially drop out, and there, as we've heard earlier today, there may be changes to the construction access routing for the Red John Hydro Scheme. So the proposed construction traffic management plan, which would generally be secured by planning condition, would allow the applicant to work with other developers to implement joint or complementary traffic management measures and to accommodate any changes, for example, other schemes coming in during the same construction period, or to cater for example, Aberarder Wind Farm falling out of that assessment. So.
Okay, thank you for that. Would the council just like to comment on how they approach sort of the management of these, assessing the management of these different projects on the road network, just to get your side of that equation?
Yes, a simple answer is it's very difficult. The construction projects happen when they happen, when funding becomes available and they're able to mobilise and get their contractors on board. The construction traffic management plans can help to try and manage the overlap of construction activity. That's dependent on there being a road network that can physically accommodate them. We don't believe there is at the minute in the South Loch Ness area. That network is not capable of dealing with such large projects overlapping with each other, which is why, as a council, we seek physical mitigation to that South Loch Ness road network alongside traffic management measures, because the network itself is not physically able to. In terms of the ability to coordinate, it really relies on developers needing to work with each other. If you're going to effectively try and manage interactions from those projects, it needs those project organisers and deliverers to work together to be able to manage their work programmes and the associated traffic that will come with that. The council has no influence over that. They are public roads and they are publicly available. We try and encourage that and seek that through construction traffic management plans, but the actual practical application of that is entirely reliant on the developers themselves.
Okay, in terms of, I'll come to you in a minute, looking at that, am I right in saying that in terms of the sort of big movements of the abnormal and the visible loads, there's much more control over when they will take place in terms of the management of those, because that coordinates the police and other parties within that. And just say just a bit about that, just so that because I think the main point is the general HGV traffic is the bit that's more difficult to control, I think, than the abnormal and visible loads.
That's correct. Abnormal loads go through a separate application process, and that is where the coordination actually happens to make sure there's no conflicts, because the last thing you want to come across is another abnormal load coming down the other direction. So they are controlled and managed. It's the general traffic which is more difficult to try, and it's like herding cats in some respect. But it is more difficult to do, and it is generally that traffic, the general traffic, the large goods vehicle traffic, that does tend to generate the damage to the road asset itself.
I think when there is cumulative impact, it then becomes difficult to determine who's responsible for any damage and deterioration. And that's one of the reasons we'll obviously come on to that about the Section 96, but you need mechanisms within all the Section 96 when there is overlap to try and cater for that. And they are notoriously difficult to determine who is responsible.
Okay, thank you. I think that's just helpful, just to split the abnormal and invisible loads process as a separate one from that. But what we're talking about here is the majority being the HGVs that are using it in terms of the coordination between the different developments. Just one point that I did make, I'll come back to the Community Council. The Stratheric sort of comment included reference to the grid connection at Foyers. Obviously we've got some supplementary environmental information on that submitted. In terms of the traffic sort of impact of that cumulative effect, was that originally considered in the TA, or has any additional work been done on that?
Sorry, in terms of the grid connection elements, at the time of the application and the submission, that wasn't included. However, in the supplemental information, I believe chapter 12, chapter 12 provides further information with regards to that, sir.
And that's the cumulative effects from the route assessment and that work being, if that work is carried out in terms of once the alignment and process goes through for the grid connection to Foyers. I think I remember reading the information in the ratio decision for the written submissions. Is that correct?
Yeah, so that's correct. It's in the environmental appraisal that was submitted. It's section 12.3 that considers the potential cumulative effects of the grid connection along with the pumped storage scheme.
Okay, so it's been covered off in that as evidence.
Yeah, that's correct, yeah.
Okay, that's fine. I'll come back to Stratheric, but I know Strathnairn are trying to sort of come in, so I'll take you next.
Sorry, I have a couple of points, and I think they're probably best dropped into cumulative impacts, but your selection of route, when you charted the first of the wind farms that had come through the B851, there actually was no cumulative impact on these. They were, for the large part, first generation wind farms. So the height of structures were very small. There were abnormal AILs were generally quite manageable, and as a rule, these wind farms were built in isolation, i.e. not with multiple projects happening at the same time. Now you're in a completely different moment of time where we're looking at next generation wind farms trying to come on the same roads. We know at Strathnairn we've been approached by several construction projects that you haven't mentioned, obviously because they've come in after you've put your documentation together, and they're saying the road is not adequate for transporting their materials and loads. So they've approached our community council. I believe they've also approached Stratheric Community Council about taking land parcels in order to improve roads. So that's what you're competing with in terms of traffic. You've also, the Highland Council have spoken about cumulative impacts in terms of damage and deterioration to roads, But there's also cumulative impacts in terms of if multiple contractors are working at the same time and someone defaults on agreed transportation routes or times, or they decide to transport out of hours, how do you identify who has done it? The community are seeing an increase of vehicles without being able to attribute it, aside from damage to the road, actually being able to attribute who is defaulting on conditions, speeding or coming out of hours or extending the day. You know, you have a construction program that's 7 in the morning till 7 at night, and that means you're going to be transporting in the middle of the night through these communities or in the early hours late in the day.
Okay, would the applicant like to make any response to the points on sort of just the increased, I think the points we made is there's an increase in cumulative effect perhaps now with more projects going on at the same time, and just how do you distinguish between who's done what, I think is the point.
Thank you, sir. In terms of cumulative elements, within the construction traffic management plan, we have proposed that there's a number of different measures there that would identify vehicle movements, for example, the use of GPS, tracking of HGVs, but also on a less technological, the other end of the scale, would be the provision of unique markings on the HGV vehicles, which would potentially have a large K and a number to denote them being associated with the Loch Kemp project. Obviously, if there are other projects happening at the same time, then the applicant has said they will work with other developers and with a construction traffic management group as well, which would involve the community councils and elected members and other important stakeholders in that, and work together to find ways that vehicles can be identified per project. Mr. Ross is quite correct. Sometimes it is very difficult to determine which vehicle's done what to a road, but there are instances, for example, that we've undertaken in other parts of the UK where you can have a mechanism to perhaps review that. And one area that has been used successfully where there's been a number of projects is to increase the condition review process along the road network and compare that against vehicle movements that have been moving during that week, and if there was damage noted, then it's slightly easier to refine that down on that. There are other mechanisms that have been used as well, sir. We would certainly like to bring that best practice experience into producing a robust construction traffic management plan that would be acceptable to the council and as far as possible to the local community as well.
Okay, thank you for that. Mr. Lumsden?
Just still on the cumulative impact. So you mentioned Aberarder. So we live and breathe the Aberarder construction project. We kind of presumed or expected the HGV traffic to be complete, but they were expecting to use a lot of materials on site for a lot of their foundations. It was found to not be of the right quality of rock, so they had to ship more HGVs through our roads for 2 months solid. That's what we experienced, and it wasn't what was expected to be in the application. So for your cumulative impact, where we've already spoken about multiple projects that are coming, is there margin, or is it just taking the best case that's been put into each application?
Thank you, sir. In terms of the cumulative assessment, we've taken a robust view, assuming that the peaks of all these different projects perfectly align with our peak. Now that in itself is not going to happen. Well, for example, Aberarder has been and gone. But we have to take a robust case and say that the peak of our construction will coincide with the peak of all these other projects and provide a much higher level of traffic than could be reasonably expected to occur.
Okay, I think I've got a reasonable understanding of the concerns. Obviously, the issues of trying to manage that. They're not without the challenges, I think it's said by the council. So I think I've got a general agreement. Mr Henley, do you want to come back just on one final point on that matter before we move on?
Please. We believe that the applicant's information in relation to Aberada is out of date. The last community liaison group 3 weeks ago, the indication was that Aberada is delayed and they're now not expecting to complete until the end of next year. So rather than being already complete, it's actually delayed. Looking at chapter 16 of the traffic access and transport section, so this is section 16.10.11, it specifically doesn't consider Corrigarth 2 wind farm, which has been delayed, and that's been delayed, so the construction is now not expected to start until late 26 or early 27. It's specifically not mentioned. Mr Reid, you mentioned the associated works and the grid connection. Within the grid connection, there are two different aspects. There is the cable itself, and there is also the expansion of the substation at Foyers. And whilst the additional information that the applicant submitted in the light of the Racial Farms ruling makes some assessment in relation to the cable, it makes no reference to any construction traffic relating to the expansion of the Foyers substation. And then the final point that we would make in relation to the cumulative effects, section 16.10.14 says the combined traffic flows indicate a large increase in traffic flows on the B851, B852 and B862. We, I think, all would agree with that. But it then goes on to say there, however, would be more than sufficient spare road capacity to accommodate this. And we've already established that the applicant hasn't actually made an assessment of the road capacity. They've only got a theoretical road capacity. So it seems to be no way that that particular statement can be true.
Okay, thank you for that. Does the applicant want to come back on any of those points before we move on?
Just to state so that Corrigarth 2 was determined after the documents had been submitted.
Okay, I think I've got the...
Just one reference, just the cumulative impact is a matter dealt with in the officer's report at 7.207 and up to the conclusion at 7.211, so that's CD 4.7. Electronic page 64.
Okay, that's the council's sort of report of handling?
Yes.
Okay. Would the council just...
Well, what I was going to say was that we've already established that the council, from the Roads Authority's perspective, we were concerned about how they arrived at the impact on the roads, because we don't think there was any proper assessment of what the B851 and the B862 actually are and how they are coping. And therefore, if we have concerns about how you would determine how your impact will be for your development, and we don't agree with the outcomes of that, it follows that we would have the same concerns when you try to apply the same thing for cumulative, because you haven't accurately assessed how the road is performing.
Can you just refer me to where that is set out in your evidence? Just so I can make a proper reference to it. If you can't say right away, then you can let me know as we move on.
I think it goes back to on the paragraph 16.10.14 that was mentioned in the EIA on page 40. But I think that relates to just our hearing statement.
So is that set out in your hearing statement or the rebuttal statement?
It is. Our position.
Just on a word check of the council's hearing statements, the word cumulative doesn't appear.
I didn't recall remembering it being mentioned in the... That's why I'm just asking, because my memory is okay, but it's not that good that I'll remember every single thing. But I just wanted to make sure that you're pointing me in the direction or off, if you've said that, or if this is new evidence, then that's different.
No, I was just trying to make the point that if we're not content with how they've applied it for their development, it follows that it can't be correct for the cumulative impact. Because if you can't assess the impact correctly for your development, I don't see how you can then accurately assess it for the cumulative.
Okay. Okay, I hear what you're saying just now, but in terms of the submissions, there's nothing formally with regards to cumulative concerns in the hearing statement or the rebuttal statement.
I'll have to double check. I can't.
Okay, if you can
recall.
just double check and just update me in due course, that'd be fine. I just want to make sure if there is, I'm not saying there isn't, and you can point me to something that there actually is. Okay, thank you for that. Right, moving on. One final question in this section to do with sensitive receptors, and this to the applicant. Concerns have been raised by various parties about the effects on sensitive road receptors. Can the applicant just outline how it sought to identify the sensitive receptors in the EIA report process and how it's established the significance of effect from construction traffic on these? I think you've already touched on that beforehand, so I think you've identified in terms of the road users, etc. But just how does that then work through in terms of the EIA process, just so that we can clear that whether that's been worked through in the submissions.
Thank you, sir. The relevant document here would be the chapter, which is reference 01.022. And if I just take you to, my apologies, it's quite a long document. So we have looked at, so in terms of identifying receptors, they generally fall into two groups. There's the users of the road. That could be cars, HGV users, pedestrians, non-motorised users, different types there. We also consider residents living alongside the link as well, and they are used. If you within the chapter refer to table 16.7, that identifies the receptors, their sensitivity, and the justification of how that sensitivity has been arrived at, and we have followed the Institute of Environmental Management and Assessment guidelines, which is the 1993 guidelines. Those guidelines were updated in 2023, just after this had been submitted, but obviously it had been scoped on the basis of the older regulations, which I think the Council in its scoping opinion and report notes and accepts. Once you've got the receptor sensitivity, you then compare the traffic impact. There's a variety of different types of effect that are reviewed. They are based upon the percentage impact, and then there is an assessment undertaken using a matrix to determine in terms of are these sensitive receptors, and what is the level of effect that is provided. In terms of the construction effects, detailed assessments after screening were undertaken on the B862 for users of the road, same with the B851. We also undertook detailed assessment in Inverarney in terms of the effects on residents, Erigi, Foyers and Gorthlick, including the primary school. Those then considered potential effects that include severance, driver delay, pedestrian amenity, fear and intimidation, accidents and safety. They are then ranked in a table, which is table 16.10, which provides the process.
Sorry, can you just give me that table number again? I just missed
my
it.
apologies. 16.10 of the chapter, which I think is 1.022. You are allowed some latitude in professional judgment in that assessment, but that provides what the effects are of development traffic on it, and it then informs the need for mitigation in terms of the EIA process. If something is considered significant, then mitigation is suggested, and then at the end of the chapter, and forgive me, it's I'm going to get mouse finger by the end of today. there is a table there, which is table 16.14, which is a summary of any residual effects after mitigation measures have been included. Yeah, I hope that gives a quick kind of counter through.
That's exactly what I was wondering. I just want to make sure that that's the process had gone through in terms of how you identified them, then how you assessed them, and then where you came through to the conclusion. As I say, some concerns have been raised. I don't know whether the council has any comments on that part of the EIA process.
The council has not challenged the work done in identifying sensitive receptors or the work done in appraising those.
So you're happy enough with the approach that's been
from an
taken?
Environmental impact perspective, yes.
Yeah. And community councils, Mr. Lonsdon?
Yeah, just I would say the most sensitive receptor out of everything that's been listed is the children stood at the side of the road waiting for the school bus. There's no pavement. They're standing on a grass verge, sometimes on narrow bits of road. I don't remember seeing that specifically mentioned in the report. I could be wrong. But yeah, it's just to raise that there is, I think you were talking earlier on about the secondary school children waiting at the side of the verge for the bus, but there's my own daughter's 6, they stand at the side of the grass verge waiting for the bus. So if they can be included and discussed as sensitive receptors, because they're the most sensitive receptor.
Okay, I'll just first of all clarify whether sort of the school bus sort of collection, I'm trying to think of the best way to describe that. So basically school pick-up time, where in terms of being sensitive receptors during that period, were taken into consideration.
In terms of the receptor review, sir, it reviews settlement areas, so in Doris, it reviewed sensitive receptors in the kind of settlement areas rather than individual groups in that regard. So residents would include people waiting for school bus services.
So in terms of settlements,
sorry, my apologies as well. It also, under the rules and regulations, includes, if you forgive me, let me just find that reference. It does include that there are receptors for residents living in settlements along the route as well. I'm just trying to find the table reference there.
When you say are you talking that would fall under, say, the pedestrian sort of receptors?
It would fall within the kind of residential receptors.
Okay.
Sorry, the table is 16.7. The reviews residents living along the B851, along the 862, and then there is specific mention for Foyers residents, for example, and that also includes the school within that table, 16.7. So.
Yeah, I think this is where the concern is. There's the pupils at the school or within sort of the larger settlements, but I think the issue that seems to be risen is that out with the main settlements there are smaller sort of groupings of properties along the route, and that's what I noticed when I was driving, that you might get 3 or 4 houses and there'd be 3 or 4 children waiting at the end of the road. And sort of scattered through the process. Now, that might be not the easiest thing to assess, but in terms of settlement size, is there a size given, or is there anything that, where you looked at sort of residents within settlements, is there a definition of what a settlement would include and wouldn't? I know this is a really quite specific point, and you might not be able to answer that off the top of your head, but if you could check to see if there's any breakdown sort of beyond, say, the main, what you would determine maybe the main villages, that might be helpful just to know whether that has been, and whether you think that's something that needed to be covered within the EIA process.
There's, in terms of the receptors, in terms of residents, it does include villages and settlements, but it also includes areas where you would have perhaps individual houses along, and they're described, they're grouped as residents along a road in that table.
So in the table itself, there's just, if you can just kind of point us in the direction of where that has been taken into consideration, just so that I can go and have a look at that afterwards.
Sorry, that's in table 16.7, and 16.7. Yeah. What I would say though, sir, if there are particular areas where there is the pickup for children at school periods, we can use the CTMP, the Construction Traffic Management Plan, to highlight specific areas where construction traffic can slow right down. We can add in other measures to accommodate more vulnerable road users, such as that in that mitigation tool there, and hopefully that will give some reassurance to the local community.
Is that something that's been done in any previous work that you're aware of, in terms of using the construction mitigation plan to address any concerns with sort of school pickup, drop-off time?
Yes, we've had other projects, mainly wind farm projects, where in remote areas. We've got one in Wales just now, where we have insisted on a 10-mile-an-hour speed limit over certain sensitive areas. This one's outside a combined primary and nursery school, and we've looked at ways that traffic can be managed effectively past more sensitive locations. So that there has been precedence for that, although not admittedly on projects on this road, to my knowledge.
Okay, thank you for that. We'll go to Strathnairn first, and then we'll come back to...
It's just a point on your point there, because in a nutshell, why they're concerned is that if you enter a zone settlement, like Far, for example, you will see speed reduction to 40 or 30 or 20. But along the 60-mile-an-hour road, there are straths that feed in and they meet a T-junction to, for instance, the B851. And it's at 60 that the kids are standing at the side of the road waiting for a collection. So if there isn't an adequate traffic management plan that recognises this, that it's not just about the settlements or where you can see the houses, these kids are so vulnerable on these community roads.
Okay, I think that's the point that I was sort of trying to make, that just establish that you've got the more random locations rather than organised, where you've got school, reduced speed, 20-mile speed limits, etc., etc. Okay, Mr.
I think you've grasped the point I was going to make, so I don't need to make it again.
Okay, thank you very much for that. Changing gear slightly. I'd just like to, I know that there's been a lot of submissions with regards to the South Loch Ness improvement strategy. I'm sure parties are probably tired sort of commenting on it, but I just want to have a quick run through it to make sure I've understood what the position is and there's nothing left sort of doubt. So I don't need a lot of background, just probably more direct sort of answers to the questions. But if you feel you need to add a bit more, then please do so. So firstly, to the Council, looking at the purpose and status of the document, as I said, there's been a considerable amount of evidence submitted in relation to this particular document. So just very briefly, just for the benefit of everybody else, can the Council just outline what the purpose of drafting the document was in the first place? Secondly, when it was published, and thirdly, what it considers to be its official status as a Council document. So that's just three elements to it, just to kind of get those out there at the outset so we know where we are with that.
Yeah, so what happened was there was 3 renewable energy developments that occurred in South Loch Ness, 2 wind farms and the Glendale Hydro Scheme. And having dealt with them, the council realised, or the local roads authority, the council realised that the roads needed significant upgrading in order to cater for them and for the anticipated traffic. And understanding that the likelihood was we were going to see more renewable energy and large-scale developments in South Loch Ness, it was felt, well, it was myself that did it, I felt that we needed a more sort of strategic framework to deal with that, because we've got a 30-mile route from the B851 where it connects to the A9 down to the B862 connecting with the A82 in Fort Augustus, and that was the direct route that was mostly impacted on to start with. So in November 2011 we met with elected members in the ward area and with the community councils to discuss what we were planning to do, which was essentially, there was a strategy statement at that time saying that we would twin track widen the roads, we would identify the villages and put in gateway features, and we just had a plan with known works, and that was the start of the strategy. And then the following year in 2012, that was taken forward to the full council, asking for it to be given capital programme investment, and it granted 3 years worth of that. And in 2014 we produced the document that is submitted, and that it's continued every year to receive capital programme funding in order to help deliver that. And the document basically is a framework setting out what the aims of the types of improvements and upgrades that are required for that, and that's to try and provide a coordinated and consistent approach to how we deliver those improvements and upgrades, whether they come from road mitigation secured through planning developments or whether it's our own capital infrastructure investment.
Okay, that's fine. I think I've grasped the reason why you carried out the document and when it was published. In terms of its official status, there's been a fair bit sort of bouncing back and forward. In terms of, it's not, and as far as I understand it, it's not an adopted planning document in any way, and I'm not aware that it's been officially adopted at committee or approved. It seems to be part of a strategy to inform capital funding, from what you said. So, in terms of its status, did it go to committee for committee approval on its own, or has it been wrapped up in the capital funding? In a sense, is it an internal, almost an internal document that's been published to guide the funding element to it, or is it a published strategy document? How the council? It's not a subtle difference, but there's a difference there for its status.
Yeah, I think the document itself didn't go to committee for kind of formal approval. The strategy was just that framework which backed up what we were trying to do, and that's what was put to the full council under the capital programme as part of its overall bid for funding, and it received that, and it's continued to receive it. And the document is kind of available. You know, that's why we ask for early engagement so that we can discuss that. And the key thing was that when we looked at it, we split the routes into discrete schemes, and we numbered that, and so that, you know, each village, for example, would have its own scheme, and that was a way for us to identify how we would direct whatever funding we had, and we were able to then identify what priority schemes, because there's different priorities as you go down the road.
Okay, I think I've got that. We're talking about a document it's a non-statutory document that is primarily internal sort of guidance for the council, but has been published. Yes. Not these documents aren't always published, but in this occasion, this one's been published. Is that a fair representation sort of the status of the document?
Yes.
Okay. Does the applicant wish to make any comment on that briefly?
Briefly, first of all, in terms of the purpose of the document, the emphasis given in the answer by the council just now is on the impact of the wind farms, whereas if you look in the introduction to the document itself, whilst it, to be fair, it does mention the wind farms, but the principal goal is to provide a effective way to cater for modern day traffic, improve road safety and future-proof the road as a local asset. Improvements will provide a much improved alternative route A82 for tourist traffic, better access for communities. So it would be wrong to suggest that it's simply due to 3 particular schemes. And that is emphasised in the report to committee, indeed in this case, which is document 407 at paragraph 7.193. In terms of its status, it's a draft document. It has no planning status. I accept it's therefore you've read, but in terms of the reference to splitting the road down into routes and any funding mechanism, as far as I can see in the documents before inquiry, neither of those are in there.
Okay, I'll come on to that point in a subsequent question. I think I'm not necessarily saying that it's. I don't take it as a draft document. I just take it as it's a document that hasn't had council approval in that sense. So it's an internal council document that's being used that you're not actually going to redo in order to make it sort of the formal sort of document, and even internal use. So it's just the use of the word draft can be a slightly. I would say it's not approved, and it has no council status in that approved sense that a committee have approved it.
Yeah, that's the sense I was meaning to use it. Is it's not gone on into redrafting since 2014, and as far as I'm aware, there's no proposal to redraft it as such.
Okay, I think we're agreed on that.
Well, yeah, it's certainly not draft, because that gives the impression that it's still getting worked out. The intention was in 2014, the intention was to produce sort of a revised document that just expanded on the lessons learned through the various projects. We would start to develop our thinking on how we would deliver a village improvement scheme, for example. And the minute when you do a first scheme, you start learning what's working and what would work better.
Okay, I think I'm going to come on to that.
Okay.
So
yeah.
I'll save you sort of saying it twice. So my next point is looking at what the role of the document has been in considering proposed developments. So such as what we have here today. So just can the council outline what the role of the document has been and how it has been applied or used when considering major development proposals that would generate significant levels of traffic during the construction phase. So it's just how has it been used since you've put it into practice in 2014?
It started in 2011, and then this document was in 2014, just to give a bit more understanding to it.
In terms of the document being an identifiable document, 2014. So just how has it been used as a tool or as a reference point?
Yeah. So it sets out the aims of the strategy and the types of within the aims how we want to deliver that, the sort of standards that we're trying to achieve. And when it's clear that a development has significant traffic generating and we determine that there's going to be adverse transport impacts arising from that, we would then use the strategy to say where we think road mitigation should be directed. Now, you're right, the strategy doesn't have the schemes, the discrete schemes from along its length listed in there. That could be something that we could incorporate if we revise the document. There's no reason why we can't do that. But what it's doing is guiding where we would put road mitigation to. So you're not really contributing to the strategy, you're contributing to the delivering road mitigation to the road network where it most needs it. And that helps us establish the discrete schemes is a key thing to establish where we're going to locate works. Because because of the changing nature of the road, we need to be able to split up a 30-mile, 50-kilometre route into discrete schemes so that we can clearly and sensibly identify where we want to direct funding.
So just to make sure I've got my understanding correct, the strategy itself has identified areas where there are improvements that are likely to be required, given the existing condition of the road. So there'll be particular sections that you'll have considered are below standard or in need of improvement, and the strategy has kind of identified where there's work, or where in settlements there's the ambition to traffic calm and reduce, and that's stuff that was all work that was done in order to produce sort of the strategy. Is that correct?
Yes, that's right. What we have is we've given a scheme number, a scheme name, what the scheme type is, whether it's a twin track widening and realignment scheme, whether it's a bridge replacement scheme, whether it's a village improvement scheme, and then what the length of that is. And then we sort of try retrospectively to measure how much we've delivered on the carriageway and the path, because there's 4 aims in the strategy, and there's key different things happening in each part of the network. So one of the issues is that we want to try and get a consistent width and physical form of the road, and we want drivers, so that each of the village schemes, when it's built out, the drivers know what to expect. But one of the problems with the road is that the road environment in the open road section is very similar to within the village, and you may have passed a 30-mile-an-hour sign, but the road environment feels the same, albeit you might have sort of roadside development. And we need to clearly set that out so we know where we're directing it to, and that helps us then liaise with and engage with the communities on where, because they have concerns on various aspects of the roads. So there's a lot of liaison and feedback between us and the community councils.
Okay, so taking it to the next point, looking at identified improvements from this development or development. From my understanding, what process does the council undertake in seeking to identify the effects of a development? Because each development may have different effects on different sections of the road, or how they relate to a road through a village. So you've got these schemes you've already identified. How are these then, how are the impacts that you've established through the traffic assessment then applied to the schemes? Because there might be a section of road, say, that's not within any identified scheme because it wasn't at the time a problem, but because of the traffic. So it's just, I'm trying to understand, you've got this document here, you've got a proposed development here. How do they, if they do indeed, interact with each other?
So by establishing all the schemes, we have the whole length of the road split up into schemes, and you can imagine that each of the villages, until they're built out with their village improvement scheme, we would determine that the village setting, so Inverarney, Farr, Croaky and the B851, they would be priority schemes. This is where we've got the concentration of houses, we've got community facilities such as a village hall, the school, play park, amenity facilities, and people want to access them. So then there is the open road sections in between the villages, and some of them will perform better than others, and some will have more significant issues with the way the existing road is. So we identified what we felt was priority schemes along each of the routes, and we considered that the best outcome and the best benefit was to direct road mitigation to the priority schemes, because that's where we think that the transport impacts will be felt the most, and the adverse impacts.
Just on that point there, is how do you, in reaching that conclusion, how do you then apportion it to a particular development in a particular location that has particular characteristics of the traffic sort of generated? That's what I'm just trying to get your process of. So, because what you've got is more as a document shows where you want to improve the road network, and those schemes, that's clear. I think that's the council's intention, ambition to do that. It's a different thing to look at the traffic impacts of a development on a road, and then obviously that will show that depending on the vehicles, the frequency, there'll be points where the road is not adequate or needs improved. It's how do you then sort of align those sort of 2 points? Because otherwise you could take the view, and this is a hypothetical thing, of taking money in just to do the improvements identified in the strategy. rather than address the impacts from the development. So that's the bit I'm trying to understand what the relationship is and to what extent that relationship happens, because I think that's the bit that I'm just trying to get some clarity on the council's approach.
So I think just to set the scene on that, on the priority schemes, we select the priority schemes, and that's based on a number of factors. And like you're saying, where maybe the road is the most inadequate and where the impacts are going to be felt the most. So the villages, the carriageway width condition, the extent to which they meet the minimum standards for the B-class route standard, whether they can safely and suitably cater for two-way traffic, the type of conflicts that exists, the road safety considerations, and what we then do is we also have a bit of community engagement and feedback from that, because we want to find out where the local residents have their highest concerns on the network, and they may not coincide with ours, so we want to at least understand that so we can engage with them on that. And then we've never put any development road mitigation on any part of the network that they haven't impacted on. So what we've done is there's a length of the road that they utilise, and it's only on that length that they would direct that to. We would identify what the priority schemes, because that's what we think is the highest need for the infrastructure investment. And then we would try and work with the developer to find out, for the ease of delivery, where's best suited. Now it may be that the developer, if they are with an estate and there is land needed that estate has, that might make delivery easier.
Okay.
So we try to.
I'm just going to pause there, if that's okay.
Yep.
The point I'm trying to get to, I think you just touched on it briefly there, was I think you said that where the greatest impacts are identified in the traffic assessment, you would take those, and then it's those ones that you'd be looking to pursue, some of which may fall within some of the schemes, but there may be occasion where there might be out with some of the identified schemes, given the schemes were identified back in 2011-2014. So you possibly, I'm not saying exactly, but possibly you could have a stretch of road that when you looked at it originally, you thought that's okay, it doesn't need a scheme, but now the impacts from the traffic assessment accesses that does require that element, and that's a possibility sort of approach, because I'm just trying to make sure that the impacts from the proposed development itself are the ones that are then sort of feeding in and just in a sense aligning with what the schemes are identified. I think that I'm going to go on because I've got a few sort of more points just on this, just to sort of clarify things for myself. So again, sorry to the council.
So just perhaps I could ask. My apologies. So perhaps I could just ask before you go on, just for whether the council can identify where these, in any document before the inquiry, where these schemes are identified, where the priority factors are set out that have just been spoken to, because we're not aware of that.
No, I wasn't either. That's why I was trying to work out the basis of how you align the schemes together. But if the council want to just answer that point before I move on.
Yeah, that's why we ask for the early engagement and the discussion, because we have the list of the schemes. The schemes, some of these have been shown on past plans that we have issued, which I've got one of them here, but I know it wasn't submitted. So the schemes are there. Some of them, as you say, that would be an existing twin track section, and therefore it doesn't require any investment, doesn't require any improvement. And we would look at where the development is impacting and determine which schemes are in most need of the investment to deal with that development's traffic, if that makes sense.
Okay, right. I think we're starting to go round a wee bit in circles here, so I'm going to move on. But if there's a relevant point to this, then, and you can get me out of this circle, then fine.
Right. So what I'm going to say is, you sound like you are saying disregard the document because it's not published and it's not adopted, in which case you have to accept that the B851 is principally single track road with a little bit of twin tracking. It's as exists, and the same goes for the B862. Or they're asking you to adopt a document and to make changes so that any community is not seeing these changes come through after all this construction work happens, after the construction phase, i.e. living with the pain and not experiencing the gain. The second thing is on the A9, there's A9 improvements, you'll all know. They come after the exit of, so from Inverness travelling Aviemore direction, the A9 improvements come after the B851 exit. There's a section of that that now has twin tracking. It goes into the quarries. So assume that there is generally added construction in there, which then can go back to the A9 to then go down to the next wind farms and sites that are happening off to Matton. They all have safe exits off the A9. They have underpasses. That junction doesn't have. It's more vulnerable for residents. Although it has twin tracking, it has a terrible exit now for residents coming in and out of Strathnairn. And also, if you're adding to the construction on that road, you'll be meeting traffic from many directions.
Okay. What I'd like to do is move on, because I think that might help to get to the point where I'm trying to get to. So.
Can I just have that qualified?
Okay.
I think when we were engaging with the applicant, they asked for the priority schemes, and we gave them a list of what they were, and we gave them the number, the name, and what the length was and what the type was. So while you wouldn't find that publicly available, that was provided. These were the schemes that we did that. That was in the dialogue back and forth. And that's what I think you used to get your contractor's assessment of costs to come back in. It was based directly on some of those priority schemes. So these schemes were highlighted and provided to the applicant.
Okay, I'm going to move on, because I think I know I've got what I need out of this, and I think we'll just end up going back and forward with this. But I think it's clear, and my subsequent questions may help to do that. So if it's not, and there's something at the end you want to add in, then do that. So again, this is just to the council. This is for clarification, because I think I know where the position is here. So can the council explain whether there is any provision or mechanism within the document for establishing what funding is required for the identified schemes, first of all, and if there's any indication of what level of developer contributions are to be sought from the proposed developments, and how that funding is to be secured? I think I know what the answer to that is, but I just want to clarify from the council.
Yeah, you're right to say that's not clarified in the document, but that comes out through the engagement through the planning process and assessing their impact.
It's not in the document itself, so the document has no provision of how to secure any funding measures in terms of developer contribution, which I would expect, given the age it is. I wouldn't be surprised that that's the case. So it's not a criticism of it.
No.
It's just the fact that there's nothing in it that provides that mechanism to do that engagement. Because I assumed if it was, it would be an adopted council policy document in order to do that. So it doesn't have that built within the document, and that's not an expectation that you would place upon it. That would be a subsequent stage in dialogue and process after. Okay, this is just about updates to the document. So just whether the council can advise whether the document, and I think you've answered this already, has been reviewed since it was first published, which I'm thinking the answer is that it hasn't been reviewed.
Oh, too busy.
No.
Well, I think it is accepted that an updated strategy document and plans to reflect the current status, work done to date, what the priority schemes are, and any changes to the design and construction methodology. I think that would be beneficial for the council, it would be beneficial for developers and for the public, I get that.
So just to be clear, the document is as it was first published, so it's not been reviewed or updated.
Correct.
So there's been no sort of further survey work done to to prepare for a review or an update to that document.
No, the intention is we would like to update it to give a bit more clarity in the document to what we're doing. No.
Yeah, it's okay. I'm not testing you. It's just to get clarity. But the last part of the question, this bit that you may wish, is there any intention to update the document?
Yes.
Okay. We'll move on from there. Okay, so we're moving on to section 5.
Just as residents, it's very difficult for us to know the knock-on impact of this project, specifically on that point, because there's no detail of what the mitigations are going to be on the project. So we don't know the true impact, because what you wrote in the application was there's no designated area to put the money into for mitigation. So you might do this, you might do that. So it's just as I suppose a point of note, it's difficult for us as residents to know, well, are we going to be happy with your project or not? It's.
Might I just make a response to both that comment and the earlier comment? I can understand why it's confusing. The council and the applicant are having an argument as to the extent of funding being required. It's no part of the applicant's case to say that you disregard the South Loch Ness Road Improvement Strategy, either in principle or the fact that some work needs to be done to it. The applicant has offered a very significant sum. I think I'll be corrected if I'm wrong by Mr. Buchan, but it's probably the largest sum of any of the schemes on South Loch Ness, so something in the 4.5 million, which is a significant percentage of the council's annual road budget for the whole area. So it would be wrong for you to leave here with the impression we do not have concern, we do not share your concerns as to the current status of or in general terms, as to the current status of the South Loch Ness Road, and that a contribution needs to be made to deal with it. The dispute, the particular dispute, which is primarily between us and the council, is the extent to which we need to do so.
Okay, thank you for that. So I'd like to move on now just to look at predicted impacts, and this may help to answer the question that has just been asked. So I'm glad my line of thought seems to be aligning with some of the questions that are coming out. So looking at the significant impacts and the receptors and locations. So to the applicant, can you just briefly take us through the receptors and locations where the significant effects from the proposed development, pre-mitigation, have been predicted in the EIA assessment, so that we can establish where the areas are where the traffic generated would have a significant impact in EIA terms on the existing road network? And if there's a table or a section you can refer us to, that would be helpful.
Thank you, sir. The relevant table is table 16.14 of the chapter, which is 001.022, which I think I'll be quoting in my sleep tonight. But that illustrates the impact and the mitigation measures that have been undertaken on the most sensitive receptors, which were the B862 users, the B851 users, residents in Torres, Erigi and Gorthlig. And the mitigation proposed is in the form of the CTMP, the Construction Traffic Management Plan, the Canal Management Plan, local road improvements, Section 96 Wear and Tear Agreement, and those measures as set out in the mitigation section of the chapter, sir.
So in terms of identifying the sections of road that require physical improvement to them, Is that set out in greater detail elsewhere? Because I think that's some of the points. It's just seeing where are these significant events going to occur. Some may be resolved through certain mitigation measures that aren't physical works, but some may require physical works to the road, and so it's identify where the physical works to the road are intended. Because I'll come on to this in a bit, but you do have a list of proposed schemes that you've costed in order to get to that point. So I'm preempting my own questions here, but it's in relation to where are those actual schemes, and not to spoil the plot, but as what I'm looking for is how do they then align with the schemes in the strategy. So that's the point I'm trying to get to, so where I can pull these different things together and say, right, do they align with that? Is there any real disagreement on the locations where road improvements are required? There might be a disagreement on the amount of money, or there might be some where there's disagreement that some are required, some aren't, but it's to find that commonality in amongst other set ones that we know that these things need to be done, and then the cost of that is a separate matter, but it's just to establish that. So that's probably my next few sort of questions all wrapped into one. So maybe it's easier just to take that as one point. I'll give you a chance to think about that, but that's what I'm trying to get to. And I think that's part of the issue that was raised by the Community Council is, you know, there's money, there's improvements, where are they going to happen and what form will they take? I should have just written that as the question.
Thank you, sir. If I could refer you to the transport assessment, chapter 8, which has all the proposed mitigation measures. That includes the CTMP and other elements, abnormal load, get my teeth in, abnormal load management plan, a canal management plan, and those elements there. In terms of public road improvements, the relevant section is 8.6 of the transport assessment, where we have said that we note that the council has looked at road improvements in the network, and we have proposed potential works there. We haven't specified exactly where those locations would be, because at the start of the process we said that we would engage with the council after, in lieu of the kind of road condition elements of it, simply because there are ongoing works, there are other developments. We're not sure who's going to be contributing, to which improvement scheme, for example, of those elements there. So we have made a commitment that there would be road improvement works. We just haven't set out exactly what they are, and we have suggested pedestrian improvements in Gortleck and potentially in Whitebridge as well, but we've kept it very high level so that could be engaged with the local authority, so it matches. It doesn't repeat the effort that perhaps other developers are doing, or it doesn't duplicate other works that perhaps the council is doing under its own limited resources as well.
Okay, so I've got two further questions. Some of those may align with some of the schemes identified in the strategy document itself, I'm assuming, but there's a list of schemes that you, I think, had costed, and what I'm trying to identify is some of the names are different with those schemes, with the schemes put forward by the council, and I'm just trying to find out if there's commonality amongst what the council's list, various schemes. You've listed other ones, so it's just, are we talking about similar, the same, or very different schemes in the submissions? I'll come back to the council to respond on their side once I've...
Thank you, sir. The applicant engaged with the council in terms of, I think there were several meetings that were held. In order to try and work out a cost, the applicant looked at primarily twin tracking elements of it and suggested contributions to schemes 3, 13, 22, 23, 25, 29 and 41, and that's where the
just for clarity, that's the reference numbers in the council's
for the council had provided the applicant.
It's just so that we're using the same numbers in the same way for for everybody, because that's what I was assuming, but I didn't want to assume that that's what it was. But those numbers are referring back to the council's schemes in terms of the reference numbers.
As far as I'm aware, yes. So those sections there were considered in terms of twin tracking, because in terms of the twin track element for estimating our cost, we didn't have any designs for the village improvement schemes, and as villages you can have different design iterations, or and the villages themselves have different challenges. We didn't want to make an estimate that was based on works that the council wouldn't want. So looking at the twin tracking, it was a much easier process to consider a suitable capital contribution for working up a total cost there, based on the length of those schemes and the council's desire to see the road widths improved.
And can I just clarify, these sections that are twin tracking are areas that have been identified through the sort of AIA process where there'd be significant effects? Because I'm just trying to line up that it's actually the reason you're carrying those out are because it's been required by the development itself.
Can I perhaps set the groundwork for that, to answer that question?
You may.
And in the chapter 16 on the EIAR, table 16.14 provides a summary of residual effects and the mitigation required to deal with them. The only significant residual effect is in terms of driver delay, and the mitigation identified for that, leaving aside the CTMP and other matters, is enhanced passing place provision and AIL management plan. So that the EIA has only identified enhanced passing place provision as the only required mitigation. It's been proposed, in the absence of approved policy, in the EIA, in the paragraph is 16.11.20, to provide additional passing places and limited road widening works, and in addition the reference that Mr. Buchan's just made to pedestrian facilities in Gorthlick. So that's where that reference comes from. The list that has been put forward that Mr. Buchan has just been speaking to has been identified not as a result of what is necessary to mitigate the residual effects, but in an attempt to meet the concerns of the council and indeed local residents as to road widening, and that's the basis of the schemes that he's listed in his hearing statements.
Okay, that clearly answers the question that I was trying to get to the point of, just so that I can understand what's come out of significant mitigation to mitigate significant effects identified by the EIA. What is done beyond that, and then how that, if it requires, to align with the strategy document, because it may not require to align with the strategy document per se, as long as it's resolving the issues generated by the proposed development itself. And I was just trying to get the clear lines of, we've got one list here, we've got another list here, and we've got the document. So I understand that now, so thank you for that sort of clarification. Before we move on, does the council want to respond back to that particular point?
I've got this quite. It's just to go back a touch. It's been clarified that there was no schemes identified in the initial application submission for mitigation. It was generic statements. WSP were acting for the council at the time because of resourcing issues. They were providing support to the council's transport planning team. They provided a response to the application. It's document reference 019011. And within that document, on page numbers, which are not very helpful. 1, 2, 3, page 5 and 6. That response includes a list of suggested schemes that could provide the mitigation required from the impacts of this development, which tie in with locations identified in the applicant's route constraints review document as being problematic locations along the B851 and B862. So those schemes, bar 1, which is referenced to scheme 13A, Flickety Bridge, which is now actually being built by SSEN, so that scheme can come out of the list. All those schemes within that list have remained within the council's assessment right the way through the process, and they remain in the final list of documents, list of mitigation schemes that we identified in our final response to the planning application before it went to planning committee. So, sorry, go on.
No, I was just going to ask the applicant to come back on that. If you
I'll see if Mr. Buchan wants to respond in a moment, but just my understanding that certainly the reference to that document is accurate. I think the acceptance that for instance, the scheme 13A Flickety Bridge should come out is an indication of bearing out Mr. Buchan's point that schemes, what is required will change as works are carried out. They are identified as potential priority schemes for delivery, which correspond with sites the applicant has identified subpar in their route constraints review. So that's the basis of their identification. It's sites which we've identified, as I understand it, in our route constraints review.
So that's coming from that process rather than the EIA process in terms of addressing mitigation from residual significant or significant effects that are looking to be addressed through mitigation.
That's my understanding.
Yeah, okay. That's what I assumed it to be. I think one of the community councillors or both want to come in, so that'll maybe give a bit of time. Mr. Hindley?
Thank you. Council for the applicant has been useful in clarifying that here we're dealing with the applicant on one hand wanting to reduce their contributions, the council on the other side wanting to maintain or maximise their income from the proposed development. And in the midst of this, the community council's position remains that we do not believe that the effects on of the construction traffic on the road network can be mitigated. Policy 18 of MPF4 is really clear that infrastructure has to be improved first, and it is not until the entirety of the transport route from the A9 all the way down the B851 and the B852 to the site is of an adequate standard to accommodate the HGV construction traffic that the project should be allowed to continue.
Okay, thank you for that. I think I have enough to understand where the areas of disagreement lie, and that's something that I will have to take into my considerations. I'm not trying to get everybody to agree today. I just need to understand where we've still got areas of dispute, and then I'll have to make sort of ruling on those positions. So I'm conscious of the time coming up to 4 o'clock. My intention is to try and get this finished today, so I think we've got scope to do that. Hopefully everybody can stay on. If you need to go, then that is okay as well. We haven't locked the door, so you can escape if you need to. So moving on to item 5, looking at predicted impacts from construction traffic. Some of these I think we've actually churned over in our discussions. We've been kind of moving back and forward. So I think we've done the significant effects, impacts, receptors limitation, we've covered that. The other significant effects, well, we've got the point from the community councils in terms of just the principle of it, and I think that's fine. Looking at 6, which is mitigation, I thought it would just be helpful for everybody and we touched on this almost at the start of proceedings this afternoon, but the document, the Construction Traffic Management Plan, it'd be helpful if the applicant would just briefly outline what the purpose of that is and what aspects, and I think you've done that to a sense, so a briefer, just all-encompassing summary of that, including, and I think this is the point I was saying, how does that document interact with some of the concerns regarding school routes, which we touched on earlier as well, but also workforce transport, which you touched on with the traffic, a transport plan. So maybe focusing that construction management plan on some of these other issues. I think you'd covered off the fact that you'd be monitoring drivers, routes and locations as part of that, but just maybe focus on those other concerns that have been raised by the Community Council, which you touched on, but if there's anything else you want to kind of highlight through that, but maybe just start with just saying what the purpose of that construction and how that interacts with the Council in actually preparing that document. This will be picked up in the conditions session. This is one area that's normally a standard condition on all major applications, would be a construction traffic management plan. So it's just to make sure that we kind of understand that.
Thank you, sir. In essence, the construction traffic management plan is a way of managing, controlling all the construction traffic associated with the project. So it's the rule book that everyone would have to abide by. In terms of how it interacts with the council, it would be a planning condition that would be requested. The applicant would then draft it and then submit it to the council for their approval. The important thing with this CTMP is it should never be a...
Just a sort of minor point, just for clarity. The condition will be imposed by Scottish ministers on the application, and the elements that are included in it may be carried out in consultation with the authority. Just as a pedantic point, but just to be clear.
My apologies, sir. I've lost my train there. So no, you're so in terms of its interaction, sorry, I was going to go. It's not a static document. So once it's produced, it shouldn't just be left. It should be a document that is live, because then it can react to other measures. So, for example, if there was a particular issue that has arisen, that can be fed into the CTMP. If there's another development that comes onto the network, then it can react to that. So I think the key element of it is it's not something that just sits and gathers dust. It's something that is alive. It can be updated. It can be improved upon, and it evolves throughout the lifetime of the project, especially given the length of time that this project has. I think that's quite important. In terms of how it addresses elements with for example, going through sensitive villages, we have suggested a voluntary speed limit of 50 miles an hour for construction traffic, for HGV construction traffic, to bring those speeds right down below the posted speed limits there, and that can be reinforced and enforced through the review of the GPS trackers on the vehicles, but also on the tachographs that HGVs are required by law to have. We have a number of other measures we can work with, and in fact within the existing document we say a voluntary speed limit for HGV traffic of 10 miles an hour when passing schools such as Farr Primary and Stratherick Primary School on the route, and that can be extended to other pickup areas as well if required. And then we potentially look at not having bulk deliveries made during school pickup and drop-off times. That's already a commitment within the CTMP. We also have driver training. We have a whole range of measures of how they should conduct themselves going through sensitive areas, and if things change, we can direct specific measures to specific parts of the route there. So it's quite a comprehensive document.
So setting those particular aspects will be something that's done in conjunction with the council to satisfy the condition that's, if the condition is to be imposed, if the scheme, and these are all ifs, but the idea is that that would be done in terms of speed limits and location. That would be done with the council to identify sort of these areas where those kind of agreements would be put in place.
That is correct, sir. And if there are other measures that the council wishes to consider, or indeed the community councils, then they can be placed within the document as well. It's also, we have proposed the kind of traffic liaison group working with other stakeholders, and that can be a conduit for measures, improvements and enhancements to the CTMP as it evolves and as the project continues, should it be consented.
Okay, thank you. Does the council want to make any comment on just the purpose of that condition?
The council supports seeking conditions of construction traffic management plans because they can provide support to managing and mitigating impacts. They need to go hand in glove with a road network that's physically able to accommodate the vehicles, because a construction traffic management plan will not deal with the inability of a road to accommodate physically the vehicles that they're looking to take. Forgive me if I'm duplicating some points because I picked up some of it but maybe not all of it. The council would be looking for a construction traffic management plan to monitor and record the types and volumes of vehicles going in and out of a site, and ideally the routing that they're taking. That is useful to get an understanding of the scale of actual impacts rather than predicted and forecast impacts. And that can be useful when it comes to things like if there is a wear and tear agreement, for example, where you've got multiple developments impacting the same route, that you can apply an element of proportionality to the delivery of repairs to any damage inflicted on those road networks, because it's very rare that somebody who damages part of the road would stop and hold their hands up and say it was me. So you have to work on a basis that you're going to assume that you won't know who's damaged the road, so how do you then apportion the blame? So having quantities of traffic movements and types of traffic coming in and out is quite useful. We'd also expect the construction traffic management plan to commit to ongoing and proactive engagement with the local communities and their representatives, which may be the community councils, it may be others as they see fit, because they're the ones that are living with it day in, day out. So to actually have those communities, their ability to voice any issues, concerns, so that the developer can take those on board, and then the developer can come back to those communities and say what they've done to change things, to make things better. We think that is always a positive thing to have in the CTMPs.
Okay, I think that's just to get a flavour of what that entails.
Yeah,
I think the details of it we'll probably discuss tomorrow afternoon if we're looking at the wording of the actual condition itself and these things. But it's a management plan in terms of how the development is to be operated with input from yourselves
and with coordination with other developments
as
well.
Okay, Mr. Lumsden.
Sorry, me again. We appreciate the things that the traffic management plan are saying, but in reality, what's said on paper is not what we experience. We need ID on these HGVs, because when we see an HGV go screaming through the village or like going fast past the school, you know, you're trying to get your camera out or record the number plate, the thing's gone. We need a clear ID so that, and especially with the cumulative impact, we know whose HGV it is for what project and how we can report it. And that goes across the board. You know, there's all these mitigations we've had with previous projects that they'll avoid school time. They don't all the time. They'll stick to the main traffic routes. There's numerous cases where they don't. They won't travel in convoy. They do. We're experiencing this. There needs to be ID so that the offenders can be identified in a stern word, so that they don't you know, if the project goes ahead, it could be dealt with.
Okay, I think the applicants kind of covered some of the responses to those points, but I think that's something that I think the council talked about in terms of if there's a liaison group, then it's getting something that allows the reporting back to be as straightforward and easy to yourselves in order to do that. But there's obviously the applicants have put their case forward on how that's to be sort of operated. Did you want to say one other thing?
All of the wording, construction, traffic management plan, has been a discussion on roads. We haven't yet touched upon whether all of this transport could be taken off-road onto the Loch Ness and canal system.
Okay, we did mention about abnormal and indivisible loads. So what the construction traffic management plan can also do is look at, and I think the applicant touched on this, and they can obviously speak for themselves on the matter, but how you move the workforce back and forward to its location. So that's something else that would normally form part of looking at your construction management plan. And I think the applicant did mention about transport and routes and buses, etc. It's for them to be, it's not for me to proffer a solution in this situation.
If I could just make a point, we've already heard from the council that the 851 is unsuitable for this construction traffic. And the fact that it's been used in the past for unsuitable traffic doesn't justify its use in the future for unsuitable traffic. But the other thing is the primary mitigation for any activity that has potential hazards is to avoid it. And with Inverness Port being designed, purpose-built for bulk transport of materials and the canal system the same, the primary mitigation needs to be moving everything by the canal through the port.
Thank you for that point. I think we've covered a lot of this earlier on, so I'm not going to sort of repeat some of my questions. And if you just give me a second, I'll work out what I need to know and what we've already touched on. Yeah, we did cover on the difference between the survey in terms of capacity or threshold and the survey in terms of the physical condition of the road, like a wear and tear survey. So the council have responded to that. So that covers the bullet point on condition survey, unless anybody else wants to add on to that particular point.
Yeah, so again, through experience of living and breathing this B851 road, every year there's the same sections of road that break up. There's sections at Little Mill, there's sections at both sides of the Socky Bends. That's the big brick wall section where SSE put in a few years ago. Either side of that breaks up every year because it's in shade and there's water. So every year the council have to do a patch repair. So if we're going to put more traffic on this road, how is that road going to get repaired? If the road then needs to be closed for repair, where is the construction traffic going to go? Is it going to stop to allow repair, or is the proposal to put diverted traffic down even worse back roads? Has that been considered?
I'll go to the council first in terms of how you would normally approach, because you're talking about a wear and tear sort of issue there, how you normally sort of look to address that in the context of a major development.
Yeah, whilst the Roads Scotland Act 1984 does allow the council to recover costs for any extraordinary expenses incurred associated with damage from excessive traffic on a network, it's very it's done in retrospect basically. So the damage has to occur before you can then actually take any action. The council looks to seek formalised wear and tear agreements with developers, which become more of a proactive approach. So we will try to establish those agreements, or we look to establish those agreements that set out a framework for establishing the condition of the road after it's been brought up to a capacity standard to take the traffic, and then it includes then a framework for its ongoing inspection. Triggers for when repairs might be required and the timescales for how those repairs might be delivered. And if it's a route that is being impacted by multiple developments, then how would that agreement should then set out the framework for how that would work in terms of multiple impacts.
Okay, does the applicant want to make any comment on that?
Sorry, I mean, in terms of wear and tear agreement, I think one of the key aspects of it is to undertake. You don't want to have the situation where you take a condition survey at the start and at the very end of this project. We want to have regular reviews so it can pick up any issues that develop on the network, so they don't become network critical issues. That's why you would have interim surveys on a regular basis agreed with the local authority, and where the applicant has, where their traffic has clearly had an issue, then there is either recourse for the applicant to do it or recourse to a road bond, which the council will have control over to ensure that any repairs are undertaken not at the public's expense on that element there.
Okay, thank you.
Sorry, my question was kind of directly related to the actual traffic. So rather, aside from the finances and the commercials, what will happen to the traffic if the road needs to be closed for repair? Where is that construction traffic going to go?
Well, I can't answer that question clearly, but so I'll ask.
I think we would because the if the development is consented, they'll be restricted to particular routes to use. That will be identified in their construction traffic management plan. So they wouldn't, and adhering to that, they wouldn't be allowed to divert onto other roads during like a resurfacing programme that may require the road to have part-time closures on it. So I would imagine the applicant would work with the community and the council to ensure that wouldn't happen. So.
Okay, councillor again.
I was just going to come back on the comments made about road bonds. Yes, the council will seek a road bond or some other form of financial protection should the development happen and damage occurs and the developer doesn't fulfil their requirements under the wear and tear agreement effectively. So it's protection basically for the council not having to tap into its own monies. There's reference in the transport assessment document 001142, page 24, to that only covering 500 metres either side of the site access. The council would not operate a road bond on that basis. It will review the length of road being impacted and it will establish a suitable road bond on that basis, and that will be all dealt with through the wear and tear agreement.
Okay. I don't know if it's given the exact answer you want, but there has been a response from both parties to that. Yes, we've touched on mitigation measures. Applicants identified a list of schemes. We've covered that already, and how it relates to the strategy. So that really takes us on to item 7, which is looking at delivery of proposed improvements, and we've touched on this a bit already. And I think the applicant has partly responded to looking at the approach taken to establishing the costs of the proposed improvement schemes, and you've kind of responded to that. I don't know whether you want to make any further submissions at this point on that matter.
Not on the costs of our schemes, but I would like to raise the council's approach at some stage so they have fair warning as to where we're coming from.
Which will be our next item. As I say, we've got that list that was submitted by yourselves that cross-references to the schemes there, and you've got an independent to assess it. That's not on the basis of any detailed design schemes at this stage. That's just sort of estimates for that typical type of work. Would that be correct?
Yeah, that is correct, yes.
Okay, so looking at the apportionment of costs to identified schemes, and if I don't pick up your point, Mr. Finlay, just pick me up at the end. What I'm looking at is just how the parties have undertaken the assessment on what proportion of costs to the improved schemes should be met as a consequence of the proposed development. Because as you said, there are other schemes going on. There's some village schemes that are wider schemes that are not just solely down to the proposed development. So it's just to get a better understanding of how both parties have reached that. So the council could probably say this, sorry, the applicant can probably summarise this quite quickly because we've touched on it already. But you've looked at various percentages for particular schemes. So can you just outline how you got to that position?
Thank you, sir. The percentages that we have proposed are based 50% contribution for schemes on the B851 in recognition that other wind farms and potentially the other projects will be making contributions to those elements, and on the B862 it would be 100% contribution is what is proposed there, sir.
And from the council's position in terms of the mechanism that sort of you used, my understanding of it is that you've made reference to previous schemes and taken an approach of a general approach to that and applying it to this particular scheme. Now, I may have got that wrong, but if you could just kind of take us through how you've reached that. You've obviously got more schemes that you think require to be done than the applicant has proposed, if that's correct. And then just how you've looked at proportioning the costs of that, because there's reference made to other developments. I think Dell, one of the versions of the Dell application anyway. So I'll let you explain how you've got to that point. And I think that picks up the point that you're looking to answer as well.
Excuse me. Sorry, just get a drink.
Mr. Hindley does have a big supply of glasses and water if anybody's needing anything. I don't think he's hogging them to himself, but feel free to help yourselves.
The council's been of opinion right the way through that the local public road network connecting this site to the A9 trunk road is physically not up to taking the type and quantum of traffic that this development would be generating, let alone in combination with other developments that are earmarked for the area. So in theory the council should be objecting to this application and on the grounds that the road is not up to the capability of taking the construction access. So
I take you're referring to your position in your hearing statement and rebuttal statement, and not another position in regards to that. Just to be clear.
Yes, I apologise. So the transport planning team representing the local roads authority, which is the Highland Council, should be objecting to development that's generating lots of.
Sorry, when you say it should be objecting, I'm a bit confused. Are we sticking to the position that's in your hearing statement and rebuttal statement? Because if you're asking me to consider something that's different from that, then you need to make that sort of clear. So I'm just being careful with the wording that's being used, that there's no confusion over what the council's actual position is with it. Because I'm seeing the council as a single entity normally, rather than a subdivision of teams. So what I'm looking for is what's the council's position on this. And that just keeps things clearer for me to understand what I'm actually being asked to consider.
Okay, just to confirm, the council is currently objecting to the application. The position I was trying to get is that it's developments like this and other large traffic generated developments, the council could take a position of saying that the roads aren't up to it, and therefore we are going to be, as the roads authority, challenging and objecting to those developments. What we've tried to do is use the South Loch Ness strategy as a tool to help facilitate development in the area. It's a tool to help support the development aspirations in the area, as well as keeping that route safe and usable for the existing users. And it's done on the basis of everybody does their fair share. So everybody contributes towards the upgrading of that route. So
Can I just, are you going to explain to me what fair share is in particular in relation to this development? Because otherwise you've given me nothing to quantify.
Sorry, that was probably context. We're just getting to that now. So, how do you determine fair share? So, what we have is agreed decisions on previous developments that have agreed values of contribution. But what we also know is that we have predicted levels of construction traffic impact, quantity and type. So that then allows a cost per traffic impact to be established, which we used in this case because there was no information that came forward with the application on trying to quantify and locate the mitigation that it was going to do. And in discussions with the applicant and his agents, there was nothing that was coming forward. There was just can't afford this, can't afford that. So what we did is we took an exercise. We took an exercise with other developments that had got permissions and agreed levels of contribution and non-traffic predicted traffic levels. We came up with the value per trip impact, and we then applied that to the predicted trips that were due to come from the Loch Kemp development using the traffic assessment work that had been done by the applicant. And we provided that to the applicant alongside then a list of schemes from the Safe Loch Ness strategy that could benefit in part or in full from that value of mitigation. There was discussions that happened, there were suggestions from the promoter that they could reduce the peak period car trips and minibus trips by adjusting how they manage their movement of workforce to and from the site. So we applied that in full to that appraisal assessment again to try and reach a position where the applicant may well be accepting of the mitigation that we were suggesting. So that reduced the value of mitigation and the scope of mitigation covered by the network.
Can I just clarify, is this the information that's set out in your hearing statement?
Yes. Not
any other subsequent sort of documentation that's been submitted? So it's purely the information that's within the hearing statement itself. I just want to make sure that I'm not referencing any other submission. Okay.
No. This was all set out in the email communication documents that we provided.
Yes, I've seen everything that's with your hearing statement. I've seen. I'm just double checking that I'm not looking at anything else in terms of the evidence that you're bringing forward. Okay, thank you.
So after applying all the reductions that were suggested by the applicant and bringing in as many schemes as we could to try and cross-check and cross-correlate this cost per trip generated, we then reached a value, if you like, or a range of values for mitigation and a list of schemes that could benefit in full or in part from that. And that's how we undertook that exercise, because there was nothing else available on the table.
Okay, so I was just trying to catch up with.
That's okay.
So, in terms of you've established a cost per trip on the basis of previous thing. When you're doing that, you're looking at major projects. So, does that include other sort of pump storage hydro schemes, or is that wind farm schemes, or a range of schemes that you're referring to there? And I suppose my point is there a difference between the impact from, say, building a pump storage hydro scheme compared to building a wind farm in terms of traffic generation and impact? Were any of those factors sort of built into your considerations?
The impact is, the difference in impact is the quantum of vehicles and the mix of vehicles. So you can have a pump storage hydro scheme, for example, 5 years project is likely to generate significantly more trips than a wind farm that might take 18 months to build. But you can deal with that. It's what we were calculating was costs per predicted trip. So it takes account of it wasn't just focusing on a peak, it was the total construction period. So we did our appraisal based on the total construction period, so it picks up all the predicted traffic impacts for the different types of development.
Okay, can I just clarify, what is this just your own sort of assessment? It's not like a recognised assessment that you can reference me to a publication or a document that would sort of say that this is an appropriate way to apportion sort of cost to a trip?
No, this was purely done for this exercise because there was nothing provided in terms of the identification of the location or scale of mitigation required. So we developed this just to inform this exercise.
So it's just an internal approach to sort of coming up with a figure that you thought would be appropriate per trip and then applying it to this particular development. It's not. Is it something that you had done previously to other proposals where you were looking at sort of costs to that, or was this the first time that you were taking this approach on this type of development?
This is the first time we've used it here because we have the opportunity to use it here because of the Safe Loch Ness strategy, where there's a list of there's a strategy for improving the network through here. So, but we've not applied that process. It was just basically to try and say we were trying to understand how do you relate the impacts to the mitigation, and the whole network needs improving at some point. But it's unrealistic and unfair to expect a single developer to do all of that. So it comes back to this point where everybody has to do their bit. So how do you quantify that bit when it comes to delivering that?
Okay, just so this is me just clarifying. So you've applied it in this case, but in the road's obviously been used previously for other sort of major developments that generate post the study being in place. So is there a reason why you didn't feel you need to use it in those ones, but you felt you had to use it in this particular one?
We had an opportunity using this one because we had decisions. When you come early on, there's no decisions in place to actually make that back check, if you like, done to establish a cost, an agreed cost that's been agreed through either a planning approval or an appeal decision, and cross-correlate that to the traffic that it was predicting to generate. So you can't do it early on until you've got those agreements in place. We had an opportunity with this one. The approach seemed reasonable, seeing there was nothing else available from the applicant to sort of say this is our impact and this is how we're going to mitigate it. So this seemed a reasonable approach to take to do that.
Okay, so this has just been one that you've developed yourselves for this particular circumstance. I'm not belittling the approach. I'm just trying to understand that it's not an industry standard. It's not best practice. It's not been applied sort of previous to others. So this is the first time that this approach has been used, and this is the sole reason that you feel that you've now got previous proposals that you can align that with, or there wasn't sufficient information from the applicant. I'm just trying to work out why this particular decision at this point was decided to use this approach for the first time.
Usually the conversations happen with Colin as the man who knows this route inside out and has developed the Safe Loch Ness strategy. It's done through early engagement with the applicants to establish where are going to be the impacts, what's the mitigation that's going to be required, what scale of mitigation, what's that roughly going to cost, and who's going to deliver it, direct delivery or through appropriate developer contributions. There was no engagement. We asked for early engagement pre-application and the EIA stage. We never got any engagement. We got the application in, there was still no engagement. It was only when it came to the point that it looked like the council might be wanting to challenge the application that the applicant came forward to start that engagement.
Okay, no, that's helpful. I just want to be clear on what basis that it was established. I'm going to come obviously to the applicant now to some points raised there in terms of your approach, so I'm sure you'll wish to answer that.
So can I just raise two preliminary matters? First, the actual reason for refusal, which is set out in the Statement of Agreed Matters, is, as I'm sure you're aware, that the proposed development will have an adverse impact and the mitigation does not adequately address those impacts. So not along the lines that Highland Council were just submitting. Second point is that in the suggestion that the applicant had come up with nothing is just not correct. I know you're not going to be interested in who said who to what at what time, but if you look at CD 19.21, the page 5 of 6, there's an email from Mr. Ross, in effect rejecting an offer of £5 million from Mr. Troop. So that the suggestion that no figures or schemes were being put forward by the applicant is simply not correct. So can I then ask you to turn to the applicant's hearing statement at paragraph 6.7, because there's a useful table there. And,
Council's hearing statement.
sorry, Council's hearing statement. My apologies. So that is CD 19.10.
I'll go against my protocol and ask you what paper page number that is.
I will not make a dig at the council and say that there's no pagination on the document, but it comes following paragraph 6.7. Page 9? Page 9.
I have the page, thank you.
So if you look at what the council have done has just been confirmed, is they've taken the costs from 2 wind farms. Now, Dell 2, there's in fact no agreement, contrary to what may have been suggested at the moment. There's no agreement at Dell 2. The Dell 2 figures, we understand, come from Dell 1, for which an inflation, I use that in short term, factor has been applied. The Dell 1 figure was, if one looks at the reporter's report, was the reporter accepted their figure of up to, I believe, £1.7 million might be appropriate and left for the council and the developer to deal with. So there's not actually a decision that Dell 1 was £1.7 million. But even more than that, Dell 1 was taking access from Fort Augustus. So it wasn't concerning these roads. And the specific figure at Dell 1 was for specific works. It wasn't calculated on any basis akin to that which is being proposed now. The Aberrada figure, again, my understanding is it comes from primarily from works to a bridge that were undertaken, which was in the order of 1.5 to 1.75 million. And that was the contribution there. That had nothing to do with the extent of traffic that Aberrada Wind Farm was developing. Like as Dell 1 had nothing to do with the extent of traffic that Dell 1 was not developing but giving rise to. The council have then taken those figures, which are not general figures for contribution to the Loch Ness Road Improvement Strategy, and applied a mechanism to them which is set out in their email chain, and perhaps most clearly, I believe, at 19.20 at page 2 and 3 of 7, where there's an attempt to factor up the figures in those wind farms to produce a sum per number of trips. But I reiterate that had nothing to do with the basis on which those figures were put forward. That is then applied, and there are all sorts of detailed criticisms in the emails which I needn't get to, but that is then applied to the transport or the traffic generation figures for Loch Kemp, and a tariff produced. That is nothing more than a road tax, which is wholly unrelated to specific impacts, and it would be in effect illegal. There has been no attempt by the council to justify a figure by reference to impact of this particular proposal, or to quantify the proportion for any road improvement strategy by relevant to specific impacts. I'm grateful the council has accepted that there is no other basis than their own internal logic for producing the figures that they've been suggesting, which were initially, as one can see in the email exchanges, as high as £14 million. They fail. The council's approach fails all the tests in the circular on conditions and the appropriate advice on guidance, indeed on the similar basis to that which Mr. Buchan has included in the applicant's rebuttal statement in terms of the Aberada project, and he's included at 3.2.14, that's in CD 18.60. So that's our position in response to the way the council's calculated its case.
Okay, thank you for that, Mr. Finlay. I'll give the council an opportunity just to come back on that, if there's anything you wish to sort of come back on, or are you happy to rest on what you've said to date?
Also, it's always good to get a preview of Mr. Finlay's closing submissions in full beforehand. I think this matter may be best dealt with in submissions, but equally this is a matter that partly arises from the late proposal from the applicant for the particular schemes that they were willing to contribute to. And I think we've rather skipped over the last bullet point about their costings. There is a figure now given in their hearing statement, which wasn't before the council before, and a letter from supposedly independent estimator, but I don't think we've got the actual figures that give any breakdown of that single offer being made to give a comparison and further consideration of that. And it's in the absence of those sorts of information that the council was trying to find a fair way to find the impact from the developer that was accepted, that there's an impact and a need for mitigation. And the only question is really what is a fair and reasonable amount to contribute to that. And we've already heard from Mr. Cross and Mr. Clough that that money would be used for the priority sections of the road that were being impacted by this particular development. So there's a difference between the principle and the trying to make a reasonable figure, and that's difficult in the absence of information on the particular parts of the scheme that are going to be upgraded. So as I say, it's a matter to be dealt with perhaps more in submission, but I don't know if Mr. Cross wants to add anything else at the moment. Yeah. But obviously things have moved on since the council first proposed that amount, and the applicant has moved significantly as well, and it will be a matter for further submissions.
Yeah, could I just add in, there was mention made of how the figures were arrived at for Dell and for the Aberarder grid connection, and there's perhaps a misunderstanding on the applicant side. So the figures on Dell, which was Dell 1, which they were derived in discussion between myself and the applicant on their routing from Fort Augustus, as was rightly said, and that was the cost to upgrade the scheme from Loch Tarf to the Suey viewpoint. And that was one of the strategy schemes, and that was costed out, and that was what was secured by the reporter for that decision. So it matched what the discussion and the agreement that we had with the Dell wind farm developer. The Aberarder grid connection figure that's recently been used to pro rata, that was index linked from a previous agreement with SSE on the Aberarder grid connection that predated the building of the Flickety Bridge. So it wasn't in relation to just extrapolating Flickety Bridge. Flickety Bridge hadn't even started on site when the original application on the Aberarder grid connection consent was agreed between SSE and ourselves.
Okay, I think I've got the evidence from both sides, and I think it's probably a matter now for closing submissions, and you can sort of relay that out. Obviously, as you've said, there's movement from the applicant in terms of coming forward with some schemes, so obviously you can respond to that in closing submissions as well. And that was partly why the earlier questions I was trying to establish was to try and align identifying where the proposed impacts would be. For example, I think the example you gave there of a specific scheme for Dell, and that happened to co-align with something that was in the strategy. So what I was trying to do with my questions was to try and say, where is there alignment and agreement and where is there dispute? But I will leave that matter for you to answer in closing submissions. I've got one point left which I think we touched on earlier, and that was just the use of section 48, but I think that was covered off by the council, so I don't know whether the applicant want to make any further point. It was really just to sort of have an explanation for everybody to why section 48 of the Act would be used and what it would secure in relation to the road network in terms of any financial contributions, and what the council's position on the use of this section of the Act for these purposes would be. So it was just to get clarity of the difference of using that and something else that's looking to secure other roadworks. So I don't know if the council want to just give a response to that.
Thank you, sir. The Red John development that we've referred to throughout the course of this afternoon secured the contributions through section 48, and it was considered that this was a comparable scheme and that therefore contributions could be secured through section 48 of the Act, and that was agreed with the applicant early on.
So if I can just come in at that point. So section 48 allows the Roads Authority, it's the legal provision that gives the Roads Authority the ability to enter into an agreement with someone to make a capital contribution towards construction related to roads. And so the applicant agrees that that's the appropriate mechanism to secure any mitigation.
So we have a mechanism, we just don't have an agreement on finance and the schemes. So if at some point there becomes the agreement, then that's the scheme, that would be the method that would be used for funding the necessary improvements. Is that everybody's sort of understand? I just want to say there's clarity in that.
That's correct.
And the council do the works.
Yeah, so the proposal is that the actual drafting of the agreement would come subsequent to any determination in the application, and the intention would be that the agreement would basically set out provision for the developer to make a capital contribution or make a payment, and the council would undertake the necessary works as the Roads Authority.
Is that the council's understanding?
That's our understanding of the applicant's position. As to whether the council agrees to that,
Obviously that will be something that you will have to agree to, but that approach is one approach. Yeah. Okay, that brings me to any other matters. So is there anything else anybody wishes to raise that we haven't so far? And I'm expecting the Community Council may, so Mr Lumsden, you had your hand up first, so you get to go.
sorry, I realise this is the last chance to speak, and apologies. I didn't know whether it would be under mitigation or traffic routes, but our stance is to try and take the traffic, if it gets approved obviously, take the traffic off the roads. We already spoke about trying to use the canal as much as possible. We would implore you to do that. Try and use the forestry track coming back on the Essex road. Again, take the traffic off the road. If the traffic does have to go on the road, it needs to be safe. We've already spoken about mitigations, but again, another mitigation that really we implore strongly you guys to look at is some kind of loop traffic route where you're maybe coming out on one road and going back on a different road. Putting the HGV out and back on the same road is crazy to us. And again, just apologies for going over old ground. I just had to reiterate that strong viewpoint that we've got.
This is your opportunity to raise the points that you've raised, so that's fine.
Thank you.
And the second point is, initially there were few developments, now there are many developments. And looking at things at a sort of wider level and across the Highland region, as a resident, the Highland Council have been forced into a reactive position where everything is about maintenance and repair. And if this should go ahead, and there is use of the road network, there is a golden opportunity to do something different, which is to plan ahead and actually make the best investment of the available funds. So instead of having only repaired roads, to actually have made a positive change. And given that you're coming from a route from Inverness and therefore the harbour into a site which is one of the sites at the greatest distance from Inverness, so some of the wind farms are significantly closer. If nothing else, based on a mileage that you're using, that should help to apportion your use of the road, albeit sections have been paid for already by others. Section improvements have been paid for already by others.
Okay, thank you for that. And Mr Hindley, do you want to make a final point?
We've spent a lot of the afternoon discussing roads. I wanted to raise two access issues that Strathairn and Foyers Community Council raised in their hearing statement. One relates to South Loch Ness Trail, the bridge just south of Whitebridge was washed away 2 years ago, so it means that users of the South Loch Ness Trail and therefore the Loch Ness 360 have to walk on the B862 for some 3 kilometres directly past the site entrance. And despite the Community Council having raised this on several occasions, the applicant has made no attempt to make that at all safe for the walkers, equestrian cyclists who use that and will be directly exposed to the HGV construction traffic on the B862. And the second issue is related to the Great Glen Canoe Trail. We went on the boat trip to view the site of the powerhouse yesterday, and it wasn't until I was there that I realised that the siting of the powerhouse is directly on the Joshua Tree or Beaches landing site, which is commonly used by users of the Great Glen Canoe Trail. We also discovered that that is the sheltered side of the loch, so that means that from a safety point of view, that is the side that canoeists will use in preference because it is sheltered and from the prevailing wind, and that safe refuge will be completely lost under the footprint of the powerhouse. Thank you.
Okay, thank you for that. Just on the bridge that was washed away, when I was on site, I was trying to establish where that actual bridge was. My escort for the day, which was the assistant gamekeeper, did take me up to show me this bridge that was sitting in a field that seemed to be to the southeast of the site. Is that said bridge that's now been sitting in the field for some time? It didn't seem to be in a location where you could actually gain access across
The actual bridge itself has been recovered by one of the local farmers. Where the bridge structure itself is sitting in a field is about 800 metres upstream from the original crossing point. There are 2 concrete blocks that are near the bank, which are closer to the original crossing point. But the river has changed considerably, and that is no longer a feasible crossing point for a new bridge. So it's not simply a matter of replacing it. The whole route will need rerouting by some means.
And is that an official route? What status does that route have? I might ask the council if you're not sure.
It was put together by Visit Inverness Loch Ness some 10 years or so ago. It is certainly promoted by Visit Inverness and Loch Ness and by the council in terms of their outdoor access promotions, but I don't believe it has a formal legal status.
Okay, so it's not a core route in the core route plan or anything of that stage that you're aware. I'm not going to quote you on it, but as far as you're aware.
Parts of it are core routes, so the part through Dell Estate here down to Foyers, which is also part of the South Lodge Trail, is a designated core route, yes.
Okay, yeah, but that'll make sense from where I saw it and where we established that you could possibly get from the road actually down to the river to cross wasn't easy to establish. I think that makes sense to me now from what I've seen. I don't know whether either the applicants or the council want to comment on that particular aspect. I'm not looking as if anybody wishes to sort of comment on it. So I'm not assuming that if it's not a designated route that the council has no responsibility then for replacing the bridge or maintaining that route as part of any outdoor access. You might not be the correct people to ask the question to. And if you don't have any knowledge of that, that's fine.
The only thing it might be the council's access officer might be, if it's related to a core path, then they may have an interest or at least understand the background to it or something. But from a road's perspective, it's not ours.
Yeah, because it doesn't seem to be that there's been any kind of official rerouting sort of the path in the absence of that. That's why I just wondered about the status of it, for whose responsibility it would be to look at that matter. But that's for somebody else to perhaps consider rather than myself. But I will note the point that that path has now an unofficial diversion sort of to that. Okay, I think that was the last of my points. And if nobody has anything else to comment, I will officially close this hearing session. And I'd like to thank each and every one of you for your participation today. It's been very helpful for me to get a better understanding of position of the various parties. So that will close us today. We will be meeting again tomorrow morning for the hearing session that we'll be looking at water management, aquatic ecology and fish, and that will commence at the earlier time of 9:30. Following that, we will then have the conditions hearing in the afternoon. Now, Mr Finlay mentioned progress being made on conditions. I'm assuming that's progress from the 27th of March submission that was there, and in order to save time, if there is, I don't know whether you want to submit to me an updated list of those conditions so that I can have at least a quick look at that this evening to see whether I need to adjust my agenda in any way for that afternoon session.
Yeah, certainly we can submit an updated version this evening and highlight any that have changed.
Right, my slight issue is that it will go to my office and of course they won't be in now, so I don't know whether that is something that could go on to